ladies and gentlemen, is whether an abuse of power falls within the meaning of the phrase high crimes and misdemeanors, since we can impeach on no other basis.
The offenses charged against the President in this article are uniquely presidential offenses. No one else can commit them. You or I, the most lowly citizen, can obstruct justice. You or I, the most lowly citizen, can violate any of the statutes in our criminal code. But only the President can violate the oath of office of the President. Only the President can abuse the powers of the office of the President.
Live from Washington, NPAC brings you gavel-to-gavel coverage of the House Judiciary Committee proceedings. Tonight, impeachment debate, July 29th, 1974. Here is NPAC correspondent Jim Lehrer.
Good evening. Abusing the constitutional powers and the oath of his office. That is one of the most serious charges that can be leveled against a president of the United States. And it is on the verge of being written into history as a formal accusation against Richard M. Nixon as this night session of the House Judiciary Committee convenes. There is expected to be a final vote on the charge, Article 2, in the impeachment accusations against the President sometime tonight. And it is certain that it will be adopted, probably by a similar margin to Saturday night's vote on Article 1. Based on the indications during today's debate, it seems clear that the 27-vote coalition against the President is holding. It may even go to 28 when the TV camera makes its second dramatic aye or nay trip back and forth down those long tables tonight. This inevitability comes on a day that has already been a bad one for the President. Late this morning, John Connally, former Secretary of the Treasury and ardent Nixon man, was indicted by a federal grand jury here in Washington. He is charged with perjury, bribery, and obstruction of justice growing out of the milk fund case. Connally said in Houston later today that he was innocent of all wrongdoing and predicted that he would eventually be vindicated.
I'm Paul Duke, and as Jim just indicated, we're now standing by waiting for the House Judiciary Committee to begin its night session on this fifth day of the impeachment debate. Beyond all the other developments, many Republicans are now conceding impeachment is almost surely to be voted by the House when the Judiciary Committee finishes drafting its resolution. In fact, some GOP members are now suggesting as many as 50 to 60, or more than one-third of the House Republican membership, will desert the President and vote for impeachment. There also are reports that substantial numbers of Southern Democrats will vote against Mr. Nixon. In the wake of these indications, Senate leaders Mansfield and Scott met today to begin making plans for a formal trial of the President in the Senate, assuming the House does indeed approve an impeachment resolution later next month. As for the Judiciary Committee, which will be assembling shortly, as I said just a moment ago, what happened earlier today was a continuation of efforts by Republican supporters of Mr. Nixon to limit the charges against the President. But the President's defenders lost on a succession of votes designed to modify Article 2, making it plain the article will be approved without significant change. Understandably, Mr. Nixon's supporters are disheartened, especially since it now appears Article 2 will be approved by essentially the same margin as Article 1 on Saturday night. The Republican mood was reflected in the comments of the committee's top GOP congressman, Edward Hutchinson of Michigan, who talked earlier with Carolyn Lewis.
Mr. Hutchinson, how do you think the President's prospects are going to be on the floor after the solid vote that we had on Saturday night?
Well, of course, the vote in the committee was strictly partisan so far as the Democratic side of the aisle was concerned. And the Republicans are divided. Now, I don't think that that will necessarily reflect the vote on the House. That is, the House probably won't stick to those same proportions. I have an idea that there will be some Democratic votes in favor of the president, and there will be some Republican votes against him. At this point, I wouldn't be willing to predict what the vote on the floor would be, but I think that the chances for the House actually sending a bill of impeachment to the Senate appear to be quite, I think that that's what will happen, but I wouldn't say by what margin.
The number one Republican in the full House, Minority Leader John Rhodes of Arizona, suggested today that the president go on national television to lay out his full defense. And of course that raises the basic question of what Mr. Nixon is doing, or more importantly, what he can do now. Chris Gall, who has been covering the White House for us, has taken a look at these two questions. Chris?
There's no indication, Jim, that the president will go on television. Certainly no indication from the White House. In fact, it seems unlikely at this point. Vice President Ford, speaking to a news conference in San Francisco today, made that clear also. He said that he thought the best way for the president to make his case against impeachment is to leave it to, as he put it, the able man who can defend his case before Congress. Not that what the vice president says will necessarily go in the White House, but I think it's extremely unlikely. And as to what the president can do now, it's a tough question. There's been some real outward White House confidence expressed by the aides to the president, but the question is, whether that confidence is in fact shared by the president. And of all the accusations leveled against President Nixon, certainly among them have not been stupidity or not being politically astute. And he must know that he has a fight on his hands, that he's going to have to fight tooth and nail, and he's going to have to do it any way he possibly can without causing any real kickback, that's a bad word to use, but any repercussions in terms of putting on too much pressure.
Yeah, it would seem that in discussing what the president can do, that you come up with a very short list, do you not, at this point, Chris? I'm talking about overt acts that he could commit in terms of trying to prevent a vote in the House, etc. I mean, there's just not too many options.
Well, it's also difficult, Jim, to figure out exactly what the White House is doing as opposed to what the White House says it's doing or not doing. And you have the White House saying, for example, that its congressional liaison staff is not even taking an actual head count in the House, things like that. Well, that seems a little difficult to swallow. There's no doubt that the president must fight in the House and then in the Senate. In order to do that, he's got to move in on supporters and sympathizers in the House and obviously in the Senate, and he's going to have to use his congressional liaison people and anyone he can get.
Jim, Congressman Rodino is now rather precariously holding his gavel, which indicates that for a refreshing change, we may be getting underway almost on time. I see that most of the committee members have arrived, have taken their seats, or are in the room at least anyway. As we said just a few moments ago, this is the fifth night session for the Judiciary Committee, which began its formal deliberations last Wednesday evening. Do you think that Chairman Rodino may have been twisting a few arms to get his recalcitrants to return from dinner early for a change?
Also, the negotiations and the caucusing and the discussions over possible changing in the language in this article have pretty well been done now.
I think that's right.
Over Sunday, also this morning, they had a long lunch break. Now they've had a dinner break, and the wording has pretty well been resolved in terms of the pro-impeachment majority. And so that's one of the reasons, of course, that they have been so late at coming back to a lot of these breaks, is that they have been working on language and that sort of thing, and there's no necessity at this point, at least, for more work of that type.
Well, we're standing by waiting for the Judiciary Committee to begin its proceedings. We would like to inform you that we do have two resident experts with us again tonight to help us interpret the proceedings, Jack Murphy and Stephen Hess. Jack Murphy of Georgetown University and Stephen Hess from the Brookings Institution. And there you see Chairman Rodino, who apparently really means business this time. He is going to get underway relatively on time. He's banged his gavel once, and now we await the second time.
The discussion tonight is over the substitute amendment, Article 2, offered by Congressman Hungate of Missouri. So you talk about, when you hear the references to the Hungate substitution, that's what they're referring to. The Hungate is playing the same role in Article 2 that Congressman Sarbanes of Maryland played on Article 1.
And we do expect a final vote tonight on the Hungate substitute, perhaps within about 2 hours if all goes well.
The committee will come to order. At the time the committee recessed, the committee was debating the Wiggins motion to strike paragraph 3, and those in opposition to the amendment had consumed 8 minutes, and those in support of the amendment had consumed 5 minutes. And I now recognize the gentleman from California, Mr. Wiggins, for such time as he may consume out of that time.
Mr. Chairman, I yield 5 minutes of my time to the gentleman from Iowa, Mr. Maine.
Mr. Maine is recognized for 5 minutes.
Thank you, Mr. Chairman. Those of this panel who would impeach the President for setting up the Special Investigative Unit would have us believe that there was just no national security involved in this at all. Well, then why was it called the Plumbers Unit? It was called the Plumbers because its purpose was to plug leaks of secret information vital to the national security of the United States. There were many instances where those leaks had occurred. I mentioned several of them just before the recess. There was the secret United States Intelligence Board's report in which it estimated the Soviet Union's strategic strength and the Russians' first strike capacity, a matter of great importance to our defense effort. Well, that was leaked by a government official to a reporter who printed it in the press for the Russians' information. There was the disclosure by one of our senior officials, at least so the newspaper reporter said, of our secret fallback position, our final offer in the SALT talks, the strategic arms limitations negotiations in Helsinki in 1971. Our negotiators there, our negotiating team, were trying to achieve as much security for the United States as possible from nuclear attack. The package which we had on the table there in dealing with the Russians was asking them to stop the construction of all nuclear missiles, both land and submarine-based. But according to another reporter, one of our senior officials confided in him that we were willing to settle for less, that we didn't really expect to get that much security from the Russians, and that if they turned us down, we would be willing to settle for just a ban on construction of land-based missiles and let them go ahead with the submarine-based. Well, now, when that was printed in the newspaper and the Russians read it, you can imagine what that did to our chances of getting the more secure arrangement, the greater protection for our country. That was definitely a security leak which needed to be plugged. Then there was the release of the Pentagon Papers by Daniel Ellsberg, also in June of 1971. Of course, Ellsberg had been identified, so that case is somewhat different because the President's highest national security and foreign policy advisors had warned him that it was extremely important that these officials who were leaking this information be identified and stopped. Well, Ellsberg had been identified, but it was by no means certain that he would not leak more information. Only part of the Pentagon Papers had been published at that time. It wasn't known whether he would go ahead with the rest, and there was also reason to believe that he had additional information. John Ehrlichman, in an affidavit, a sworn affidavit in April of this year, testified that in the week or 10 days after the publication of the first Pentagon Papers, these papers which related to our decision-making processes in a war which was still going on, in which American troops were still in combat, which Kissinger was trying to settle in sensitive negotiations in Paris. Ehrlichman said that Henry Kissinger met with him and the President and told them about Ehrlichman, about Daniel Ellsberg, and told them that he was, and I quote, in knowledge of very critical defense secrets of current validity, such as nuclear deterrent targeting. And I'm reading from page 621 of Book 7, Part 2. And I continue the quote. Having never heard of Ellsberg before the theft of the papers, my impression from Kissinger's description was that the nation was presented with a very serious potential security problem beyond the theft of the largely historical Pentagon Papers. I later learned that the papers themselves were believed by defense experts to contain vital secrets. Dr. Kissinger told the President that the theft made very difficult our foreign relations with allies with whom we shared classified information. In these meetings, both the President and Dr. Kissinger were obviously deeply concerned, end quote.
Gentleman has consumed 5 minutes.
One additional minute, Mr. Wiggins.
Gentleman is recognized for one additional minute.
How the President, ladies and gentlemen of the committee, felt on the advice of his closest foreign policy and national defense advisors that he had to act to protect the national security to stop these leaks. In my judgment, and perhaps yours, he acted unwisely in setting up this special investigative unit, headed by a brilliant young man who had no investigative experience. I believe, and I think you do, that it would have been much better to rely on the FBI, which had experience in this field and would have known the legal limits and the practical limits in which to carry out a proper national security investigation. But is the President of the United States to be impeached because he made an error in judgment, because he was not perfect in his decision to act quickly and necessarily to protect the national defense? Is it a high crime and misdemeanor not to be letter perfect in the performance of your office? I think not, and I think this alleged ground of impeachment simply should not receive serious consideration by the committee.
Gentleman has consumed another minute. I recognize the gentleman from California, Mr. Walde, for 3 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I think this particular issue is one of the most serious offenses alleged against the President. It relates back to one of the remarks that I made in the opening session of this committee when I suggested that the liberties of this country were enormously fragile and had been subjected to an assault the likes of which we have not seen in our lifetime. And I think this particular case, the Fielding break-in particularly as an activity of the plumber, indicates the insensitivity of the President to the constitutional obligations that he had as the President of this country to protect the people in their liberties. One of the basic stability points of a free society is that the law enforcement authority of that society is accountable. And the moment you destroy accountability of law enforcement authority, you jeopardize and endanger freedom of individual citizens. And when the President denied the opportunity of the legitimate law enforcement institutions of this government, the Federal Bureau of Investigation and the Central Intelligence Agency, denied taking his problems with security to them for resolution, and sought to set up an extracurricular secret police force accountable to no one in this government or in this society except to the President individually and as a person, he, in my view, was in a major way interfering with the constitutional protections that have been set up to protect liberty. Now, for the President's defenders to suggest that it was an extraordinary departure from the institutions of law enforcement, but warranted because of the threat of national security, the burden is then clearly upon them to establish that the activities of the plumbers were in fact designed to protect the national security. And I call attention to what I thought was a very important statement of my colleague, Mr. Conyers from Michigan, where he pointed out that we must now, once and for all, draw a line with the use of national security as an excuse for all sorts of illegal and illicit activities generally that result in erosion of freedom. And just to test whether or not national security really was the purpose of this burglary in California when Dr. Fielding's offices were burglared by the plumbers to procure access to the psychiatric files of Daniel Ellsberg, allegedly for a national security purpose, but in reality to interfere with the trial that was to begin involving Dr. Ellsberg, you only have to examine the language of the President in his conversations with Mr. Dean on March 21st and March 17th.
Time of the gentleman has expired.
Well, I appreciate that. It's hard for me to complete a sentence when I want to analyze a conversation, but let me just, I appreciate that. I do appreciate that. I referred to March 21st, and the conversation that I will be reading will be a description of how the Ellsberg case became a national security case. The President is told by Dean about the break-in out there, and he says, the President said, "I don't know what the hell we did that for." And Dean said, "I don't either." And the President said, "What in the name of God did that?" And then move on to page 112 of the March 21st transcript. And the President says, properly, it has to do with the Ellsberg thing. "I don't know what the hell." And Haldeman says, "But why?" The President says, "Yeah, why? I don't know." The President says, "What is the answer on that? How do you keep that out?" "I don't know." "Well, we can't keep it out if Hunt." You see, the point is it is irrelevant. Dean says you might put it on a national security ground basis, which it was. Haldeman says it was, and Dean says, "And just say that," and the President says, "Yeah." And
the other minute of the gentleman has expired.
Well, I really didn't finish the sentence.
Well,
it's a long sentence.
I think you have. Mr. Chairman, how much time do we have remaining on this side?
The gentleman from California has 8 minutes remaining.
I'll be happy to yield 4 minutes to my colleague from Ohio, Mr. Latta.
The gentleman from Ohio is
Thank you, Mr. Williams. I think the gentleman from California used about the longest minute we've had thus far. Well, let me say, he mentioned one conversation that I think that we ought to go back to a prior conversation. His minute didn't permit him to do that. And I have reference to the first time that the President of the United States found out about this, months after the break-in. And that's the conversation between the President and John Dean on March the 17th, 1973. Let's read that. Dean, the other potential problem is Ehrlichman's, and this is, and the President spoke up and says, in connection with Hunt. Dean says, in connection with Hunt and Liddy both. And the president inquires, they work for him? Dean, these fellows had to be some idiots, and we've learned after the fact. They went out and went into Dr. Ellsberg's doctor's office, and they were geared up with all this CIA equipment, cameras and the like. Well, they turned the stuff back into the CIA some point in time and left the film and the camera. Good sleuths, I might interject. The CIA has not put this together, and they don't know what it all means right now. And the president says, what in the world, what in the name of blank was Ehrlichman having something, and this is unintelligible, in the Ellsberg? This is the first time he ever heard of it, months after this had taken place. Dean says, they were trying to, this was a part of an operation that in connection with the Pentagon Papers, the whole thing, they wanted to get Ellsberg's psychiatric records for some reason. I don't know. President, well, this is the first I ever heard of this. Unintelligible again, and perhaps some expletives that were deleted. Care about Ellsberg was not our problem. And Dean says, that's right. Now, the gentleman from Iowa has mentioned something about the FBI not getting into this case, and I think we better talk about that. It was brought out before our committee that the late J. Edgar Hoover happened to know the father-in-law of Mr. Ellsberg. And the FBI was not responding to the prodding of the administration to get on with investigating these leaks, to which I shall refer in considerable length when we get on general debate on the articles themselves. And Mr. Chairman, I yield back the balance of my time to Mr. Wiggins.
Well, I'm waiting for him to rule. Mr. Chairman,
the gentleman has 3.5 minutes remaining.
Total. May I be recognized?
Gentleman is recognized.
Mr. Chairman, it was my intention to discuss the Houston plan and to clarify for the benefit of our members the origin of that plan, and to demonstrate that it was a plan of the top security people in this country recommended to the President of the United States, and he acted in pursuant to their advice, approved their plan for a period of about 4 or 5 days, and thereafter canceled his prior approval upon the recommendation of the Attorney General. I only intended to take the time on that subject because some of my colleagues seem to be concerned about that 4 or 5 day period of approval by the President of the United States in 1970. Rather, in my remaining moments, Mr. Chairman, I want to try to place this plumbers issue in its proper focus. The question is not whether the creation of the plumbers was justified. There is no law, nor regulation, nor rule, nor act of Congress prohibiting a President of the United States from establishing a unit within the executive branch for the purpose of coordinating intelligence activities. That's not the issue. The issue, rather, is whether or not the activities of that unit, once created, constitute an impeachable offense with respect to the President. We know that they do not, unless the President approved them, had knowledge of them, acquiesced in them, condoned them. Well, we now know, as a result of the splendid contribution of my friend from Ohio, that the President did not learn of these activities with respect to Dr. Fielding for nearly 18 months after they happened. The first time he learned about it. And now the question is, should he be impeached? Should he be impeached because he took an improper act upon learning of that activity? The President, without question, ladies and gentlemen, without question, regarded the Pentagon Papers matter as a national security issue. It is idle to talk about whether a conviction is proper under the Espionage Acts. Those acts, as my colleagues at the desk know, involve aiding a foreign power. It wasn't the motive of Dr. Ellsberg, ladies and gentlemen. It was the fact of disclosure, whatever his motive, that prejudiced the United States of America. And the President's actions were prompted by reason of the fact of disclosure rather than any subjective motive of Dr. Ellsberg to aid a foreign power, a fact which would be very important in a prosecution under the Espionage Acts. That's the issue. That's the issue, whether or not after the 17th of March, 1973, when the President learned of an act which happened about a year and a half prior to that, whether he acted prudently, given his state of knowledge and belief at that time. And I'm telling you that the weight of the evidence, the overwhelming weight of the evidence, is that Richard Nixon believed the Pentagon Papers issue was a national security issue. And his actions after learning in March of 1971 were wholly consistent with that belief on his part. Now, if a majority of this committee really believes that a president of the United States should be impeached because his honest and good faith belief that the security of this nation is in jeopardy and that decisive and bold action is required on his part, then so be it. But, ladies and gentlemen, you live with that judgment. History is going to judge you ill if you make that judgment. This is not a proper grounds to impeach the President of the United States. I yield back the balance of my time.
Recognize the gentleman from Maryland, Mr. Sarbanes, for 3 minutes.
Thank you, Mr. Chairman. I think it's very important for the members of this committee and the American people to appreciate exactly what the plumbers did in the Fielding break-in. The plumbers broke into Dr. Fielding's office. Dr. Fielding was not under suspicion. They went into his office in order to get one of his files on one of his patients. And I ask every doctor and lawyer and insurance agent and accountant in the country, what kind of land would you be living in if a group of hired hands have the power to come into your office in the dead of night in order to get one of your files? If the purpose was legitimate, why didn't they obtain those files in a lawful manner? And the answer to that is, of course, the purpose was not legitimate. Who were the plumbers? They were a band of hired hands. They were not law enforcement officials. Why wasn't the FBI brought into this matter if it was a legitimate matter for governmental action? Because the plumbers were doing absolutely illegal things that the FBI refused to do. And that does go back to the Houston plan of the previous year, when this fellow Houston put forward to the President and had it approved a plan that involved surreptitious entry in a memo that says the activity involves illegal entry, and the FBI opposed to surreptitious entry. That same Houston report provided for covert mail coverage, and the FBI added a footnote and said the FBI is opposed to implementing any covert mail coverage because it is clearly illegal. They could not use the FBI because the FBI was not prepared to do these illegal things. Let us look at one other thing. From whence did the plumbers get their money? Where did the money come from in order to do this operation? Ladies and gentlemen, it came from private sources. Mr. Baruti, a PR man here in Washington, a close friend of Mr. Colson's, states in an affidavit in the latter part of August or on the first part of September, Mr. Colson telephoned me and told me that the White House had an urgent need for $5,000. So he took $5,000 over to Colson's office, and they told him to go down to an office and give it to the fellow that he would find there. That was Eagle Crow, the head of the plumbers unit.
So Baruti goes down there with his $5,000 in cash and gives it to Krogh. He takes it in there. They said, "Did you look in there to see what it was?" "I looked in the envelope to see this was money inside of it. It was in the form of cash." "Had you stated to Mr. Colson anything about the form in which you wanted the funds?" "Yes, he wanted them in cash." "Why?" "I believe because it was felt that there shouldn't be any way to trace the money that was used."
The 3 minutes of the gentleman has expired. I recognize the gentleman from Massachusetts, Father Drinan, for 3 minutes.
Thank you, Mr. Chairman. This fiasco called the Plumbers had 3 names. It started out as Project Ellsberg. David Young named it the Plumbers, and the President, 18 months later, gave it the name of Special Investigative Unit. It was political and covert and unlawful from the beginning. Patrick Buchanan had the good sense to decline the job that was offered to him to be head of the Plumbers. And on July 8, 1971, he gave the best description of the purpose of then Project Ellsberg. He wrote in a memo to Mr. Haldeman that this is a project for a 3-month period to link the Pentagon Papers with the left-wing newspapers and people of America. There was no national security involved. Mr. Pat Buchanan had an alternative, which he thought was better. Let's undertake a major public attack on the Brookings Institution. Everyone had hysteria over the Pentagon Papers except Melvin Laird. 10 days after they were released, he said that 98% of the Pentagon Papers could have been and should have been declassified. The hysteria, I assure you, was created months after when the identity of the Plumbers came out. In Mr. St. Clair's brief on page 94, he said that the Special Investigative Unit was created, quote, in an entirely legal manner. And I doubt if he can support that, because this is entirely outside the ordinary way that the executive branch of government operates. Mr. St. Clair concedes at a moment in time that there was a shift in the unit's way of acting, but he said that the purpose was legitimate. He failed to tell us why they had sterile phones, whatever they are, in this little cubbyhole in the executive office building, and why you needed special passes to enter this section, and why, in total defiance of the law of the CIA, they regularly violated that prohibition against any internal security matters of the CIA. Mr. Henry Peterson testified before this committee on July 12, and he said there is no area of violations of federal criminal laws which is not covered by existing statute, and that if there is any residual jurisdiction, it goes to the Department of Justice. I suggest, therefore, that this was political and unlawful from the beginning, and the names came later. If the President says that there's an epidemic of leaks, that is not substantiated by the evidence. And let me quote you one justification that has come out today in a minority report from this committee that demonstrates that hysteria is still going, and with that I close. And this statement says, in justification of the Plumbers, that foreign espionage agents can read English and they can read the New York Times. Thank you very much, Mr. Chairman.
Time of the gentleman has expired. I recognize the gentleman from Maine, Mr. Cohen, for 3 minutes.
Thank you, Mr. Chairman. I'd like to direct my attention to the final sentence of this paragraph, whereby the President attempted to prejudice the constitutional rights of the accused to a fair trial. Several days ago, the gentleman from New Jersey made a statement that we must view the totality of the evidence, and I happen to agree with Mr. Sandman. He is absolutely correct, because only by viewing all of the evidence can we trace the threads of attitude and action that weave a pattern of spirit and conduct that is the very basis of our investigation. And I want to call your attention to the September 1572 conversation between the President, Mr. Haldeman, and Mr. Dean, whereby Mr. Dean indicated he was talking about Edward Bennett Williams, which time the President says, we're going after him. Haldeman, this is the guy we've got to ruin. And then I'm skipping on to page 10. I think we're going to fix, and I'm paraphrasing the SOB, believe me, we've got to, because he's a bad man. Now, I think this statement is relevant with respect to the Ellsberg matter, because Mr. Colson told us, as he told the court, that on several occasions the President urged Colson to disseminate information about Ellsberg and also his attorney, and this is the same act for which Mr. Colson pled guilty to corruptly endeavoring to obstruct the criminal trial by devising and implementing a scheme to defame and destroy the public image and credibility of Ellsberg. Now, Ellsberg, in my opinion, and I agree with Mr. Hogan, he should have been prosecuted, but his trial should have been gone to its full conclusion according to due process of law. What was done in Ellsberg reminded me of what Commodore Vanderbilt said to his adversaries: "I won't sue you, I'll ruin you." The administration did not just seek to sue or prosecute Ellsberg for his wrongdoing, they set out to ruin him. And that, ladies and gentlemen, of this committee is not only contrary to the spirit of our Constitution, it is also contrary to the law, as stated in the cases of U.S. against Krogh and Colson. A man cannot set attack dogs loose with general instructions to stop and destroy leaks at any cost, and then say that he is not responsible when the constitutional rights of citizens are shredded in the process. I yield to the gentleman from Maryland.
The gentleman has 1 minute remaining.
I'd just like to return to the wiretap matters that I wasn't able to finish earlier. In addition to the Kraft wiretap having no criminal or national security basis, it was done by a consultant to the committee to re-elect the president, which makes it totally illegal. In addition, under normal procedures, the Attorney General reviews the necessity and propriety of wiretaps on national security matters every 90 days, and this practice was not followed in respect to any of these 17 individual taps that the president had authorized and approved. Now, I'd like to read from a transcript of a conversation between the President and Dean on February 28, 1973 on wiretaps, when they were just talking about the Time magazine story which revealed the wiretaps at the White House. The President says, "Sure, and the Henry staff, he insisted on Lake, you see, after working with McGov for Muskie." And Dean says, "Uh-huh." And the President says, "Incidentally, didn't Muskie do anything bad on there?" Unintelligible, Henry, unintelligible. "At least I know not, because I know that. I know that he asked that it be done, and I assumed that it was Lake and Halpern. They're both bad." This is the President talking. "But the taps were, too. They never..."
Time of the gentleman has expired. All time has expired, and the question now occurs on the Wiggins amendment to strike paragraph 3. All those in favor of the motion to strike, please signify by saying aye. Aye. All those opposed? No. The noes appear to have it. The noes have it, and the amendment is not agreed to. I recognize the gentleman from Texas, Mr. Brooks.
Thank you, Mr. Chairman. Mr. Chairman, in this debate, we have neglected a most vital part of this article, being Section 1. I think it is very pertinent to this entire activity. It is a primary area of abuse that has subjected the American people to spying and prying. And in the interest of debate, in that all of those members who have an interest in presenting the facts on this matter, Section 1, and those who are opposed to it, I have an amendment at the desk to strike Section 1. Would so move.
The clerk will read the amendment.
Amendment by Mr. Brooks. Strike subparagraph 1 of the Hungate substitute.
And the gentleman from Texas is recognized in accordance with the rule recently adopted by unanimous consent. The gentleman recognizes that there's 20 minutes in opposition to the amendment and 20 minutes in support of the amendment. And the gentleman controls the 20 minutes in support of the amendment.
Mr. Chairman, I would ask that the time that I would use be deducted from the time of the opponents of this, so that the proponents of it would not suffer in any way and would have a full 20 minutes to utilize, which I would yield to them as they request.
Without objection, it is so ordered.
Mr. Chairman, Mr. Nixon's personal involvement in efforts to misuse the IRS for political purposes in violation of individual civil rights is clearly documented in events that occurred on September the 15th, 1972. In the tape of a meeting between the President, Mr. Haldeman, and Mr. Dean, there is no question that there was some discussion as to how efforts were going to get the IRS to institute audits and investigations of Mr. Nixon's political enemies. Some of the evidence involving Mr. Nixon's efforts to misuse the IRS has not been made available to this committee. The transcripts submitted to us do not include the last 17 minutes of this meeting with Haldeman and Dean on September the 15th. And yet, Mr. Dean has testified that during that time there was a specific discussion about the plan to use IRS for these purposes. Judge Sirica has listened to the entire tape and has announced in open court that those 17 minutes do indeed involve conversations relating to the abuse of the IRS. He has since made those 17 minutes available to Mr. Jaworski, but under the restraint put on him by the U.S. Court of Appeals, has been unable to provide them to the Judiciary Committee. And needless to say, Mr. Nixon has not made this portion of the tape available to us, despite his continuing protestation that he intends to cooperate fully with our investigation. Now, we can only use the evidence that we have. And that evidence, the September 15th tape, Judge Sirica's announcement, John Dean's testimony, the Johnny Walters testimony, clearly indicates that there was a definite, concerted plan to misuse the Internal Revenue Service for personal and political gain. Now, Mr. Chairman, our constitutional safeguards protecting individual rights against arbitrary and unrestrained government power mean very little to a president who would use the IRS for such distorted fashion. I would reserve the balance of my time for those who are opposed or in favor of this proposition.
Mr. Chairman.
Gentleman from New Jersey, Mr. Sandman.
I'm in an uncanny position, Mr. Chairman, because I can't figure out, as I couldn't yesterday, whether or not the proponent of the motion to strike really wants that motion carried. Now, if he does, he has my assistance. And I know of a lot of other people who will give him their assistance. Now, before I comment, I would like to hear from the gentleman from Texas. Do you really want to strike paragraph 1? Let me know how I should proceed. Will the gentleman from Texas please answer?
I'd be pleased to answer. I thought I had made clear to my distinguished friend from New Jersey that in the interest of debate, of getting the facts about just what happened to the IRS, how it was used, who told them to do it, what they did, that I thought that we ought to have this motion so that the people of this country and so this committee can fully evaluate just what happened. And I want you to have every advantage of a full 20 minutes to discuss why it should be included.
That's fine, but I'm still wanting to know, do you want your motion passed? If
well,
you
to
want,
be
I'll
candid
supply
about it,
a
when
yes
you
vote.
offer a motion for debate purposes, you're not necessarily confined to wanting it passed, and
well,
certainly I do not.
Now stop using my valuable time. The public now knows what you're up to.
You glad to get you that time, Mr. Sandman.
I'm not going to yield
it.
you any more of that valuable time because it is obvious that this is a game. In fact, we've been involved in quite a few games here. And you aren't any more serious about striking this article than my friend from Alabama was yesterday in striking any of the articles that he tried to strike. I'm mindful of the fact that they tell me we have about a 20% audience, which is about 44 million people it gives you exposure to. And maybe you can convince them with some of your generalities. That's the purpose behind all of this. I know it, you know it, and 44 million people know it. Make no mistake about it. Now, I'd like to yield some time to some other members of this side, and I'd like to yield to the gentleman from Indiana, Mr. Dennis.
Thank you, Mr. Sandman. I would like to say, Mr. Chairman, that if I felt that the evidence here substantiated that the Internal Revenue Service had been misused and abused for improper political for discriminatory purposes, I would take a very dim view of that myself. I would do so even though such use, misuse, and discrimination has not been entirely unknown in past administrations, because that would not constitute a defense now, even though nobody bothered to fool with it then. I believe, for instance, that in his diaries, the late Drew Pearson says that the late Harry S. Truman turned the IRS loose on him at one time. And that doesn't make it any better if it was done now, but I think it's a good thing to bear in mind that we have a certain amount of pious hypocrisy in these proceedings from time to time. Now, the truth of the matter is that there really isn't any evidence connected with the president, again, if you please, which we're always sort of sloughing over here. The president did anything out of the way about the IRS at all. The only thing anybody even attempts to cite is the conversation of September 15th. And as a matter of fact, the president doesn't refer to the IRS in that conversation. He says, we have not used the power in this first 4 years, as you know. We have never used it. We haven't used the Bureau. That's the FBI, and we haven't used the Justice Department. He doesn't talk about the IRS, as a matter of fact. But the interesting thing is that all that conversation is talk anyway. Now, it's not good talk. It would be damaging talk if there was something to be shown that the president ever followed up on it. But I haven't seen anything in this record where the president did follow up on it.
The gentleman from New Jersey has used 5 minutes.
I reserve the balance of my time and request Mr. Brooks to take out the podium again.
The gentleman from Texas is recognized.
Mr. Chairman, I would yield 2.5 minutes to Congressman Mr. Danielson from California.
The gentleman is recognized.
Thank you for yielding. Inasmuch as my distinguished friend, Mr. Sandman, and others request specificity on many of these items, I feel it's appropriate that it be provided. Within this field of the use of the Internal Revenue Service, there are other items than those mentioned by Mr. Brooks. For example, along in 1971 and 1972, Mr. John Dean, who had authority to work as liaison between the White House and the Internal Revenue Service, obtained confidential Internal Revenue information about a rather large number of people, and under his direction, efforts were made to have the Internal Revenue Service conduct audits on certain persons who were low on popularity within the White House. This is borne out on March 13, 1973, for example. In a conversation within the Oval Office, the President asked Mr. Dean if he needed anything from the IRS, and Dean responded that he didn't at that time. He said he now had sources in the IRS and could get whatever he needed without any further trouble. Along in the spring of 1972, the political campaign was warming up, and they thought, John Ehrlichman and others in the White House thought it would be good to get some information on Lawrence O'Brien, who was chairman of the Democratic National Committee. They had found that in an investigation of Howard Hughes, there was some information indicating a financial connection with Mr. O'Brien. So Mr. Ehrlichman in 1972 instructed Treasury Secretary Schultz to investigate and interview O'Brien about his tax returns because the president was interested. Thereafter, because of the inquiry, the IRS did interview Mr. O'Brien, and they furnished Schultz with the results of the interview. It didn't indicate anything particularly bad, so on August 29, Schultz, together with Treasury Secretary Schultz, together with Barth and Walters of the Internal Revenue Service, decided that they would do nothing further about O'Brien. They notified Ehrlichman that they were dropping the matter, and of course Mr. Ehrlichman strenuously objected. But they wouldn't leave it alone at that point. A couple of days later, in early September, Mr. Ehrlichman got in touch with Herbert Kalmbach, the president's loyal personal attorney and fundraiser, and told Kalmbach to go up to Las Vegas, Nevada, and plant the story with Hank Greenspun of the Las Vegas Sun, I believe it is. But Kalmbach, fortunately, refused to do so. But this is a part of the pattern of misuse of the Internal Revenue Service.
Gentleman from Texas.
Mr. Chairman, I would yield 2.5 minutes to the gentleman from Illinois, Mr. Railsback.
Gentleman from Illinois is recognized.
I thank the gentleman for yielding. This is one of the areas that I mentioned I was concerned about in my opening statement. I want to express the feeling that I share the concern that was expressed by the gentleman from Iowa, Mr. Maine. Let me just say that this story is what I would call both bad and good, or good and bad. The story is bad in the respect that top officials of government clearly tried to misuse their power. Good in the respect that in this particular case, contrary to many of the other aspects of the Watergate affair, there were some good people in the administration that rejected and fought what I think was a blatant misuse of power. The facts are these that trouble me so much, and I realize that other administrations had been guilty of similar activities, but certainly I don't think on the massive scale that this was attempted. On September 11th, John Dean gave 591 names to the Internal Revenue Commissioner and asked him to audit those persons' returns. What is an IRS audit? What is an audit? Well, to begin with, the taxpayer is asked to furnish a full and complete justification for everything used within the tax return itself. The IRS agent has access to prior returns. An audit of civil cases can go back 3 years, and in a criminal case, if criminal fraud is suspected, they can go back without limit and check in any and all returns filed by the taxpayers. In a typical civil case, the agent must be provided by the taxpayer access to all records involving deductions, medical bills, information regarding outstanding loans, and other significant financial data. If the IRS agent suspects there's been income received and not reported, he will prepare a net worth analysis, and to do this, he will interview friends, neighbors, associates to determine a taxpayer's lifestyle. Oftentimes, the taxpayer will have to hire a lawyer or an accountant at an expense to him. Many of my constituents have complained about IRS audits. Now, the direct evidence that we have testimony by John Dean along these lines. This was conducted by Mr. Doerr of John Dean in secret session. This list of 591 names, they were a group of McGovern's supporters and contributors.
The 2.5 minutes of the gentleman has expired. I recognize the gentleman from New Jersey.
It's interesting to note that the gentleman from California, Mr. Danielson, has given me an opportunity to prove beyond all reasonable doubt what we've been arguing about. The specificity, it's a real word. And that's the thing that's going to be remembered here, because those who have that solid 27 seek to violate it so badly. Now, here is the whole case. Let me make an illustration of what this gentleman has said. They're willing to be specific, sure they are. Look at how specific he just was. He started out by saying, on a number of occasions in 1971 and 1972, John Caulfield, a member of John Dean's staff, obtained some IRS confidential information. In any court in this land, would that kind of indefinite thing hold up? Of course it wouldn't. Let's go down to the next one. In the spring of 1972, the spring takes in 3 months. What part of the spring? He doesn't dare tell you because he doesn't know. That's why they don't want to get specific. And in that one, John Ehrlichman received some information and passed it on to someone else. The next thing he told you, during the summer of 1972, a span of 3 more months. Now, the 38 members here have tried more criminal cases than they ever want to remember. And there isn't one can tell you that this can hold up in any court in the land. Each of these periods is 3 months. When in 3 months? And you can go right on through the whole bit. It's just a whole conglomeration of generalities. That's why they don't want to get specific. They don't want to do this thing the right way. Never did. Now, we have valuable time, and I want to yield to my friend from California, Mr. Wiggins.
I thank my colleague for yielding, and I'll only take a moment. But I do want to put in focus what my friend from Illinois has just said about this egregious act of John Dean in going to the IRS with some 500 names of political opponents of the president. That is absolutely indefensible, ladies and gentlemen, and no one at this table, Republican or Democrat, friend or foe of Richard Nixon, condones for 1 minute that act. But you see, the president didn't know that. He didn't know that John Dean went to the IRS, and there isn't a word of testimony that he did know when Mr. Dean went. And it's important as well to know what the IRS told Mr. Dean. The person that told Mr. Dean was the appointee of the president, executing the president's instructions, I presume. And there's no dispute as to what Mr. Dean was told. And in so many words, and if you'll pardon the expression, he was told to go to hell. Now, that's what happened.
Would the gentleman
For
yield?
that, the president is not to be impeached. This whole case of IRS abuse turns on the conversation of September 15, and on that, we'll just have to submit that. And we'll study it, and review it, and decide whether or not at that time the president approved of this, or whether it was simply a discussion in the context of the time 3 months before an election in this country. I'll yield back that time to my friend from New Jersey.
Mr. Chairman, I yield 3 minutes to the gentleman from Indiana, Mr. Dennis.
Gentleman is recognized for 3 minutes.
Mr. Chairman, continuing the situation, I think it's worth remembering that Commissioner Walters said on the occasion that Dean came to him that Dean stated that he had not been asked by the president to have this done, and he did not know whether the president asked that any of this activity be undertaken. And Mr. Dean stated here in this committee, in answer to Mr. Railsback, I don't know of any audits that were accomplished, and the Joint Committee on Internal Revenue Taxation found that, in fact, none of these people were audited. So that's the record on the situation as to what actually took place as against a political conversation on the 15th day of September. And there is no evidence in the record anywhere that the president ever made any request except a hearsay statement by Clark Molinoff, who says that Haldeman told him that the president asked for a report on Governor Wallace's brother, which wouldn't stand up in any court in the land. And there's no evidence that that, in fact, is the truth, and it's been denied by 2 or 3 other people during the course of the testimony. And as Mr. Railsback said, there are good people in this. There were Secretary Schultz, there's Commissioner Thrower, there's Commissioner Walters. All of them turned Ehrlichman's efforts and Dean's efforts down. There's no evidence of a presidential effort, and the thing that there is evidence of is that Secretary Schultz and Commissioner Walters and Commissioner Thrower were presidential appointments of Richard M. Nixon's. I yield back to the gentleman from New Jersey.
I yield 2 minutes to the gentleman from Ohio, Mr. Latta.
Thank you for yielding. I want to reemphasize, underscore in capital letters what's been said by the gentleman from California, Mr. Wiggins, that no one at this table condones any such request that Mr. John Dean put forth. And certainly if the President of the United States had put forth that request, I would think that would be an impeachable offense. Now, the question is, did he or did he not authorize John Dean to do this? As already been pointed out, when he went to Mr. Walters, he specifically stated that he was not there at the President's request. And I think it's important to note, when this whole matter was submitted to a Joint Committee on Taxation here in the Congress, which is controlled by the opposition party, that they made this report. The staff's investigation paid particular attention to the cases of those individuals mentioned in the press as victims of politically motivated audits. The Joint Committee staff has difficulty in discussing these cases specifically because of the problem this would present in violating the individual's rights of confidentiality. Now, this is the place I want to emphasize. However, in none of these cases has the staff found any evidence that the taxpayer was unfairly treated by the Internal Revenue Service because of political views or political activities. Now, this conclusion is further supported by the House Judiciary Committee's materials, this committee's materials. Commissioner Walters stated in his affidavit of May 6, 1974, with respect to the list furnished him by Mr. Dean, "At no time did I furnish any names or names from the list to anyone, nor did I request any IRS employee or official to take any action with respect to the list."
The gentleman has consumed 2 minutes, and the gentleman from New Jersey has 6 minutes remaining.
I'd like the gentleman from Texas to take the next time.
The gentleman from Texas has 11 and a half minutes remaining. Gentleman from Texas.
Mr. Chairman, I yield 5 minutes to the gentleman from Iowa, Mr. Mizvensky.
Okay. Gentleman from Iowa is recognized.
Thank you, Mr. Chairman. Mr. Chairman, this article is the article on abuse of power. To me, it really symbolizes what the drafters of the Constitution really meant. They were worried when they just came out of a revolution whether or not we, in fact, would find a president that would abuse that power. And you found that a gentleman from Virginia, Mr. Randolph, said that he really advocated the impeachment process, specifically because he was worried about that abuse of power. Abuse of a presidential power, because if the president would abuse that power, it could very well lead to, quote, insurrections by the people. And really what this particular provision, it's a committee provision which is saying that to guard against this abuse, we have to take a look. We have to see, which what the Founding Fathers didn't have at that time, the Internal Revenue Service, whether or not that's been abused. And I think why the gentleman from Illinois, Mr. Railsback, and also the gentleman from Iowa, Mr. Maine, are so concerned about this matter, and why some of my colleagues, in all due respect, are defensive, is because I think there's the realization that one of the greatest abuses that we have is the abuse of the IRS. Because I think there's the realization that it poisons the system. If you abuse the IRS, really what you're doing, you're poisoning the system, and to a great extent it becomes probably one of the most hideous of all the charges. And why? Because we all pay taxes. We know that the IRS has personal information. We know that it's based on voluntary action on the part of all of us. We know that it's based on honesty and our conscientious ability to pay our taxes. And we have, really what we have is a self-confession when we all file our taxes. We know that and we understand it. And I think why the apprehension sets in is because there's the realization that Richard Nixon's presidency has really leveled a serious blow in the area of the abuse of IRS. Now, you've had talk about the enemies and the enemy list. And I'd like to say that there's another area. What happens about taking care of your friends? And I have submitted before that one of the president's best friends is the president himself. And we'll have an article on that subsequent to the one that we're considering tonight. Now, what do we see about the friends? And why is the friends matter as significant as the enemies? Because if you impede the due administration of the Internal Revenue Act with a violation that someone may have done, and you say that in fact the IRS is conducting an audit of that particular individual, and then you get a directive from the White House saying, look, which we have direct testimony from that says that we have to take care of our friends and turn the IRS off of our friends. What does it mean? It means another kind of cover-up. It means another kind of protection. And that's exactly what's happened. And let me tell my friends, though we're in a constitutional issue, which I agree, and they're groping for criminal violations, that if you intend and you are part of helping your friends and stepping into an audit that is done by the IRS, that is an interference with the due administration of the Internal Revenue Act. And I only cite it as an example, which is not only a significant violation of our Constitution and abuse of office, but it's also a clear violation of Section 7212 that says that, in fact, if you interfere with the due administration of the Internal Revenue Service, you're subject to a felony and to being put in prison. And I would bring that to the attention of the members of this committee. I'd also say that, in all respect, the Joint Committee on Internal Revenue Taxation that took a look at this issue, what are they doing? That investigation is going on. And they, in fact, have asked for re-audits of those friends, those ones that have had direct contact and have been the closest associates and friends of the White House, and we have testimony direct that, in fact, the White House was involved. Now let's point to the one item that's very interesting to me. That's the whole focus on September 15th and the testimony by the gentleman from California, who I respect, Mr. Wiggins. No direct testimony. We have Mr. Dean just talking about it. He's talking about it supposedly in the abstract. Well, let me say this, that it's not in the abstract. It's right on target. Let's refer to March 13, 1973. And what do we see? We see direct involvement, direct discussion. Page 50. They're talking about issues. What does the President say directly? Do we need any IRS stuff?
The time of the gentleman has
direct
expired.
Involvement.
And the gentleman from Texas has 6.5 minutes remaining, and the gentleman from New Jersey has 6 minutes remaining, and the gentleman from New Jersey wish to be recognized.
I recognize the gentleman from Mississippi, Mr. Lott, for 3 minutes.
Gentleman is
Very much,
recognized.
Mr. Sandman. Mr. Chairman, this is certainly an area that can be used to inflame the emotions of the American people, because there are many out there that I know of personally that feel that they are harassed by IRS and don't feel that they're necessarily on anybody's list. But I think that there are some key issues and points that we must stress and keep in mind. There is no evidence of any such misuse in the final analysis on the part of the President. The Joint Committee on Internal Revenue Taxation's report should be noted in this conclusion, and I'm going to cite some sections from that report in a minute. Also, almost all of the examples of alleged attempts to misuse IRS come from the person that used the most influence, supposedly, within IRS to get these audits. John Dean is a person that made these points with John Walters and others. Now, a lot has been made of this missing 17 minutes of tape. Well, the fact is we don't have that 17 minutes. And there's already been some contradictions about what's included in those 17 minutes. So I don't think we can base this decision tonight on something that we don't yet have. And maybe we will later on, and we should consider it then. But it's been claimed that several individuals in the White House attempted to misuse the IRS for partisan political purposes. It's clear that such an alleged misuse could only succeed if it were supported by the power and authority of the President in the final analysis. On looking at all the evidence available, it's clear the President did not take that action. And one point I want to emphasize that Mr. Dennis made a while ago. These people that have been praised so highly, Mr. Schultz and Walters and Thrower, these people were appointed by the President, just as these aides were, like Dean. Now, let me quote to you some of the sections in the report from the Internal Revenue Committee. However, in none of these cases has the staff found any evidence that the taxpayer was unfairly treated by the Internal Revenue Service because of political views or activities. The staff believes that in 3 cases there are substantial questions about decisions made by governmental agencies about friends of the White House, but the staff does not have evidence that there was any pressure involved. The staff also believes that a number of enemies either were not audited when the staff believes they should have been, or were audited too leniently. And then in Mr. Dean's response after questioning by Mr. Railsback, he says, so I don't know if the President got it back in it or not, or I don't know of any audits that were accomplished. In conclusion, I think that the record clearly shows that while some personnel at the White House may have indeed used improper intentions against the IRS, the fact is, in the final analysis, no IRS abuse resulted. Thank you.
The gentleman from New Jersey has 3 minutes remaining.
I reserve and yield to the gentleman from Texas to use some of his time.
The gentleman has 6.5 minutes remaining.
Mr. Chairman, I'd yield 6 minutes, reserving 30 seconds to myself. The 6 minutes I yield to the gentleman from Alabama, Mr. Walter Flowers.
I yield
Gentleman
1
is
minute
recognized.
of my time, and I thank the gentleman from Illinois, Mr. Railsback.
Thanks, Mr. Flowers. Let me just say, let's don't delude ourselves here. There was a conversation. The President was involved. The President knew exactly what John Dean had done on September 11th. Not only did he not turn it off, in my opinion, and according to John Dean's direct testimony, he told him to go back again. Now, some people argue that because nothing was done, that there's no serious offense. Why wasn't there anything done? Was it because the President of the United States decided to turn it off and register his outrage? It's because these investigations did not occur because there happened to be two rather dedicated public servants, one by the name of George Schultz, and then a rather good IRS commissioner that wouldn't have anything to do with it. And I think that Commissioner Walters gave very good advice to Mr. Dean. When he presented this list, he testified that he told Dean that compliance with such a request, and I quote, would be disastrous for the IRS and for the administration and would make the Watergate affair look like a Sunday school picnic.
I thank the gentleman for his comment. You know, my friends, a fundamental principle of our government is that equal justice under law is a guarantee to every citizen. Put it another way, we are a government of laws and not of men. This commitment to equal justice is written down in a few places, like in our Constitution and in our laws and in some court decisions. But I think just as important are some commitments to this principle that must be assumed in our society. For instance, the assumption that the sensitive agencies of government with peculiar power over each one of our citizens, like the police power and the power to tax, will not be abused or misused for political purposes. This is a fundamental source of the people's confidence in their government. We, the people's confidence in our government. That the President and his men should have trifled with this source seems to me sufficiently grave to qualify as a component of an article of impeachment. Can you imagine under any circumstances ever the President of the United States saying to an aide, do you need any IRS stuff? Well, that happened on March the 13th, 1973 in the White House. Can you imagine the President's lawyer, his counsel, his close subordinate, saying with impunity and apparent approval of the President, we have a couple of sources over there that I can go to. I don't have to fool around with Johnny Walters, who was our IRS commissioner. We can get right in and get what we need. That also happened in the White House. Let me turn to some specifics, which may be just the tip of the iceberg. There was a two-pronged attack on a well-known political figure who is now the governor of my state, and a great and courageous American, which I believe is shared equally, a belief I believe is shared equally by those who agree or disagree with him. In the spring of 1970, George Wallace was not governor of Alabama, but engaged in a heated contest with then-Governor Brewer, who had succeeded Governor Lurleen Wallace on her death in 1968. The decision was made by whom I don't know, but I think you can be certain it was in the highest councils of the White House, that the success of Governor Wallace in a Democratic primary in the state of Alabama was somehow incompatible with the interests of the Nixon administration. So what did they do? Well, at the specific instance of Mr. Higbee, primary assistant to Mr. Haldeman, Chief of Staff to the President, $400,000 in funds left over from the 1968 presidential campaign was funneled into Alabama in a devious and undercover manner in an unsuccessful effort to defeat Governor Wallace. There's direct evidence to this from Mr. Kalmbach before this committee in this room. Then in early 1970, H.R. Haldeman directed a special counsel to the President to obtain a report from the IRS about its investigation of George Wallace and his brother. Haldeman gave assurances that the report was for the President. A report from IRS Commissioner Thrower was requested on this basis, received, and given to Haldeman. Material contained in the report was thereafter transmitted to Jack Anderson, a syndicated columnist, by Murray Chotiner, a White House aide and personal confidant of the President. Portions of the material potentially dangerous politically to Governor Wallace were published nationally on April 13, 1970, several weeks before the primary election. Now, both of these foregoing actions were a gross abuse of the IRS as an agency of government and, incidentally, a violation of federal law. Now, I ask you, my friends, who was it that maintained a political enemies list in an effort to get back at them? It was the administration of Richard Nixon. Who was it that released potentially damaging tax information about the governor of Alabama? The aides of Richard Nixon. And on another subject of gross abuse, who was it that frustrated that ultimate date with justice that awaited Daniel Ellsberg and Anthony Russo, and which I trust would come to them at the hands of a jury? Was it some left-wing radical liberal plot? No, my friends, it was the administration of Richard M. Nixon. However you describe yourself and wherever you may be, you ought to be vitally concerned here, because if this president, with whom you perhaps agree politically, can get by with the abuses described in this article, then so can succeeding chief executives, including those with whom you do not agree, thus imprinting in the standards of our highest office a standard of conduct that is certainly unacceptable to me.
Time of the gentleman has expired. The gentleman from New Jersey has 3 minutes remaining.
Well, I think now we have the whole case, and if we could rest all of it on this one, this lawyer would ask for a directed verdict because these are the facts. And now you know why they won't be specific. All they have are generalities, groups of dates, and each one include about 3 months. All they have is, in 1970, Haldeman told Mollenhoff. All they have that over here sometime in 71 and 72, Caulfield did something the dean told him to do. All they have is in the spring of 72, Ehrlichman told someone else something. The only thing left is that magic date, September the 15th, 1972. Why don't you say that's all you have? Why don't you let this count rest on that date? Because you know it can't hold up. That's why you don't do it. And here's why it won't hold up. All you have is a conversation which anybody that listens to that tape can tell why and how it was arrived at. Mr. Railsback now has brought something new in. This is a majestic case, to say the least. Modern Times has done away with the Fifth Amendment. We heard that a day or so ago. And what did Mr. Railsback just say? You know what he said? Nothing happened. Not one of the 591 people were audited, not one. But you got to look past that. You can impeach the President of the United States for a thought, not a deed. That's what he's saying. When did that happen before? And what kind of law is this going to make for every man that sits in the White House from now on? This is what I'm concerned about. This can be a stage show from now on for any majority party to manipulate against any man that becomes President of the United States that is not a member of his party. And such action as that cannot be in the best interest of the government and the country we all love so well. This is the thought we have to prove to 220 million people. This shows beyond all reasonable doubt. You cannot prove this count. You know it. The people know it. And why don't you pass this motion to strike?
Time of the gentleman has expired. The gentleman from Texas has 30 seconds remaining.
Mr. Chairman, with 30 seconds remaining, I would yield 15 of that, half of what I have, to my distinguished friend from New York, Mr. Fish.
I thank the gentleman. I'd just like to say that
I think most people listening to us know really what is the facts here, that to faithfully execute the laws of our country does involve policing your lieutenants and does involve an obligation to stop them when you see the course in which they're following. And for those who are looking for the smoking pistol, I'm afraid they're not going to find it because the room is too full of smoke.
I've been much impressed by the debate and the comments of my colleagues on this committee. I think we've all benefited from it, and I would withdraw the motion to strike.
Under the rules of the House, the gentleman has a right to withdraw the motion to strike.
By unanimous consent.
Thank you, Mr. Chairman.
Chairman, on a point of parliamentary procedure, doesn't he need unanimous consent to do that?
I'd be pleased to answer that.
Do you?
The chair will respond. The chair will respond if the gentleman wants the chair to cite the rule, and the Rule 19 of the rules of the House. The gentleman who is operated under the House as a committee of the whole is entitled to withdraw the motion as a substitute amendment without even asking for unanimous consent. So the gentleman is perfectly in order. There being no further amendments before the desk, the gentlemen are now recognized, those who so wish, to speak under the 5-minute rule to the substitute amendment that was offered by the gentleman from Missouri, Mr. Hungate. Gentleman from Illinois is recognized for 5 minutes.
Mr. Chairman, if nobody wants to take the time for the general debate, I would move the previous question.
Mr. Chairman.
Well, that's what I'm asking. Well, no, I'm asking.
The gentleman
I withdraw
from...
mine.
The chair would like to state that under the rule adopted that every member has a right to the 5 minutes unless he declines to use it.
Mr. Chairman.
The gentleman from Missouri, Mr. Hungate.
Thank you, Chair. Mr. Chairman, the late President Truman was mentioned, along with the late Drew Pearson. Of course, Mr. Truman doesn't need any defense from me. He's been known to handle people who made attacks on him by saying some of them were prismatic prevaricators, liars any way you looked at them. But it's not appropriate, I think, to be critical of those who are deceased. And we do know that Mr. Truman opposed passing the buck. He was almost as opposed to passing the buck as Dick Nixon is good at it. On Mr. Truman's desk, there was a sign in the Oval Office that said, "The buck stops here." Now, we've had other criticism of other presidents who were deceased, President Johnson. We've had discussion of the Fifth Amendment. Now, I'm not going to tell you, I can tell you all about the Fifth Amendment and due process, but I think it's awfully hard to give due process to dead man. So I would hope that when the final record is written, we would strike any attempt to make attacks of that kind, and I would certainly say that I would resist any that might be made with regard to President Eisenhower. We were in the Army together. And I would only quote the words of our distinguished former colleague, Brooks Hayes of Arkansas, Mr. Thornton's state, who recounted the story of some boys in the Ozarks playing cards, and one of them looked over at the others and says, "Come on, boys, play the cards fair. I know what I dealt you." So, Mr. Chairman, I yield to my distinguished, learned
colleague from Indiana.
A friend from Missouri, I really didn't intend any criticism of President Truman, who happens to be a gentleman I admire myself. And if he did check into Drew Pearson, I would come close to thinking that that might almost have been justified.
I thank the gentleman for his comment, and I know that as a distinguished trial attorney, he would do nothing except what is proper. We've talked about people and agents and servants and employees, and I'd like to, in this brief time, talk some about Mr. Butterfield's testimony. I thought he was good. He was one of our better witnesses. He's not been indicted. Now, he said that in some of his testimony, after qualifying as to how much time he's sworn in the first day in the East Room, that's as early as you could get sworn in, and he's right up there next to the Oval Office. And he goes through some of this. Mr. Haldeman, in addition to being chief of the White House staff, was in charge of everything other than domestic international trade, congressional and national security. He was in charge of everything that had a personal connotation: speech writing, appointments, travel schedule, liaison with outside groups, political matters, personal matters, communications with the media. I could go on. This is the staff I knew best, the Haldeman staff. If a crunch matter came up, of course, they checked Haldeman. Larry Higbee was Bob Haldeman's alter ego. Larry Higbee was to Haldeman what Haldeman was to the president, working along with Higbee, but in not the major role Higbee held with Haldeman, where Gordon Strachan responsible, etc. Then he says he was responsible for keeping it tuned to the political happenings around the country and had a close liaison to the committee to re-elect. Then continuing in our testimony on page 29, the president, first of all, is well organized, always, and highly disciplined as an individual. The whole staff reflected that. The staff was a very, very well organized, firmly run staff. Mr. Dorr, could you give the committee an indication of the president's work habits with respect to attention to detail as you knew it, Mr. Butterfield? Yes, from my observations, having seen thousands and thousands of memoranda over this period of time, I may be using the figures loosely, hundreds and hundreds of memoranda, working directly with the President Haldeman, I know him to be a detail man. Then he goes on and says, the President often, of course, was concerned with whether or not the curtains were closed or open, the arrangement of state gifts, whether they should be on that side of the room or this side of the room, displayed on a weekly basis or a monthly or daily basis. Social functions were always reviewed with him. The scenario, after they came to me from Mrs. Nixon, each was always interested in the table arrangements. He debated whether we should have a U-shaped table or a round-shaped table. He was deeply involved in the entertainment business, whom we should get for what kind of group, small band, big band, black band, white band, jazz band, whatever. He was very interested in meals and how they were served and the time of the waiters, and was usually put out if a state dinner was not taken care of in less than an hour or an hour's time. He debated receiving lines, whether or not he should have a receiving line prior to the entertainment.
Time of the gentleman has expired. Did Mr. Dennis seek...
Chairman, I'll seek recognition. Sure.
Dennis?
Mr. Chairman and my colleagues on the committee, I think perhaps this article, if the proof were here, would be more important in many respects than Article 1 that we dealt with earlier. But the difficulty, as I see it, is that whereas on Article 1 you had a difficult matter of balancing proof and deciding where the weight lay and whether a case had been made beyond a reasonable type of a doubt, and I decided it had not been. But while you had that kind of a problem there, here where you might have the serious case if you had the evidence, you just don't really have the evidence. And I can't believe that we're going to impeach the President of the United States without the facts. Now, it's difficult to go over the same ground, but let's just look quickly at what we're talking about. First is the IRS. I was just talking about that a moment ago. The Japanese had a offense in the old days they called dangerous thinking. And maybe on the basis of the conversation of September 15th, you could convict somebody of
of constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, Richard M. Nixon, by such conduct, warrants impeachment and trial and removal from office.
The gentleman from California is recognized on point of order and will state his point of order.
Mr. Chairman, my point of order is that Article 2 fails to state an impeachable offense under the Constitution. May I be recognized on my point of order?
The gentleman is recognized.
Mr. Chairman and members of the committee, it's quite clear from a full reading of proposed Article 2 that the gravamen of that article is an abuse of power on the part of the President of the United States. That concept of abuse is stated in various places by use of the word misuse and in use of the words in derogation of constitutional rights as distinguished from in violation of those rights. The question, ladies and gentlemen, is whether an abuse of power falls within the meaning of the phrase high crimes and misdemeanors, since we can impeach on no other basis. If it does not, then my point of order should be sustained. If it does, then we should proceed with the consideration of that article. My problem, Mr. Chairman, is that I have no quarrel with abusive conduct when that conduct does in and of itself violate the law. If that be the case, then we should impeach because of those violations. I do have serious concern as to whether or not conduct which does not violate the law, but which may be characterized by this committee or the Congress as abusive, falls within the phrase high crimes and misdemeanors. It's apparent from the proposed article that its author believes that abusive conduct is impeachable. My problem is this: just what is abusive conduct? What does it mean? I suggest that that is an empty phrase, having meaning only in terms of what we pour into it. It must reflect our subjective views of impropriety as distinguished from the objective views enunciated by society in its laws. It ought to be clear to this committee, a committee of lawyers, that such a phrase as abuse of power, is sufficiently imprecise to meet the test required by the Fifth Amendment. In my view, Mr. Chairman, the adoption of such an article would embed in our constitutional history for the very first time, the principle that a president may be impeached because of the view of Congress that he has abused his powers, although he may have acted in violation of no law. If that is true, then we truly are ratifying the statement attributed to the now Vice President that impeachment means exactly what the Congress says it means at any given moment. By declaring punishable conduct which was not illegal when done, this Congress is raising the issue of a bill of attainder, contrary to the express terms of the Constitution. The argument of ex post facto legislation is now before us. If we are to declare punishable that conduct which is not illegal under our laws. In so doing, Mr. Chairman, we ought to recognize the momentous nature of such a decision, because we are taking a step toward a parliamentary system of government in this country rather than the constitutional system which we now have. We are in effect saying, Mr. Chairman, that a president may be impeached in the future if a Congress expresses no confidence in his conduct, not because he has violated the law, but rather because that Congress declares his conduct to be abusive in terms of their subjective notions of propriety. In terms of the future, Mr. Chairman, what standard are we setting for presidents in the future? How will any future president know precisely what Congress may declare to be abusive, especially when they have failed to legislate against the very acts which they may condemn? I think it's holding up to a future president an impossible standard that he must anticipate what Congress may declare to be abusive in the future. Under the law, Mr. Chairman, we have no right to impose our notions of morality and propriety upon others and make it their legal duty to comply therewith. But that's what we're doing when we say that a president may be impeached for abuses of his office when the acts of alleged abuse are not in themselves violation of the law. I have much more to say later with respect to the take care clause, but I'll reserve that until that is considered under separate subdivisions. Mr. Chairman, I believe my point of order is well taken and urge that it be sustained.
Point of order.
The gentleman from California is recognized in opposition to the point of order.
Mr. Chairman, I apologize to Mr. Hungate. I feel very deeply about this point of order, and I feel that I must speak in opposition. In my opinion, Mr. Chairman, this is probably, I'll make that stronger, it's certainly the most important article that this committee may pass out. The offense charged in this article is truly a high crime and misdemeanor within the purest meaning of those words as established in Anglo-American jurisprudence over a period of now some 600 years. The offenses charged against the President in this article are uniquely presidential offenses. No one else can commit them. You or I, the most lowly citizen, can obstruct justice. You or I, the most lowly citizen, can violate any of the statutes in our criminal code. But only the President can violate the oath of office of the President. Only the President can abuse the powers of the office of the President. When our founding fathers put our Constitution together, it was no accident that they separated the powers. Against the backdrop of 400 years of history of Anglo-Saxon jurisprudence, they had realized the need to have a device, a constitutional means of removing from office a chief magistrate who had violated his solemn oath of office. And I respectfully submit that the impeachment clause of our Constitution, which fortunately we've only had to use now for the second time, is that means. These are high crimes and misdemeanors, meaning that they are crimes or offenses against the very structure of the state, against the system of government, the system that has brought to the American people and has preserved for the American people the freedoms and liberties which we so cherish. This is uniquely a presidential offense, Mr. Chairman, and the most important thing that we have in this hearing. There are some, and I'd like to respond right now, there are some among us, there are many conscientious, dedicated Americans who harbor a feeling of fear and apprehension at this proceeding. They seem to, I submit that it's a sensitivity to the travail through which our republic is now passing. But they feel, they recognize, they sense that this is a serious, a most grave responsibility in proceeding, and some of them say that this should not be done because it might harm the presidency. Mr. Chairman, I submit that only the President can harm the presidency. No one but the President can destroy the presidency, and it is our function, acting under the impeachment clause, to preserve and protect the presidency as we preserve and protect every other part of our marvelous structure of government, and we do it through this process. Someone in the opening statement referred to this being a situation of we the people acting. We the people are acting through this procedure, through the wonderful provisions put into our Constitution. The American people, Mr. President, are entitled to and want a government which they can honor and respect, and they should have it. The American people, Mr. President, are eager to revere their president. They're entitled to a president whom they can revere. Mr. Chairman,
I ask, is not the violation of the solemn oath of office an impeachable offense? It is not found in our criminal code. It is implicit in our Constitution, but it's necessarily implicit in the Constitution. For otherwise, why would there be an oath of office? The offenses charged in this proposed article, I respectfully submit, Mr. Chairman, are offenses which go directly to that solemn breach of a solemn oath of office. Can anyone argue that if the President breaches his oath of office, he should not be removed? I say not, and I respectfully submit that this point of order should be denied.
The chair has heard arguments for the point of order and in opposition to the point of order, and the chair has prepared the rule. The chair makes reference, first of all, to Article 1, Section 2 of the Constitution, which gives to the House the sole power of impeachment, and in Article 2, Section 4, the declaration that impeachment shall lie for treason, bribery, and other high crimes and misdemeanors. So the issue of impeachment and the nature of an impeachable offense is, as the gentleman knows, the very nature and subject of these proceedings. And no point of order can possibly lie in the nature of a challenge as to the impeachability of such offenses. That is a matter, as the Constitution has already clearly stated, for the committee which has been delegated with this responsibility by the House itself, and ultimately the Senate to decide. The gentleman will be given full opportunity to debate this question and attempt to persuade his colleagues that no grounds for impeachment have been stated in the articles. But the issue does not state a point of order. Rather, the issue presented in the point of order is a constitutional argument that must persuade the Congress. And therefore, the chair rules against the point of order.
Mr. Chairman.
The gentleman from Missouri.
Mr. Chairman, before going further, I should like to ask unanimous consent that debate on any amendment to the substitute, including amendments in the nature of a motion to strike, be limited to a period not to exceed 40 minutes, to be divided equally between the proponents and opponents of the amendment.
Without objection, it is so ordered.
Mr.
Gentleman
Chairman
is recognized.
Thank the Chairman. And I thank the distinguished gentleman from California, both distinguished gentlemen from California, for drawing the issues and the problems before us in a skillful way as they have done throughout this proceeding. Mr. Truman once said that, or asked people if they knew what it was like to have a load of hay fall on them, and I think this morning I know what he meant. So all I can explain is that sometimes when you practice law, you'd find that the best cases didn't come in through the most ideal clients, and that's our problem today. I apologize to my colleagues for the lateness with which they received my substitute, but I know all of them to be distinguished and able attorneys and conversant with the facts and problems before us here. And I should make it clear that the Hungate substitute is really a distillation of the thought of many members from many areas and of differing political philosophies, and the input of many of the capable members of this committee, for which I only seek to be a catalyst. It would be rather difficult, if impossible for me, in 5 minutes to explain all the points that should be and will be considered and debated here. Various of my colleagues I know are learned on the various subparagraphs 1 through 5, and will outline this in more detail in our debate. I believe the gentleman from California, Mr. Wiggins, touched some elements that are correct in that basically, as I see it, Article 1 involves obstruction of justice, standards of conduct that may be criminal, and basically, perhaps, what we have today involves abuse of powers, and whether we shall say that you can be president as long as you're not subject to a criminal charge, whether that's the level of conduct we require, or whether we shall set a somewhat higher standard, and whether we shall set that standard so that we will realize that the oath of office of the presidency means what it meant to Madison and the founders before the Constitution was even completed. Now, some would believe that if we find any one of these 5 subparagraphs would support impeachment. And I think more would believe that a combination of one or more, or all of them, would support impeachment. Because we do discuss, I think, and consider repeated violations. In many cases, repetitive conduct within the article, and certainly repetitive conduct within the subparagraph, and certainly repetitive conduct throughout the 5 articles. I would think that if only one instance of improper conduct, and it perhaps could be quite serious, I don't know that we would be here today. I think this sort of impeachment trial was deliberately set up historically so that those who are in political life and political figures try the president, a political figure, those who can understand some of the pressures and nuances involved in serving in a public position. And for my part, I think there's more tolerance in such a political body than one would find in just a body without the experience, as I've said, of the pressures and difficulties in public life. And I say again, if only one violation had occurred, I doubt that we should be here. Men are human, humans are frail, but I think we discuss and consider here and see here a consistent disregard of the law. To give an example that's not worthy of the problem before us, I think if a man is driving his car and he crosses the center line, that's not grounds for a whole lot of punishment, taking his license or thoroughly incarcerating him. But if he crosses the center line 15 times every mile he drives, or if he insists on straddling the center line all the time, then I think we find action has to be taken. So I think, thank you, Chairman.
Time of the gentleman from Missouri has expired. I recognize the gentleman from Michigan.
Thank you, Mr. Chairman. The proposed article of impeachment now being debated charges that the President has violated his oath of office and his constitutional duty to take care that the laws be faithfully executed. It charges that he has done so by repeatedly engaging in unconstitutional and illegal conduct. The wording of proposed Article 2 raises a number of serious questions which I hope will be addressed by its proponents during the course of this debate. While I strenuously dispute, as a matter of fact, that the evidence establishes that the President has repeatedly engaged in unconstitutional and unlawful conduct, I am curious as to what the drafters of this article perceive to be the legal significance of the allegation that such acts have been done repeatedly. What is the gravamen of the offense charged in this article? The supposed repetition of misconduct, or the specific instances of it which are alleged? Would any of these individual allegations standing alone support an article of impeachment? Or do they only amount to impeachable conduct when considered in the aggregate? If some would stand alone and others could not, tell us which is which. How many of these allegations must the member believe to be supported by the evidence before he would be justified in voting for the entire article? Even if each and every allegation were proved true, is it fair or is it grossly misleading to say that the President has violated his oath repeatedly? Repeatedly means again and again. Surely this does not mean isolated or even sporadic failures of duty. It can only connote a regular, persistent course of conduct, warranting a belief that the alleged instances of lawlessness are characteristic and not exceptional. Is it really fair? Does it depict the whole truth to examine the entire record of this administration during the past 5.5 years, to examine the totality of countless tens of thousands of official actions taken by the President personally, by members of his White House staff, and by other subordinate officials of the executive branch of the government, and to cull from that huge mass of official action this relative handful of specific allegations, and to derive from them the proposition that the President's conduct has been repeatedly unlawful? Consider, for example, the question of wiretaps. I do not acknowledge that these wiretaps were unjustified or under all the circumstances illegal as the law existed at the time they took place. But even if some were, which I do not concede, in all fairness can it be said that those few wiretaps, most of which were instituted in two groups, spread over a 1-year period, and the last of which terminated in February 1971, furnish evidence of repeated violation of the Constitution. As in the case of the evidence relating to the Plumbers operation, they show a specific presidential response to a specific and serious problem, namely the public disclosure by leaks of highly sensitive information bearing upon the conduct of American foreign policy during that very turbulent period, both domestically and internationally. What effort has our staff made to bring before this committee a coherent, comprehensive reconstruction of the climate and the circumstances of the 1969 through 1971 period in which those wiretaps occurred? We've heard no eloquence to stir our memories as to the violence and the disorder and the war which nearly had this nation on its knees at the time that Richard Nixon took office. The President's prosecutors would have us view the actions in which they complain in the abstract, ripped from the very context of the events which precipitated them, giving not even lip service to the serious governmental problems which they were designed, even if designed clumsily, to cope. Mr. Chairman, I will vote against this ill-conceived article of impeachment.
Time of the gentleman from Michigan has expired. The gentleman from California seeking recognition.
Mr. Chairman, is the article now having been read open for amendment at any point?
The article is open for amendment at any point.
I'm prepared to offer an amendment, but if we're going to have, in effect, general debate on the article, I'll withhold.
If the gentleman will defer.
Surely.
Thank you.
Mr. McCory?
I would like to be recognized at this point to discuss generally this proposed article of impeachment. It seems to me that this really gets at the crux of our responsibility here. It directs our attention directly to the President's constitutional oath and his constitutional obligation. There is nothing mysterious about this, and there's nothing evil or malicious about it. It directs its attention directly to this responsibility that is and has been reposed in the President. This is certainly no bill of attainder. We're not thinking up an offense and then charging the President with the violation of it. We are calling the President's attention to the fact that he took an oath of office and that he had in his oath of office a solemn obligation to see to the faithful execution of the laws. This is quite different and distinct from the elements of criminality that are involved in Article 1, charging the President with a conspiracy and all kinds of
criminal acts of misconduct and obstruction of justice and so on. An article which I did not support because I don't believe the facts support that kind of charge. Now, some of those who have expressed themselves in support of Article 1, the conspiracy and cover-up theory, have included feelings of deep hostility and bitterness and political bias. In my support of Article 2, based upon the Take Care Clause of the Constitution, which specifies a solemn obligation of the President to take care to see to the faithful execution of the laws, I want to make perfectly clear that I harbor no malice, I attribute no evil thoughts or conduct to the President of the United States, I express no bitterness, no hostility. What I do want to make clear is that the President is bound by his solemn oath of office to preserve, protect, and defend the Constitution, and to take care to see that the laws are faithfully executed. While many of the paragraphs contained in Article 2 may appear similar to those found in Article 1, which I opposed, it's important to note carefully that the pattern of conduct which is delineated in Article 1 is quite distinguishable from that in Article 2. For one thing, I would point out there's no clear proof of conspiracy in the fact that others surrounding the President have been found guilty of acts of gross misconduct. However, there's a clear violation of the President's responsibility when he permits multiple acts of wrongdoing by large numbers of those who surround him in positions of greatest responsibility and influence in the White House, the establishment of the plumbers, and many of the activities attributed to them are wholly unrelated to Watergate, and that's the same case with respect to his misuse of the FBI and the CIA and the IRS. Nothing to do with Watergate for the most part. But these are clear acts of misconduct which it seems important for us to take note of. In other words, the acts and conduct upon which I feel an article of impeachment should be presented to our colleagues is strictly constitutional, relates narrowly and directly to the President himself and his personal oath of office. While this article may seem less dramatic and less sensational than the Watergate break-in and cover-up, it's nevertheless positive and responsible, and a positive and responsible approach on our part as investigators of misconduct. One purpose of the impeachment process, it seems to me, is to set a constitutional standard for persons occupying the office of President. Thus, if we approach our task in constitutional terms, we will be setting such a standard. I view the duty of the House of Representatives as something other than serving as a district courthouse to hold the President accountable for statutory statutory violation of criminal law. I think we can agree that the President should not commit crimes. But if we are to set a constitutional standard, we must take a different view of the facts. We must phrase our charges in constitutional terms so that presidents to come may know what is meant by our action. If we are to establish our proceeding as a guide for future presidents, we should speak in terms of the Constitution, and specifically in terms of the President's oath and his obligation under the Constitution. It will be of limited value to admonish future presidents not to obstruct justice or engage in a cover-up. However, it will aid future presidents to know that this Congress, this House Judiciary Committee, will hold them to their oaths of office and their obligation to take care to see to the faithful execution of the laws. I realize there's no nice way to impeach a president of the United States. I realize also that the distinction between criminal conspirator theory, the criminal conspirator theory in Article 1, and the purely constitutional aspects of Article 2 may be misunderstood. But as a member of this committee, the most I can do is to exercise my independent judgment and to search deeply my conscience. Both reason and wisdom dictate the judgment I'm going to make in supporting this Article 2 is right. Thank you, Mr. Chairman.
The time of the gentleman has expired. Under the rules of Jefferson's manuals and the rules of the House, the chair is constrained to state that perfecting amendments take precedence, and the chair did state this. The members, however, who would want to speak on the substitute will have their time reserved for them. I'm going to recognize at this time those members who wish to offer perfecting amendments. And I recognize the gentleman from California, Mr. Wiggins.
Thank you, Mr. Chairman. I have an amendment at the desk. I ask unanimous consent, Mr. Chairman, that my amendment be deemed to apply to the language in subparagraph 1 and 3, because those are exactly the same words, and as you know, that new language was read in as an addition here just a few moments ago. Does Mr. Hungate understand my point, since it's his substitute?
Mr. Hungate.
Be exactly the same, and
I have no objection, Mr. Wiggins.
So the chair would understand that if the amendment were disposed of, it would be disposed of
as to both.
As to one and three.
Certainly. I'd like to do it all at one time.
The clerk will read the amendment.
Amendment by Mr. Wiggins. In subparagraph 1, after the word has, strike the words acting personally and through his subordinates and agents, and add the following: personally and through his subordinates and agents, acting with his knowledge or pursuant to his instructions.
The gentleman from California is recognized.
Thank you, Mr. Chairman. I believe my intent is evident from the words used, and I'm merely trying to avoid any possible ambiguity created by the language which is now in subparagraph 1 and subparagraph 3. Going back to the introductory words in Article 2, it states, in essence, Richard Nixon has repeatedly engaged in conduct, etc. It makes it clear that we're talking about Richard Nixon's acts. And yet when we move to subparagraph 1, we deviate from that standard and we say, as presently proposed, that he acted personally and through his subordinates and agents. I have no quarrel with impeaching President Nixon by reason of the acts of his subordinates and agents, so long as we know that we are talking about those acts of his subordinates and agents which were done with his knowledge or pursuant to his instructions. And we are not seeking to impeach the President vicariously by reason of acts of others about which he had no knowledge and contrary, perhaps, to his instructions. I have every reason to expect, although I haven't asked my friend, the gentleman from Illinois, to support such an amendment, because this is, in essence, what he was talking about yesterday, that he was willing to impeach the President by reason of his personal misconduct, but was not willing to impute vicariously the acts of others. My amendment to subparagraph 1 and subparagraph 3 is to make this concept abundantly clear, and I urge its acceptance. Of course so. I'll yield.
Mr. Chairman?
I've yielded to the gentleman.
The gentleman still has time. Mr. Cohen.
The yielding. Mr. Wiggins, under your proposal that would make it personally through his subordinates and agents acting with his knowledge or pursuant to his instructions, would that also cover such situations where agents may have acted without the President's personal knowledge in advance, but such acts were thereafter ratified or condoned by the President?
Yes, I would not necessarily exclude that. I realize that a President must of necessity act through subordinates, and that the acts of subordinates may not be personally known to the President. But so long as those acts are pursuant to his instructions, or perhaps policy, to use a word that's been used around here, or ratified and condoned by him as his acts, then I have no objection to attributing them to the President.
So if he acquired knowledge thereafter and ratified, in effect, the prior acts, that would be within the scope of your amendment. Thank you.
Well, I'll submit that question.
And yield to me?
If I have time, I'll yield first to the gentleman from Illinois.
The gentleman from California knows that pursuant to the rule that we have adopted, those supporting his amendment and speaking in support of it will have 20 minutes in entirety. And
well, I think then I'd best reserve whatever time I have and permit others to speak, Mr. Chairman. Well, now, Mr. Chairman, am I, in effect, foregoing the balance of my time if I reserve? It's not my understanding that I personally have 20 minutes.
No, you personally do not have 20 minutes, but those in support of your amendment have 20 minutes. And therefore,
if I've used up my time, of course, I'm out of time and others can speak.
The gentleman still has 1.5 minutes.
I'll yield to the gentleman from Illinois.
Gentleman from Illinois.
I thank the gentleman for yielding. I have only the same questions that were raised by the gentleman from Maine. What worries me about this, the president in some cases perhaps had knowledge, not initially perhaps, but learned of improper activities and saw fit to either condone or acquiesce in such activities. And what I'm wondering is, if it is the intent of his amendment, again, let's make it very clear. Is the intent of your amendment to rule out that kind of what I believe is serious misconduct?
It's not my intent to rule it out, but I don't wish to say that I embrace it. I let, as you said yesterday, let the words speak for themselves.
Would the gentleman yield?
Of course, if I have time.
I'd like to ask the gentleman if his amendment would cover a situation such as we had testimony on, that the president would give instructions sometimes saying, now I want you to get this done, but I don't care how you do it. Don't bother me with the details. Would that be sufficient to cover the instructions under the gentleman's amendment?
Well, I think the instructions are subject to interpretation. I know the incident to which the gentleman refers, and I could not concede that the president was by that instruction authorizing the doing of an illegal act. So long as the act is consistent with a reasonable interpretation of his policy and direction, I have no quarrel with attributing that conduct to the president.
Well, wouldn't that...
California is
Mr. Chairman.
fired. I recognize the gentleman from Texas.
I oppose the gentleman's motion. The specific acts included within the scope of this section involve an awesome array of impeachable offenses against the United States Constitution and the American people. The evidence that we've gathered clearly establishes that Richard M. Nixon and his agents sought and obtained confidential tax information from the Internal Revenue Service in a manner unauthorized by law and for unlawful purposes. Specifically, he and his subordinates made repeated attempts to influence the selection of citizens to be targeted for audit and other special action by the Internal Revenue Service. In a sworn affidavit to this committee, Johnny Walters, former IRS commissioner, stated that in the summer of 1972, John Ehrlichman requested the IRS to check out the income tax returns of Democratic National Committee Chairman Lawrence O'Brien. The IRS checked O'Brien's returns and conveyed the relevant information to Ehrlichman through then Secretary of the Treasury Schultz. Ehrlichman was not satisfied, and because of his demands, O'Brien was interviewed on August the 17th, 1972. The IRS furnished a copy of the O'Brien conference report to Secretary Schultz. A short time later, Schultz informed Walters that Ehrlichman was still not satisfied. Walters told Schultz that there was nothing else the IRS could do. On August the 29th, 72, in a joint telephone call to Ehrlichman by Secretary Schultz, Walters and his assistant, IRS Commissioner Roger Barth, Ehrlichman was told that O'Brien's returns were closed, that there was nothing further for IRS to do. Ehrlichman then told Walters, and I wanted them to turn up something and send him to jail before the election, and unfortunately, it didn't materialize. Ehrlichman told Walters, and I would repeat that's the right quote. I turned to the wrong page. What Ehrlichman said on page 235 was, indicating disappointment, and he said to me, quote, I'm goddamn tired of your foot-dragging tactics. And then, when Ehrlichman was so interested in the IRS status of O'Brien's operation, in testimony before the Watergate Committee, Ehrlichman arrogantly stated the reason that I previously stated. He wanted something turned up before the election. Unfortunately, it didn't materialize. On September the 11th of 72, John Dean gave Walters a list of the Democratic presidential nominee staff members and campaign contributors, instructing the IRS to begin investigations or examinations of the people named on the list. Walters testified that he advised Dean that compliance with the request would be disastrous for the IRS and for the administration, and that he would recommend to Schultz that the IRS do nothing with the request. 4 days later, H.R. Haldeman and Mr. Nixon met and discussed, among other things, Dean's working through the IRS. Our transcript of the September the 5th meeting had the following exchange. Haldeman, between times he's moving ruthlessly on the investigation of McGovern people, Kennedy stuff, and all that too. I just don't know how much progress he's making because I'm president. The problem is that's kind of hard to find. Haldeman, Chuck has gone through, has worked on the list, and Dean's working the thing through IRS and, in some cases, I think some other unintelligible things. He's turned out to be tougher than I thought he would, which is what, Mr. President? Yeah. Now, later, Dean joined the President and Haldeman and continued their meetings. We have not received a tape recording of this portion of the conversation, but Dean testified that at that meeting there was a discussion of the unwillingness of the IRS to follow up on the White House directives. In his testimony, the following exchange took place between Mr. Dorr and Mr. Dean. Mr. Dorr, did you discuss your assignment with respect to the IRS with the President during your meeting on September 15th? Mr. Dean, I'm not sure how directly or specifically it came up, but there was, indeed, a rather extended discussion with the President on the use of IRS. He made some rather specific comments to me, which in turn resulted in me going back to Mr. Walters again. Mr. Dorr, when you say the use of IRS, what are you talking about? Mr. Dean, well, as I recall the conversations, we were talking about the problems of having IRS conduct audits. And I told him that we hadn't been very successful at this because Mr. Walters had told me that he just didn't want to do it. I did not push him. As far as I was concerned, I was off the hook. I had done what I'd been asked. I related this to the President. And he said, may I conclude this paragraph? And he said something to the effect, well, if Schultz thinks he's been put over there to be some sort of candy ass, he is mistaken. And if you have got any problems, you just come tell me, and I'll get it straightened out.
Time of the gentleman has expired, Mr. Chairman.
In a moment, Republican David Dennis will take up the opposing arguments. INPAC's videotape coverage of the House Judiciary Committee's impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service.
Can you hear it? Sure you can. Sound familiar? Sure it does. Feel that tingle? Oh, tingles are good, especially Tingles Revisited. Here it comes, the great American Dream Machine. Re-originals of your favorites, as crisp and crunchy as the day they first came down the pike. I'm Marshall Efron, inviting you to hook up to the great American Dream Machine. It'll make you feel good. The Great American Dream Machine.
award-winning films from the Washington National Student Film Festival, as judged by Nicholas Ray and Stan Vanderbeek.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
As we go back to the hearings, the congressmen are debating an amendment which would add words saying the president was aware of the misdeeds of his aides.
Chairman, the gentleman from Indiana is recognized in support of the amendment.
Correct, Mr. Chairman.
The gentleman is recognized for 5 minutes.
Mr. Chairman and my colleagues, I think this amendment is a very important one which we all ought to give careful consideration. Actually, it would be my belief, and certainly my hope, that this is what the Hungate substitute means, even as unamended, because when you say acting personally and through your subordinates and agents, surely that means through actions of theirs which you have ordered or of which you have approved under normal principles of law in any kind of a criminal or quasi-criminal situation such as we have here.
Could the gentleman yield briefly?
I'd appreciate it. I'd like to yield to my friend, Mr. Hungate, and I will if it's very brief.
I believe the gentleman correctly states the intention, the gentleman from Indiana correctly states the intention of the drafting of the Hungate substitute at that point, and really my argument would be that the amendment is superfluous for that reason. The gentleman, I agree, I think, with his argument.
Well, I'm very glad to know that that is what the gentleman means, and knowing the gentleman's capacity as a distinguished lawyer, I felt confident that that is what he meant. But that being what he meant, in other words, that it does have to be with the knowledge or pursuant to the instruction of the principal, there can be no harm in writing that in, and I think it's extremely important that we do so. For one thing, if we vote such an amendment down, which the author of the original amendment agrees means what I say it means, it then seems to indicate that the majority of the committee thinks it means something else. And for another thing, it's quite important that this principle be nailed down here, because as you go through this and listen to the argument, you hear an awful lot about Haldeman, you hear an awful lot about Ehrlichman. Very rarely do you hear the mention of the president, and it's important that we keep in mind that there's got to be a connection, that he's the man we're going to impeach, if anyone. Now, this is just a matter of ordinary fairness. We all have staffs of our own, not nearly as large as the President of the United States, but I think every one of us has had enough experience to know that people on your staff can get you into some very, very embarrassing situations sometimes. And things which you knew nothing about, didn't authorize, didn't want them to do, and to be held responsible. Therefore, this is just an illustrative thing, but one which could come home because it's kind of familiar. Now, I would say, of course, ratification, sure, that's ordinary law. If the agent went out and did something improper, and I said, well, fine, that's great, I'm all for it, and approved it, ratified it afterwards, in my judgment, that's ordinary Hornbuck law, too. But otherwise, you've got to have an instruction to the man, you've got to have knowledge of what he's doing, or you've got to approve it and ratify it after he's done it. And as Mr. Hungate and I agree, that's really all we're saying here. We're just making crystal clear what he and I agree is already reasonably clear. And under the factual circumstances here, and under the frequency with which we hear testimony about other individuals, and the infrequency with which we hear anything about the President, and the importance of not forgetting the necessity and the importance of the connection, I think in simple fairness, this is a reasonable and important amendment, and I hope it will be adopted.
Would the gentleman yield, please?
Briefly yield to my friend from Missouri.
I think I've misled him, perhaps, and I would not do so.
Well, I wouldn't want you to do that.
To the extent of our agreement, certainly ratification is within our agreement, but I would understand that presidents act through subordinates, and I'm not talking about the rural mail carrier, I'm talking about Haldeman, Ehrlichman, Mitchell, and Dean, and I think the language in the original substitute speaks for itself, and I just point out I think there is an area of agreement, but I believe I understood my friend to say that he agreed with the language acting with his knowledge or pursuant to his instructions. I hope he did, but if he doesn't agree with that, then the amendment becomes tremendously important. We've just got to have it. I want to be. I could not agree with that language. I regret to inform you.
Well, if the gentleman doesn't agree with it, then we're in a situation where it is going to be suggested that the president can be impeached for actions of his subordinates who were acting without his knowledge, not pursuant to, even against his instructions, I would assume, and without any ratification thereafter. And really and truly, I wonder, seriously, whether the majority of the committee, which has already indicated it wants to bring articles of impeachment, wants to take that line. That is not, I think, even in accordance with the Constitution of the United States. I would caution the gentleman not to do that.
The time of the gentleman from Indiana has expired.
Mr. Chairman.
McClory.
Mr. Chairman, I'd like to speak briefly in opposition to the amendment.
Gentlemen,
I do want to say that I did have the privilege of taking a small part in the drafting of this proposed article, and I think it's a good article the way it's drafted at the present time. I interpret this article as that which embodies the take care clause of the Constitution, and I'd just like to read just one line from this volume, which is made available to members of the Congress interpreting the Constitution. And with regard to the take care clause, the volume reads as follows. Quote, the Constitution does not say that the President shall execute the laws, but that he shall take care that the laws be faithfully executed. That is, by others, who are commonly, but not always, with strict accuracy, termed his subordinates. End of quote. In other words, what we are charging here is that the President has a responsibility to see to the faithful execution of the laws. We're not charging that he's gone out and personally committed some criminal act, but we are saying that there are 20-some persons who are either charged or convicted or serving time or have already completed their service of time, being engaged in criminal conduct in and around the White House, some of his top aides. And I think that this is involved here. The President can only act through his agents and subordinates, but is he tolerating and has he tolerated this kind of conduct in the White House and in and around him? Well, it seems to me that that's the charge we're making, and I think that to erode this charge in any way would be a mistake. And I think that the article is adequate the way it is, and I hope that it will. The amendment will be rejected. Well, I yield back the balance of my time, and you're perfectly free to get time from the chairman if you want to speak in. On the amendment.
I recognize the gentleman from California, Mr. Daniels.
Mr. Chairman, I, too, oppose the amendment offered by my colleague, Mr. Wiggins. I respectfully submit that if this amendment were put into the articles, it would unduly and
unnecessarily limit and restrict the proof which the managers will at some time be compelled to make before the Senate. I concede that the managers must prove each and every charge before it can serve as a basis for an impeachment, but they should not be unreasonably and unrealistically limited in that proof. The wording of this proposed amendment would require that there be proof that the President in each and every instance knew in advance of the precise act that was going to be carried out by his agents and subordinates. I respectfully submit that that's unrealistic. Let's look at, for example, Mr. Segretti. Do you suppose, is it reasonable to suppose that if Mr. Segretti, if we were to prove that he was authorized by the President to commit these dirty tricks, do you suppose that he picked up the phone every time just before he did one of them and called the President and said, Mr. President, I am now about to order 400 pizzas for Mr. Muskie's fundraiser? That's unrealistic, and yet the language of Mr. Wiggins' amendment would require that type of prior action by the President in each and every instance. I respectfully submit that the managers before the Senate must prove each and every charge against the President, but this must be done in the context of the real world. If they should prove that the President knowingly and intentionally set one of these forces in motion, then the President is responsible for the natural and probable consequences of having set that force in motion. I mentioned Segretti's dirty tricks. This goes to many other things. Let's take a look at the Watergate burglary. Someone mentioned properly the other day that it was improbable that the burglars called the President down in Key Biscayne and said, I believe it was my colleague, Mr. Rangel, Mr. President, we're about to make a hit. Of course they didn't. But if it can be shown that he set this force in motion and that the activities of the perpetrators were the natural and probable culmination of the force he set in motion, then I submit that he's responsible. You know, we hold the President to a higher standard of conduct than that of the marketplace. He is the person who is to set the moral and ethical standard of the nation, of the entire republic. I submit that Mr. Wiggins' amendment would unduly and unnecessarily restrict proof, and for that reason it should be defeated. I yield to Father Drinan.
Thank you very much for yielding. And I'd like to raise a basic question as to the authorization that is in the proposed amendment by quoting the President himself. Just before the establishment of the plumbers, the President, speaking to Mr. Haldeman and Mr. Colson, according to Mr. Colson's affidavit in the Ehrlichman case, said this. The President said, I want these leaks to be stopped. I don't want to be told why it can't be done. I don't want excuses. I want results. I want it done, whatever the cost. I have difficulty in accepting the proposed amendment in view of this type of blanket authorization. I yield back to the gentleman.
Mr. Chairman, I would like to add one more point. Of course, I don't believe, and I don't think any other member believes, that the President should be held responsible for the acts of his subordinates under a general doctrine of respondeat superior, which simply says that he's liable for whatever his agents do within the scope of their general authority. But where the President has failed to take the actions to make sure that his agents have stayed within the scope of their legitimate authority, and furthermore, as the Father Drinan has indicated, has told them, I don't care how you do it, just get it done, implying that he didn't care about the niceties of the law or anything else, why we have a totally different situation, and yet the amendment proposed would not take into account that type of situation.
I should like to conclude by stating, Mr. Chairman, that if the President sets forth a general policy or a general instruction, and pursuant thereto his aides misuse the President's power, then the President alone can be held to account.
Time of the gentleman has expired. The Chair would like to observe that the proponents of the amendment have consumed 10 minutes, and those in opposition have consumed 12 minutes, and the gentleman from New Jersey. Mr. Sandman is recognized in opposition to the amendment.
Oh, no. I want to be recognized in support of the amendment, sir. Now, it wouldn't be truthful.
The gentleman is recognized.
It wouldn't be truthful for me to say I'm surprised because so many things have happened here that would surprise anybody. So I guess we're following a normal course. But isn't this really the crux of what it's all about? The gentleman from California, truthfully, adds only 2 words. That's all he adds. For him to be responsible so that he can be removed from office, my colleague from California says he either has to have knowledge of the wrongdoing before it happens, or he has to be the person directing that the wrong be committed. Now, maybe we're making new laws for presidents. And I want to say to my colleagues on the other side, someday you may have a Democrat president. And you want him to live up to all these kind of new laws that you're making? We heard yesterday that the Fifth Amendment and due process has become outmoded. You want that to apply to your president like you're trying to apply it to this one? You want all of these things to be done the hard way. Now, let's go through just a couple of things. And I'm not going to prolong the argument on specificity, that long word. But isn't this why you won't agree to that particular thing? Which one of these abuses are you going to attempt to prove? Which one of them? And now we understand that the gentleman from California, Mr. Danielson, he says it's all right even if you can show that the president didn't know about it or that he didn't direct it. No other human being can be held responsible for the acts of his agent in any kind of a criminal conviction unless he has one or the other of those conditions present. When I'm through, I will if I have some time. Now, I've asked that we make a simple sentence out of each charge. The opposition have danced around that request now for several days. Now, this, I think, points to precisely why you won't do it. Through some mistake, I suppose, I got some of the arguments that the staff gave fellows on that side to use. But one of these things starts out with early 1970. Haldeman directed Molenkopf, it's my time. That doesn't say the president did, it says Haldeman does. That was in 1970. The next thing that you have here on page 2, John Caulfield, a member of Dean's staff, he did something at the request of Haldeman. It doesn't say at the request of the president. Now, are you talking about the incident of March 13th? We're entitled to know. Because if that's the one you're concerned about, you're not going to have much of a case. Then you've got another one here. In the spring of 72, Ehrlichman wanted some information on O'Brien, but there's nothing in the info in front of me here that was handed to you by the staff that involves the president. Another time, Ehrlichman told, not yet, Ehrlichman told Schultz. It doesn't say the president told Schultz. And then we get down to Ehrlichman told Kalmbach. The president didn't tell Kalmbach. Ehrlichman told Kalmbach. And this is another date, September 72. Is that the one you're going to rely on? We should know. Now, in addition to that, the biggest one of all that you're relying upon, apparently, is the conversation of September 15, 1972, where if you listen to that tape, there is no question that the president is extremely disturbed on what Dean is telling him, and it is there that he explodes about Schultz. And these are ugly words taken by themselves. They're terrible. But the important thing about that conversation, September the 15th, 1972, there is no proof that's been presented by this committee or any other committee that shows that the president followed that up by talking to Schultz or anyone else. And in addition to that, why don't we for the first time admit that not a single audit was made on a single soul on that list? This, I think, is important. This, again, is why you won't agree on specifics. You will not nail down that one date, that one act. And now, lo and behold, you're taking away the right of requiring that the president have knowledge of the wrongdoing or that he directed. You're entirely wrong, and you know it. This should be adopted.
Time of the gentleman has expired. Recognize the gentleman from Maine.
Chairman. Just indicated that the motion of Mr. Wiggins adds just two things, but he failed to state, I think, that it omits one very important thing, and that is the question of ratification. And I noticed the gentleman from California was rather reticent about expressing this word ratification in his proposed amendment. Now, there are two major areas which are of concern to me in this subject of abuse of agencies under the Internal Revenue Service and the FBI. Now, for example, we do have direct evidence before this committee, taken before this committee by Mr. John Dean, that on September 11th he did have a conversation with the director of the Internal Revenue Service, during which time he presented a list of political enemies for the purpose of having those enemies audited. Now, there is no evidence before this committee, in my opinion, that would justify saying the president knew in advance of Mr. Dean's activities. However, on September 15, the conversation to which Mr. Sandman just referred to, we do have direct evidence that the president was indeed interested in having this matter pursued. Mr. Sandman forgot to indicate that, or failed to point out, I should say, that we were missing 17 minutes of this September 15 tape, which was not presented to the committee, which we have subpoenaed. This is the alleged portion of the tape, according to Mr. Dean, whereby the president directed Dean to go back and see George Shultz, and if he didn't get cooperation, to let him know. Now, the question is Dean credible? Well, we have direct evidence from the Internal Revenue Commissioner, who testified before the Senate Select Committee, that indeed Dean did come back to him on September 26th, just several days thereafter his conversation with the president, presenting a reduced list, again asking for the audits. Now, I suggest and submit to this committee that the president's activity on September 15 would indeed constitute a ratification of the prior acts, which would make him responsible for such activity. With respect to the FBI abuse, I'm referring specifically to the investigation of Daniel Shore. If there is evidence before this committee that Daniel Shore did criticize one of the president's speeches, and that while aboard Air Force One, Mr. Higbee, Mr. Haldeman, asked the FBI to conduct an investigation. Again, we have no evidence before us to say that the president knew that they had called while aboard Air Force One to ask for that investigation. But we do have direct evidence before the committee taken from the lips of Mr. Colson. And Mr. Colson told this committee that once that FBI investigation was exposed to the press, that he then came to the president and said, we've got a problem here, we're in a jam, what do you think about sending out a statement that indicates that Mr. Shore was being investigated because we're considering him as a consultant to the White House, to which the president approved. I would submit to this committee that that in turn would constitute a ratification of the prior activities on behalf of the FBI, which I think were an abuse. And for those reasons, I cannot, without express wording in the motion offered by Mr. Wiggins, support that without the word ratification. And I yield to the gentleman from Virginia, Mr. Butler.
I thank the gentleman from Maine. Just take one moment, but I feel like that we ought to complete what was said by the gentleman from Texas, Mr. Brooks, with reference to the O'Brien investigation, and point out that there is among the evidence which is brought to our attention the affidavit of Mr. Thompson with reference to the conversations with Mr. Fred Bussart on behalf of the White House, in which he advised that on September the 15th, 1972, Dean reported on the IRS investigation of Larry O'Brien. There would be some question in my mind under this amendment as to whether that would in fact be relevant and admissible, but under the proposed amendment substitute by Mr. Hungate, I'm quite satisfied that it would. In my judgment, the proposal by Mr. Wiggins expressly excludes the opportunity for ratification and evidence of ratification, and I think that's very significant. The time is not mine, I say to the gentleman from California.
Yes, it's not my intention as the maker of the motion to exclude the concept of ratification. That is not my intention. My words were only intended to convey to the gentleman that I did not accept the view that the facts constituted a ratification, but that the issue of ratification is still before us in terms of my language.
I thank the gentleman for yielding. I agree with my colleagues who say that we cannot impeach the president for the wrongdoing of his aides. I've said so myself. I think there's a very strong case of personal culpability on his part. As Mr. Cohen has indicated, a number of them, I'll, in the short time remaining, try to hit some of them myself. We have his words on record. But one of the strongest things of personal involvement to me is when the Department of Justice files briefs in the Ellsberg case and says there's no record that any wiretaps or any overheard conversations of Ellsberg. The reason they file those briefs is because it was not in the files of the FBI. And why wasn't it in the files of the FBI? Because the Assistant Attorney General Mardian flew to San Clemente and personally discussed the matter with the President, not his aides, personally with the President. And he said, what shall I do with these records? And the President said, deliver them all to the White House. And Mr. Mardian testified that he delivered them to the Oval Office. When he said, well, to whom did you give them? He said, I'd rather not say. Well, who sits in the Oval Office except the President? And then they were given to Ehrlichman, and Ehrlichman kept them in his files outside of the records of the Department of Justice. This is one of the reasons the Ellsberg case was dismissed, which I think was a calamity. In February '73, when Time magazine came out with a story about a White House wiretap program, the President personally approved the cover story, as he did in the Daniel Shore case, that there was no such wiretap program. May I continue for 30 seconds?
Time has expired. Well, there are 3 minutes remaining in support of in opposition to the amendment.
Could the gentleman, could I be recognized for one of those three, Mr. Chairman?
The gentleman will be recognized.
He denied the existence of the wiretap program when Time magazine came out with the story. That's in February 1973. In May 1973, he publicly states that he, the President, personally had authorized and directed the electronic surveillance of 17 persons. A number of these wiretaps were blatantly illegal. There was no justification for them whatsoever under criminal or domestic security basis. And is it reasonable for the reasonable and prudent man to conclude that White House aides would tap the phone of the President's own brother without his approval in advance? I think there is ample material linking impeachable offenses directly to the President, not to his aides, directly to him. I agree that we should do that, and I think we have done so.
1 minute of the gentleman has expired. There are 5 minutes remaining to those in support of the amendment, and 2 minutes remaining to those in opposition to the amendment. And I think the chair will, unless there are those who wish to be recognized this time for the short 2 minutes, otherwise there's a roll call vote, and the vote is on the conference report of military procurement authorization, and the chair will defer calling on any members on either side until we have returned from the roll call at 1:30. We'll recess until 1:30. 2:30, I'm sorry. 2:30.
Just before time for debating the amendment ran out, the committee members recessed for a vote on the House floor and for some lunch. When they returned, the debate was on an amendment to the abuse of power article designed to narrow the charge against Mr. Nixon.
The committee will come to order. At the time that the committee recessed, the opponents of the amendment, the gentleman from California, had 2 minutes left, having consumed 18 minutes, and the proponents of the gentleman's amendment had consumed 15 minutes and have 5 minutes left. I'll recognize now the gentleman from Mr. Maine.
Thank you, Mr. Chairman. I must speak in opposition to the amendment of my friend from California because I certainly do not want to do anything to dilute or limit in any way whatever responsibility the President may have for the very outrageous attempts to use the Internal Revenue Service for political purposes. I consider the evidence shows that the approaches that were made by Mr. Dean and Mr. Ehrlichman to Commissioner Randolph Thrower and to Commissioner Johnny Walters to be absolutely indefensible. Our tax collection system in this country is based on a voluntary contribution assessed and paid by people on a voluntary basis, and it will certainly be destroyed if people cannot have confidence that it is not being used to reward political friends and to harass political opponents. I think that not only does the President have a responsibility not to directly approve such indefensible action, but he has a responsibility not to ratify it after it has occurred, and has a responsibility over and above that to have enough idea of what is going on in his administration to be very sure that this kind of political prostitution of the Internal Revenue Service does not occur. There is nothing in this record which, to me, is more disappointing or more cause for concern of the continuation of free government than the way in which this Internal Revenue Service was attempted to be used for this base purpose.
Time, the gentleman, has expired. All time for those in opposition has expired. I recognize, is there anyone seeking recognition in support of the amendment? Mr. Smith?
I'd like to yield my time to the gentleman from California if he wishes some more.
I appreciate that courtesy, Mr. Smith, but it's not my intention to use any more time. I think the case has been made.
I yield back the balance of my time, Mr. Chairman.
The question occurs now on the amendment offered by the gentleman from California. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? No. The noes appear to have it.
On that, I demand the yeas and nays.
The gentleman from New Jersey demands the yeas and nays, and clerk will call the roll. All those in favor of the amendment of the gentleman from California, please signify by saying aye. All those opposed, no. Clerk will call the roll.
Mr. Donahue? No. Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde?
No.
Mr. Flowers?
No.
Mr. Mann?
No.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drinan?
No.
Mr. Rangel?
No.
Miss Jordan?
No.
Mr. Thornton?
No.
Miss Holtzman?
No.
Mr. Owens?
No.
Mr. Mezvinsky?
No.
Mr. Hutchinson?
Aye.
Mr. McClory?
No.
Mr. Smith?
Aye.
Mr. Sandman?
Aye.
Mr. Railsback?
No.
Mr. Wiggins?
Aye.
Mr. Dennis?
Aye.
Mr. Fish?
No.
Mr. Maine?
No.
Mr. Hogan?
No.
Mr. Butler?
No.
Mr. Cohen?
No.
Mr. Lott? Mr. Freilich?
Aye.
Mr. Moorhead?
Aye.
Mr. Marizidi?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No.
Mr. Chairman,
Clerk will report.
9 members have voted aye, 28 members have voted no.
And the amendment is not agreed to. The gentleman from California.
Yes.
The clerk will report the amendment.
Amendment by Mr. Wiggins. In the Hungate substitute, strike from subparagraph 4 the words, "and concerning other matters."
Ladies and gentlemen of the committee, this raises once again the question which was debated at some length concerning specificity. I'd call your attention to the wording of subparagraph 4. It charges the President with failing to take care that the laws were faithfully executed by failing to act in 2 respects. One, with respect to the unlawful entry into the headquarters of the Democratic National Committee, and 2, with respect to other matters. It's my view, Mr. Chairman, that this pushes beyond all reason the apparent desire on the part of the majority to not specify with particularity that conduct which they condemn. I can think of nothing more vague nor uncertain than the language concerning other matters. If we start from the premise required by the Constitution that a defendant in any proceedings, and especially in these, is entitled to reasonable notice of the nature of the charges against him, then I ask you, what notice is afforded by the charge that he failed to act concerning other matters? We should not have extended debate on this, Mr. Chairman. I would hope that the author of the substitute would state with particularity the other matters if he wished to rely upon them. But failing that, it seems to me appropriate as a matter of law and certainly as a matter of the good sense of this committee to strike the vague and uncertain language now contained in subparagraph 4 that the President failed to act with respect to other matters.
The gentleman has consumed 1 minute and a half, and it will be 18 and a half minutes
Under the
remaining.
rule, I take it that I may yield at this point, but I cannot reserve my time. Is that correct?
You may yield at this point, but there still is 18 and a half minutes remaining for
That's a
those
familiar
who are
number,
speaking
Mr. Chairman.
in support of the amendment.
Of course, if it's in support of the amendment.
I support your amendment.
I'll be happy to yield.
I think that this is material that perhaps, I hope, escaped the drafter of it and can be stricken from it. That's about all I had to say. I support your amendment.
I am prepared to yield to my friend from Indiana.
Really, this matter doesn't need much debate, I don't believe, because it's so obvious and plain that under any theory of the law, modern, ancient, or whatever you want to call it, you're entitled to know a little something about what you're charged with. And as a matter of fact, there's a certain amount of specificity in this article as it's drawn, and we've been given some justifications for Article 2 up here, which are fairly specific. And just to run in here that he's failed to take care that the laws were faithfully executed by failing to act when he had reason to know his subordinates were going to do certain specific things with regards to the Democratic headquarters, and then throw in a catch-all and concerning other matters without any definition at all seems obviously unfair. I agree with my friend from Iowa down here to the extent that I feel that this Article 2, if the proof were here, and I don't think it is, as I'm going to discuss further later when we get to debating the article proper, but if the proof were here, I think in many ways this could be a more serious impeachable offense than that we had presented under the article the other day, because if there were actually a concerted, intentional abuse of the powers and duties of the presidency for political reasons or other improper reasons, I think you might have something worthy of consideration. But if you're going to get into that, and particularly if you're going to include things as we're trying to include here, which are not even violations of the statutes, you at least owe it to everybody to set out what you are talking about. This is just so vague and general, it could go back as far as you can go and cover anything that anybody might dream up at some time. And it's difficult to argue because it's simple and right. So I support the amendment.
I thank the gentleman for yielding. I rise also in support of his amendment, and honestly, I would hope that the proponent of the amendment would accept this, or the proponent of the article would accept this amendment.
Mr. Chairman, the gentleman from Illinois.
Mr. Chairman, I'd like to speak in opposition to the amendment. For this reason, it strikes me that the break-in of the Democratic National Headquarters is only part, and in my opinion, only a small part of the misdeeds, the misconduct, which is attributable to these aides and assistants of the president, and where the president, through these individuals, attempted to impede the Department of Justice and to otherwise interfere or frustrate the lawful inquiries. For one thing, certainly the break-in of Dr. Fielding's office and the events surrounding that are far more reprehensible, in my opinion. The Watergate, the break-in at the DNC is a political matter, but the other is unrelated to any political campaign. And there are a number of other activities that I suppose they could be all delineated, but I think they're all well known. Now, it's possible that some other appropriate language which would cover this would be adequate instead of just the blanket phrase "other matters." A great deal of this does arise from the break-in of the Democratic National Headquarters. In other words, while that seemed to generate this sort of clandestine operation which took place in the White House, nevertheless, it was only a small part of the overall activities in which all of these different characters were involved. And I would hope either that we would retain this language or that some appropriate, more explicit language would be offered in order to cure what the gentleman feels is too much of a generalization. I yield the gentleman from Maryland, Mr. Hogan.
I'd like to associate my remarks with the gentleman from Illinois, Mr. McClory. While I think it would be preferable in the drafting of this clause that we did include more specific items, there are many more items than the break-in of the Democratic National Committee. But I think this argument of specificity that my friends and colleagues have so effectively and articulately made is in effect a red herring, because we should not delude ourselves into thinking that the deliberations in which we are now engaged is a presentation of the evidence. We do not intend to duplicate the 10 weeks of evidentiary hearings which brought us to this point. We're only trying in the most general way to give a summary of the kinds of items which support the various paragraphs in the article. We are not presenting the evidence. I will vote against the amendment of the gentleman from California, but I do hope that some of our draftsmen who are supporting the Article 2 will jot down some additional specifics and offer an additional amendment so we can clarify the objection raised by the gentleman from California.
Mr. Chairman.
Come on, we've got to find
Mr. Hogan and inquire of the gentleman who drafted this article as to whether or not he is prepared, as we have been prepared in the past, to list a number of the specific instances to which you are referring. In addition to the break-in into Dr. Fielding's office, I think a particular concern might be the matter that Mr. Hogan mentioned just prior to the break, and that was the activities involving the transfer of FBI records from the FBI to the Oval Office at the direction of the President. Could the gentleman from Missouri help us out in that regard as to whether or not he'd be in a position to delineate some of the specific items upon which he intends to rely upon the proof of this case?
I thank the gentleman for yielding. The language of 4, if you refer the first few lines of that, as it would concern, when you talk of concerning other matters, he has failed to take care that the laws were faithfully executed by failing to act when he knew or had reason to know that his close subordinates, etc. Now, we're talking of situations of which he should know or should have good reason to know, and as we have said earlier, the doctrine of impeachment cannot really be very narrowly confined. It's as broad as the king's imagination. It has to be. If you'll confine it closely enough, there will be somebody figure a way around it. What about the Kleindienst situation? The testimony, the evidence before the committee was that, as I recall it and would state it, that Mr. Kleindienst received what we would call a chewing out from the President in rather plain and forceful, clear language, and concerning a specific matter. And then when he was before the Senate committee, they were asked if anybody had approached him concerning the same matter, ITT as I recall, and he in effect said, well, he might have casually mentioned it. Well, I'm telling you, the chewing he got was such you'd remember it no matter who gave it to you, and certainly if it came from the President, he remembered it. Now, still we find him, the President, after this date, going before the American people and saying, when he knew that this testimony had been given and when he had reason to know that the testimony was not true, and upholding the testimony of Mr. Kleindienst in that situation. Now, there are other examples, I am told, in the Jaworski considerations, in the false gem cables. These are the sort of things that would be covered here. I yield back to
Mr. Chairman.
Just a moment. How much time has the... Will the gentleman please defer? There are 6 minutes that have been consumed in opposition and 4 minutes in support, and therefore...
Mr. Chairman. Mr. Chairman.
Mr. Waldy.
Mr. Chairman, I rise in support to the amendment. And the reason I do is because we were specific in our allegation in the first portion of that paragraph where we limited the failure to faithfully execute the laws to the unlawful entry into the headquarters of the Democratic National Committee. Now, I happen to believe that the matter of Mr. Kleindienst and the antitrust case might very well fall within the provisions of the general allegation of paragraph 4, but we allege specifically the break into the Democratic National Committee, and we threw in just absolutely as an afterthought those last 4 words, and concerning other matters. And I have not at all concurred in what I have thought to be the objective of my friend and my colleague from California.
utmost caution that we weaken that office that we hold so dear. And let me direct my attention for the few moments that we have to another area that concerns me because we've touched upon it so lightly. In fact, I heard somebody say, and I'm sure he said it in jest, something about it's a bugaboo. And I have reference to national security. National security. What are we talking about? We're talking about protecting the lives and the security of 220 million Americans. That's what we're talking about. So let's not talk about it lightly. I happen to be one who, since I've been in the Congress of the United States, who have supported a strong national defense. A strong national defense. We can't be second. We've got to be strong, and we're talking about national defense as a bugaboo issue? I think not. The President of the United States was concerned about leaks right after he took office. Now let's take a look at what he was talking about. Where were these leaks coming from? Were they coming from somebody's bridge club? Or out of some non-sensitive agency of the government? We know better than that. They were coming from no other place than the National Security Council. Now, who sits on the National Security Council? Staff members? The President of the United States, the Secretary of the Defense, the Secretary of State, and the Director of the Central Intelligence Agency, along with the Secretary of Treasury and the Attorney General by designation of the President. Now, they don't talk about rules for a handball game. They discuss and make the policy for the defense of this country. Your defense, my defense, our children's defense. That's what they do. And these leaks that concern the President of the United States were coming directly out of that National Security Council. Now, what were they? Many of my colleagues here today have alluded to them. And I don't want to duplicate what they've said. But let me point out that about every time the National Security Council would make a decision, a couple of days later, and I hate to mention newspapers, but I must, the New York Times would publish it, or the Evening Star. Wouldn't this concern you? It concerned me. It concerned the President. Let me give you just one. On April 6th, the New York Times prints a front-page article indicating U.S. consideration of unilateral withdrawal. June 1969, shortly after a decision had been reached to begin an initial withdrawal of troops, the New York Times and the Evening Star reported this decision, indicating it would be made public following the meeting with the South Vietnamese president, too. Leaks damaging Dr. Kissinger's diplomatic efforts to end the war for the South Vietnamese government to hear publicly of our apparent willingness to consider unilateral withdrawal without first discussing the matter with President Tu. What does this do to our credibility? Damage and leaks had been occurring with regard to the SALT negotiations have been discussed. Also, internal use by our government of the strategic force posture. A study was made to determine what programs should be adopted relative to our country's, get this, deterrent, conventional, and nuclear capability. The study included 5 possible strategic options, from an emphasis on offensive capabilities to heavy reliance on anti-ballistic missile systems.
costs even were discussed. Notwithstanding the obvious need for secrecy of this study, the May 1st, 1969 edition of the New York Times reported the 5 strategic options under study and even gave the cost estimates. The United States Intelligence Board had been engaged in an analysis of the Soviet Union's testing of missiles and issued a report in June 1969 setting forth their estimate of the Soviet Union's strategic strength and possible first strike capability.
Gentleman has consumed 10 minutes.
I wished I had 10 more, Mr. Chairman. Thank you.
The gentleman from Ohio, Mr. Seiberling, is recognized for 5 minutes.
Thank you, Mr. Chairman. I think that the other gentleman from Ohio has put his finger on one of the very fundamental issues which brought about this proceeding, which is whether under the guise, the phraseology, national security, the President has a blank check to violate the law, because that's what it's all about. When Attorney General Ruckelshaus declined to fire Special Prosecutor Cox after Elliot Richardson had resigned because he declined to follow him, you remember what General Haig, the President's aide, told him? He said, "Your Commander-in-Chief has given you an order." And Mr. Ruckelshaus had to remind him that he was subject to the law, and that the Commander-in-Chief could not give an order that violated the law. Now let's take a look at that law. Point 5 of this article talks about the disregard of the rule of law by the President of the United States. And among other things, he disregarded it when he fired the special Watergate prosecutor, Archibald Cox, or ordered him to be fired. Now let's go back to April 30, 1973, when the President accepted the resignation of Haldeman, Ehrlichman, Kleindienst, and Dean. He at that time pledged to the American people that he would do everything in his power to ensure that those guilty of misconduct within the White House or in his campaign organization were brought to justice. And he announced he was going to appoint Elliot Richardson Attorney General, and he announced that Elliot Richardson would appoint a special prosecutor, and in due course that came to pass. And Mr. Richardson submitted to the committee a statement of duties and responsibilities of the special prosecutor, and the statement provided that he would have jurisdiction over offenses arising out of the Watergate break-in, allegations involving the President, members of the White House staff or presidential appointees, and they also provided that the special prosecutor would have full authority for determining whether or not to contest the assertion of executive privilege or any other testimonial privilege, and that he would not be removed except for extraordinary improprieties. Now, the law had already been long established by the Supreme Court in the case of Accardi versus Shaughnessy in 1953, that as long as the Attorney General's regulations remained operative, they had the force of law and denied him or any other member of the executive branch the right to violate those regulations, and such were the regulations under which the special prosecutor was operating. And that principle was upheld again as recently as last week when the Supreme Court reaffirmed it in the case of United States versus Nixon. Now we all remember the shock that we all experienced last October when in quick succession 2 attorney generals and the special prosecutor were fired on order of the President because they had the temerity to carry out an order of a court of the United States government, which order had been appealed and affirmed by the President, affirmed by the court, and ordered the President to turn over the tapes, which he subsequently was forced to do by public opinion. And it was that act which brought about the creation of this special proceeding. Now, I've always believed that any man elected to the highest office in the land would rise to the occasion. Like every American, I want to believe the best of my president, and I've tried to do so as I studied the evidence before us in this proceeding. And having done so, I must sadly say to my friends on both sides of the aisle and in the country, he let us down. Mr. Chairman, I yield back the balance of my time.
The gentleman from California, Mr. Moorhead, is recognized.
Chairman, members of the committee, one thing certainly must be clear by now to everyone in America, and that is certainly the President of the United States is not so all-powerful under any circumstances that he can't be examined one way or the other for his acts and, even if necessary, be removed from office. I don't believe that any man in the history of this world has ever been examined as thoroughly as this President, Richard Nixon. I don't know of anyone who has ever had $25 million of federal money spent on various investigations over a period of 2 years' time. And many, many more millions of dollars by other private agencies. Everything that Mr. Nixon could possibly have done wrong has surely been uncovered by this time. And yet you look at the evidence that's brought to us here today, and it almost seems pathetic that $25 million brought in so very little. If the IRS was used wrongly, no one would object louder or stronger than I. I spent 16 years running a legal aid and lawyers reference service, and no one has any more respect for the underdog or the law than I do. And there is nothing that brings the fear into the heart of the average American that is brought into their heart by an IRS audit. That must be clear to everyone. But the cold, hard facts are that the IRS was not misused by the President. It's true that 4 days before he talked to the President, Mr. Dean went and asked, at least took a list of enemies to the IRS and asked for something to be done about it. But the evidence that was brought to us by our staff was that the President's connection with Mr. Dean was very, very slight during those particular days and picked up only in the months of 1973. Now, it's true that Dean and Nixon had a meeting on the 15th of September, but there isn't one shred of evidence that anything was done as a result of that meeting on the 15th of September, and no real evidence that anyone took the comments seriously. And certainly on Mr. Dean's request for IRS consideration of certain people, there was nothing done. The names were put away and were never presented to another soul. There's been a suggestion that perhaps the IRS was used to help friends. Well, certain people, evidently, a few of them had come to the people in the White House and said that they were being harassed by the IRS. I wonder how many congressmen have had people come to them and say they were being harassed by some agency of the federal government. These were checked into by a simple request, what's happening? This is the testimony that we have. There was no special consideration given. There was no evidence of any pressure put on these people. What kind of a count for impeachment is that? We have the question of the Plumbers Group. Plumbers is a name of art that's been given for this special group. I don't approve of many of their later activities. Certainly, they went beyond any power that the President expected them to have. We have the testimony, the sworn testimony of Emil Crow. He said, with respect to the purpose for the Special Investigations Unit, it is Mr. Crow's sworn testimony that on or about July 15, 1971, he was given oral instructions by Mr. John Ehrlichman to begin a special national security project to coordinate a government effort to determine the causes, sources, and ramifications of unauthorized disclosure of classified documents known as the Pentagon Papers. We have other national security matters. We have the 17 wiretaps that were approved by J. Edgar Hoover and the President. There's mention made of 2 or 3 other wiretaps that were not authorized by the President, and no showing whatsoever of any authorization by the President. But the 17 wiretaps that were actually made at the President's request, or at least with his signature, were very definitely brought about by a very great concern with Henry Kissinger, with the salt-talk negotiations that were going to take place and with knowledge that might be given to a foreign country. Here,
the time of the gentleman has expired.
I'd like another 10 minutes, too.
Thank you, Mr. Chairman. I'm
The
proud.
gentleman has not yet been recognized. Gentleman is recognized for 5 minutes.
Well, thank you again, Mr. Chairman. I'm very proud and honored to associate myself with the remarks of my dear friend, a very great lawyer, the gentleman from Massachusetts, Mr. Donahue. Mr. Chairman, our debate today has distilled the issues of this article to where we all now can clearly see that they constitute a clear threat and attack against our Constitution, which is the essence and soul of our republic. We cannot and must not fail a responsibility which is ours, and so again, with heavy heart and great sadness, we must vote for this article of impeachment. I yield back the balance of my time.
The gentleman from New Jersey, Mr. Mariziti, is recognized.
Thank you, Mr. Chairman. We see here the sharp differences in the interpretation of the facts and the law in this matter. Chairman, I submit that we have these sharp differences because the case and the evidence is not clear and convincing against the President. Specific allegations are not set forth, and the proponents of the resolution to impeach continue to refuse to set up these specific allegations in the articles. We have theories propounded that the President should be held accountable for the acts of his subordinates, even though he has no knowledge and did not authorize certain acts. A great deal has been said, and in fact proven, that this staff member did this, and that staff member did that, and these staff members in concert did this and did that. But, Mr. Chairman, I submit to you that the proof fails and fails in a very vital respect. When it fails to draw the line to the President of the United States. Now, on the question of wiretapping that we've heard so much about, and without going into details because it's been thoroughly discussed, what do we really have here? We have heard the urgent pleas by Mr. Henry Kissinger to stop the leaks from the National Security Council. Mr. Chairman, these pleas were made not by just an ordinary individual that might not have had the knowledge and information necessary to appreciate the seriousness of the situation, but no less a man than Mr. Henry Kissinger, who, in my opinion, would be the highest authority in the land as to whether or not leaks would affect the security of the United States. And And what do we have here? In response to that plea, the President, in pursuance of his constitutional duty to protect the United States, ordered the wiretaps and stopped the leaks. And as I said in my previous remarks today, I, for one, Mr. Chairman, would, on the basis of Henry Kissinger making a request, if Mr. Nixon refused to take this action to protect the United States by ordering these wiretaps, I, for one, would vote to impeach him for that refusal of his constitutional duty and responsibility. In closing, Chairman, let me say that I think we ought to give some serious consideration to exactly what we are doing here. Mr. Richard Nixon was elected by 47 million people of these United States to be the President of the United States. And what I have heard, and on what I have heard today, I cannot and will not bring myself to vote to remove that choice of 47 million people and impeach Richard Nixon, President of the United States. Mr. Chairman, if I have any time left, I yield the balance of my time to Mr. Latham.
Gentleman has 30 seconds remaining.
Thank you, Mr. Chairman. I may just complete my comments concerning the national security. The threat was compounded by the fact that Mr. Ellsberg was a former staff member of the National Security Council itself, and the prospects that he might divulge additional information, and the realization that the Soviet government had already received a copy of the Pentagon Papers on June the 17th and might be recipient of additional classified information. He also had a broad area of access to the clearance to see classified information, including PSYOP, better known as the nation's single integrated operations plan. Now, what does this encompass? Nothing other than all, and I stress the word all, of this nation's military contingency plans in case of war, including integrated conventional and nuclear options. That's what concerned the President.
Time of the gentleman has expired. Recognize the gentleman from Massachusetts, Father Drynan.
I'm happy to yield to Ms. Jordan a minute of my time. Ms. Jordan.
Thank you for yielding, Father Drynan.
Recognized.
Mr. Chairman, one phrase in subparagraph 3 of Article 2, which has generated much debate, is that acting personally or through his subordinates and agents. There is no need to substantiate this phrase by agreeing or disagreeing with the Madison superintendency theory, because the charges which underlie this phrase are permeated with presidential command, presidential direction, the president in charge. The colloquy which gives the greatest clue to this chain of command and the president knowing what his subordinates did is not the testimony of Mr. Butterfield. We don't have to rely on him. We have an exchange between Mr. Thornton of Arkansas and Mr. John Mitchell. Mr. Thornton, did you ever check to determine whether or not the information relayed to you through Mr. Haldeman was a correct reflection of the president's instructions? Mr. Mitchell, there may have been occasions, Congressman, but I would have to say that in most all instances that I can recall, Mr. Haldeman's representations to me of the president's position were truthfully and fully stated. Mr. Thornton, did you ever check with the president to determine whether information you had passed toward him through Mr. Haldeman had been received by him? Mr. Mitchell, no, I don't believe I did, but I think there again the record of actions coming from such line of communication would indicate that they were fully and faithfully conveyed.
Mr. Chairman, this article is so overwhelming that I don't think it's an exaggeration to say that history will judge this as comparable to the moral rebellion centuries ago at Runnymede. They were our legal and moral ancestors because they revolted against tyranny. But I want to pay tribute tonight to two men who made this possible. I am honored and humbled because these two men happen to be my constituents. One is a Democrat and one is a Republican. And I speak about Archibald Cox and Elliot Richardson. When they followed their conscience, 3 million citizens wired their congressman, and this inquiry began. These two good men never realized that their decision not to submit, not to go along, would force every member of Congress and every American citizen to make the same moral decision. They were the first to see the repeated abuses of the constitutional rights of citizens on which this committee is to act tonight. Mr. Cox, the former Solicitor General of the United States, distinguished professor and author, he would not back down. He would not become a part of the cover-up. And Elliot Richardson, the former Attorney General of Massachusetts, Secretary of HEW and Defense, he gave up his entire career rather than tarnish his soul and permit himself to be a part of the cover-up. I pay tribute to these two men. Without their courage, the victory for justice, which we witness here tonight, could never have happened. And, Mr. Chairman, I hope that their courage will continue to be contagious. I yield back the balance of my time.
Recognize the gentleman from New York, Mr. Smith.
Thank you, Mr. Chairman. Mr. Chairman, we have spent all of today in the debate of this Article 2, which says that the President of the United States, contrary to his trust as President and subversive of constitutional government, repeatedly engaged in conduct violating the constitutional rights of citizens, impairing the due and proper administration of justice and the conduct of lawful inquiries, or contravening the laws governing agencies of the executive branch of the government. And I think probably almost everything has been said about this that could be said. From the comments that have been made, I would say that a majority of this committee believe it will support this article and believes what it says, and there are some who don't feel that the evidence is such that's been produced in this long proceeding that this committee has been involved in. It makes out a clear and convincing case that this is so, the President of the United States himself. And with that, Mr. Chairman, I'd like to yield 2 minutes of my time to the gentleman from Indiana, Mr. Dennis.
Dennis is recognized for 2 minutes.
I thank the gentleman for yielding because something the gentleman from California, Mr. Moorhead, said struck a very responsive chord with me. I believe I have spent as much time in courtrooms defending the underdog as any man or woman on this committee. And I have done it enforcing their civil rights, too, where it counted. And I have done it when every man's hand in the establishment was against my client and when every public organ was crying loud for his blood. So that situation's nothing new to me at all. But I never expected to find myself in the similar situation where the President of the United States was concerned. And now that I have, I simply want to say that it is my belief and opinion, and my sincere opinion and belief, that the President of the United States has exactly the same rights, and I will stand up for them exactly the same way, as did those humble citizens I used to represent. I thank you.
The
gentleman is recognized for 1 minute.
I thank the gentleman for yielding, and in 1 minute I'd like to explain that while I voted against Article 1, which was the vote that we took on the last article, that I intend to vote in favor of Article 2. In my opinion, there was no proof, no clear and convincing proof of any criminality or any conduct of the President which involved him as a co-conspirator. But the President does have a constitutional oath and an obligation to see to the faithful execution of the laws. and with multiple acts of misconduct, of illegality, of criminality being conducted in and around the White House by many of his top aides, it seems to me that the President has failed us in this take care provision of the Constitution. While I bear no malice and no hostility to the President, it seems to me that I have an obligation myself as a member of this committee, when I see the constitutional obligation in default, to support an article of impeachment. Thank you, gentlemen.
Gentleman has 40 seconds remaining.
Mr. Chairman, thank you very much, and I'm sorry that my remarks, brief as they may have been, failed to sway my colleague from Illinois who sits on my right, and with that I yield back the balance of my time.
Recognize the gentleman from New York, Mr. Rangel.
Thank you, Mr. Chairman. I would like to thank you and the members of this committee because through their decision they have restored some faith and integrity to our system of government. We've heard in the past many times the words law and order, but most Americans recognize who those words were directed at and exactly what those words really meant. Today, Mr. Chairman, that phrase can be restored to some of its original meaning because we have established some law and some order as relates to the abuse of presidential power. The Vice President of the United States has reportedly said that this committee does not properly reflect or represent the members of the House of Representatives, and perhaps it does not for what committee truly does. Nevertheless, the committee system is a part of the House of Representatives, and is not a part of our American way of life to attack the entire system merely because we differ with the results. The President of the United States not only disregarded the law, but in fact feared the law and feared the grand jury system in our nation's capital. On March the 27th of 1973, the President, in talking with Ehrlichman about the fate of Mr. Mitchell, Mr. Ehrlichman said, "I think we have to recognize that you're not going to escape indictment," talking about Mr. Mitchell. This is what they're supposed to tell him. "There's no way. Far better that you should be prosecuted on information from the United States Attorney based on your conversation with the United States Attorney than on an indictment by a grand jury of 15 blacks and 3 whites after this kind of an investigation." The President responded, "Right. And the door of the White House, we're trying to protect it." Well, Mr. Chairman, I am satisfied that while the President is protected from indictment at this time from a grand jury in the nation's capital, and while he has been denied his day in court as it relates to the criminal courts, that I am satisfied that he would have had a fair hearing in the House of Representatives, that he will have a fair trial in the United States Senate, and for the American people and its Constitution, it would have had its day to prove that the system can work, and indeed it has been a victory for law and for order. Thank you, Mr. Chairman.
I recognize the gentlelady from New York, Ms. Holtzman.
Thank you, Mr. Chairman. The question has been raised tonight, what are the rights of the President? And I think we have to confront what his duties are. And he takes an oath, a solemn oath, to defend and protect the Constitution of the United States to the best of his ability. And the preamble of this Constitution says, "We, the people of the United States, to secure the blessings of liberty." And that is our precious heritage. And what has this President done as this committee has examined? We have seen that the President has engaged in a course of conduct in which the ends justify the means, and in which this blessing of liberty has been trampled to our disgrace. Let us look first at this Houston plan which the President, our President, your President, and my President approved. This Houston plan, which I read in anger twice or 3 times, says that dissent is tantamount to treason. And because it's tantamount to treason, the President has the right to bring to bear against any dissenter the force of the CIA, the force of the FBI, illegally. That a person is subject to having his mail opened, or his house broken into, or his phone tapped because he dissents. And it's not at all clear from the evidence before this committee that the Houston Plan was not carried out. And let us look at the leaks that everybody's talked about. Do they justify the ends we have seen? Does anybody argue that the wiretap of Joseph Kraft by a private operative on behalf of the White House is constitutional or legal, and that the President can put his imprimatur on that? Does anybody argue that that is within the bounds of the Constitution? I can't believe it. And what about the Ellsberg case? Perhaps the President didn't authorize the burglary in the first place, but he, according to Ehrlichman, ratified it afterwards. And if it were such a horrendous crime in the President's eyes, then why didn't he expose the people who were responsible to the criminal authorities? No, he covered it up. And he said that Ehrlichman, who has since been convicted for that break-in or being involved in that, he said that Ehrlichman was one of the two finest public servants he had ever known. And what about the Internal Revenue Service, with 575 names of political opponents of this administration turned over? The President clearly approved that in a conversation on September 15th, and we have his words. He didn't expose these people. He didn't throw Haldeman out of his office. He didn't throw Dean out of his office. At a later date, he said, "Do you need any more help with IRS?" And Mr. Thrower, the Commissioner of Internal Revenue Service, submitted an affidavit to this committee in which he said it was the White House's intention to try to create a personal police force out of the alcohol, tobacco, and firearms part of the Internal Revenue Service. What we have seen here is an attempt by the administration with the imprimatur of this President to bring retribution against those who seek to oppose the administration. And how many of us have not quarreled with presidents in the past, Democrats or Republicans, over agricultural policy or environmental policy or foreign policy or whatever? Does that give any president the license to burglarize our home, to wiretap our phones, to open our mail? I submit that if it does, we have gone down the long road to tyranny, and that the blessings of liberty that we formed this Constitution 200 years ago to preserve will vanish very quickly. And I would like to remind my colleagues that under the Constitution of the United States, we in the House of Representatives, through the power of impeachment, have been given the duty to preserve this Constitution and to preserve the blessings of liberty. And for that reason, I feel that we are compelled to approve this article of impeachment. Thank you, Mr. Chairman.
The gentlelady from New York has expired. I recognize the gentleman from Virginia, Mr. Butler.
Mr. Chairman, I yield my time to the gentleman from Maryland, Mr. Hogan.
I thank the gentleman from Virginia. A number of our colleagues have said that the evidence presented today fails to support the impeachable offenses. I know that they do not want to give the erroneous impression that we have been involved today or in any of these recent deliberations in a presentation of evidence. What we've been involved in is debating amendments to these articles of impeachment. The evidentiary presentation took 10 weeks of our time after months of staff work. So we shouldn't give the impression that what we've been presenting is evidence. But what we have seen is the results of all of that labor, and having all 38 members of this committee study that evidence for 10 weeks in long sessions, day after day, hour after hour, an overwhelming majority of this committee can subscribe to the idea that that evidence supports these articles of impeachment.
I yield back, Mr. Chairman. I yield back the balance of my time.
Recognize the gentleman from Utah, Mr. Owens.
Thank you, Mr. Chairman. Article 1 of impeachment focused on many instances of one immense abuse, the cover-up of the Watergate break-in. In contrast, Article 2 is a collection of separate, individual, very serious abuses of the power of the presidency. These are charges that the President used his power, or knowingly permitted his power to be used, to do something unconstitutional, illegal, immoral, or to do something legal but for political or non-legitimate purposes. This is not a grab bag of presidential actions, which a majority of the committee thinks is unwise or bad or contrary to our national interest. These are what they must be to be impeachable, acts which would be clear violations of the standards of conduct for any president, violations which are so grave and are such an abuse of the presidential trust that the public well-being requires that they be corrected. There are other serious offenses of the president which do not, in my opinion, rise to the level of impeachability. On the basis of evidence before us, I do not believe that the allegations of bribery, for example, in the ITT case or the milk case, have been sustained. But each one of the abuses contained in Article 2 is adequate in itself to sustain impeachment, in my opinion. These instances of presidential abuse center around the violation of the guarantee of civil liberties contained in the Bill of Rights, namely the right to be free from government interference in his privacy, his home, his letters, and his belongings, and his conversations. I would hope that the President is watching this proceeding tonight. I feel that I have grown to know him intimately over the past 8 months. We who are about to vote this new article of impeachment do not wish him the slightest personal harm. We recognize that there is tragedy involved. There is only goodwill on this committee, and I believe that every member acts tonight in accordance with his or her conscience and in pursuit of a constitutional obligation, and I would hope that he would believe that. This article of impeachment does not attempt to apply new standards to this president. We apply old standards, which everyone knows of through the impeachment process. And impeachment is the only remedy for the abuses which Article 2 proposes to correct. Some of them are not criminal abuses, and even if they were criminal, the President, when sitting, is beyond criminal process. Probably the principal reason the framers included the impeachment power in the Constitution was because they saw that the only remedy against a president for the unlawful enlargement of the executive power and the encroachment upon individual liberties was through this type of stern accountability, the only remedy. By passing these articles of impeachment, we set an example. It is a fair example because we apply only the most fundamental and basic standards of which any president should be aware. And it is an example to future presidents and to all who hold civil authority in this country that the Congress, even to the exercise of its impeachment capability, will stand against the abuse of power and the invasion of civil liberties which would undermine our Constitution or the rights and the dignity of the individual. We should not forget that the history of liberty in the world is very short. The history of tyranny is very long, and the principal source of oppression has always been the unrestrained power of the state.
Mr. Chairman, I ask unanimous consent to consider and adopt in block technical perfecting amendments I have at the desk, and they have been distributed to each member.
I
ask unanimous consent, Mr. Chairman.
Gentleman from Missouri ask unanimous consent that certain technical amendments be adopted.
Yes, Mr. Chairman, I might state that this is on page 2, on line 4 of page 2. We strike out a comma following the word directing, and at the bottom of the page, the fourth line from the bottom on page 2, you insert a comma immediately before which. And, Mr. Chairman, on page 3, the word misused is misspelled missued. The correct spelling.
The gentleman has read the amendment. Is there objection? Without objection, the technical amendments are adopted.
Mr. Chairman.
Mr. Hungate.
I move the previous question.
The question now occurs on the adoption of the Hungate substitute as amended. All those in favor of the Hungate substitute as amended, please signify by saying aye. Aye. All those opposed? No. The ayes have it. The ayes. A call of the roll is demanded, and the roll call is ordered, and the clerk will call the roll. All those in favor of the Hungate substitute as amended, please signify by saying aye. All those opposed, no.
Mr. Donahue.
Aye.
Mr. Brooks.
Aye.
Mr. Kastenmeier.
Aye.
Mr. Edwards.
Aye.
Mr. Hungate.
Aye.
Mr. Conyers.
Aye.
Mr. Eilberg.
Aye.
Mr. Walde.
Aye.
Mr. Flowers.
Aye.
Mr. Mann.
Aye.
Mr. Sarbanes.
Aye.
Mr. Seiberling.
Aye.
Mr. Danielson.
Aye.
Mr. Drinan.
Aye.
Mr. Rangel.
Aye.
Miss Jordan.
Aye.
Mr. Thornton.
Aye.
Miss Holtzman. Mr. Owens.
Aye.
Mr. Mezvinsky.
Aye.
Mr. Hutchinson.
No.
Mr. McClory.
Aye.
Mr. Smith.
No.
Mr. Sandman.
No.
Mr. Railsback.
Aye.
Mr. Wiggins.
No.
Mr. Dennis.
No.
Mr. Fish.
Aye.
Mr. Maine.
No.
Mr. Hogan.
Aye.
Mr. Butler.
Aye.
Mr. Cohen.
Aye.
Mr. Lott.
No.
Mr. Freilich.
Aye.
Mr. Moorhead.
No.
Mr. Marizidi.
No.
Mr. Latta.
No.
Mr. Rodino.
Aye.
And so the Judiciary Committee approves the language for a second historic article of impeachment against the President.
Mr. Chairman.
The clerk will report.
28 members have voted aye. 10 members have voted no.
And the substitute as amended is agreed to. The question now occurs on the adoption of the Article 2 of the Donahue Resolution as amended by the Hungate substitute. All those in favor, please signify by saying aye. Aye. All those opposed? No. The ayes appear to have it.
Mr. Chairman, on that I demand the ayes and nays.
The gentleman from New Jersey demands a call of the roll, and the call of the roll is ordered, and the clerk will call the roll. All those in favor of the adoption of the Article 2 of the Donahue Resolution as amended by the Hungate substitute, please signify by saying aye. All those opposed, no.
Mr. Donahue.
Aye.
Mr. Brooks.
Aye.
Mr. Kastenmeier.
Aye.
Mr. Edwards.
Aye.
Mr. Hungate.
Aye.
Mr. Conyers.
Aye.
Mr. Eilberg.
Aye.
Mr. Walde.
Aye.
Mr. Flowers.
Aye.
Mr. Mann.
Aye.
Mr. Sarbanes.
Aye.
Mr. Seiberling.
Aye.
Mr. Danielson.
Aye.
Mr. Drinan.
Aye.
Mr. Rangel.
Aye.
Miss Jordan.
Aye.
Mr. Thornton.
Aye.
Ms. Holtzman.
Aye.
Mr. Owens.
Aye.
Mr. Mezvinsky.
Aye.
Mr. Hutchinson.
No.
Mr. McClory.
Aye.
Mr. Smith.
No.
Mr. Sandman.
No.
Mr. Railsback.
Aye.
Mr. Wiggins.
No.
Mr. Dennis.
No.
Mr. Fish.
Aye.
Mr. Maine.
No.
Mr. Hogan.
Aye.
Mr. Butler.
Aye.
Mr. Cohen.
Aye.
Mr. Lott.
No.
Mr. Freilich.
Aye.
Mr. Moorhead.
No.
Mr. Marizidi.
No.
Mr. Latta.
No.
Mr. Rodino.
Aye.
Mr.
Clerk will
Chairman,
report.
28 members have voted aye. 10 members have voted no.
And the resolution is agreed to and pursuant to the procedural resolution, Article 2 as amended, is adopted and will be reported to the House. And the committee will recess until 10:30 tomorrow morning.
So the House Judiciary Committee has approved its second article of impeachment, charging President Nixon with a broad abuse of power, with violating his oath to defend the Constitution and to take care that the laws be faithfully executed. The outcome was not a surprise, inasmuch as the committee already had voted one article last week charging the president with an obstruction of justice in his handling of the Watergate case. But tonight, on the second article, the supporters of impeachment picked up one additional Republican vote. The vote again was 28 to 10. And on this vote, all 21 Democrats voted for the impeachment article, and 7 of the 17 Republicans supported the motion. It's the first time since 1868 that a congressional committee has taken such drastic action aimed at removing the president from office. Again, this assures that articles of impeachment will be included in a resolution that will be sent to the House floor. Tonight's action climaxed a long day in which the president's defenders lost several attempts to weaken or modify Article 2. So now we're certain that at least two articles will be included in the impeachment resolution when it is finally approved.
And overall, of course, this continues the momentum toward impeachment of President Nixon. That one additional Republican vote was that of Robert McClory of Illinois, who voted against the first article, obstruction of justice, but did vote aye when it came to abuse of power, as he said he would all along. Now, this does not mean, as Chairman Rodino just said, the committee will meet again at 10:30 tomorrow morning Eastern Time. Still to be resolved are possibly 3 other articles of impeachment that will be introduced, debated, and then finally reach a vote. They include the charges that involving the president's authorization of the secret bombing of Cambodia, a similar charge having to do with the president's personal income tax liabilities. And those are the basic complaints the basic charges that will be introduced and debated tomorrow. Let's go now to Carolyn Lewis down on the Hill. Carolyn?
Well, I guess you can see that the second time around it was a lot easier. Last Saturday night they voted the first article of impeachment, and it was a very solemn occasion. It was solemn tonight, too, but there seemed to be a sterner voice from most of the members who voted for impeachment. There wasn't the same stillness in the room. Everybody, in fact, was rather anxious to get it over with because the hour was late. Today, the mood had shifted. If you look back over the day, the chemistry had changed, whereas the members were rather quarrelsome last week. Today, it was a very businesslike session, and they really did move along and get the business done and reach a decision on the Article 2 for impeachment. I might say, as far as the members are concerned and the press is concerned, it was a tug-of-war between human exhaustion and a sense of historic purpose. Back to you, gentlemen.
Well, Jim, maybe it would be appropriate for us at this time to review what is in Article 2, inasmuch as this article is certain to be included in the resolution of impeachment that will be sent to the floor. As we said earlier, the first article charged the President with an obstruction of justice on a number of counts in his handling of the Watergate case. This one is directed almost exclusively at the abuse of power by the President, and it enumerates a number of ways in which Mr. Nixon is charged with violating his oath of office.
The proposed article claimed that the President violated his constitutional oath and acted in disregard of his constitutional duty to take care that the laws be faithfully executed.
The first specific charge accuses the President of violating citizens' rights by trying to get tax information for unauthorized purposes and trying to initiate tax audits in a discriminatory manner.
Number 2 charges Mr. Nixon with misusing the FBI, the Secret Service, and other executive branch personnel by directing them to conduct electronic surveillance that was unrelated to national security. It adds that FBI records of those wiretaps were concealed.
The third section cites Mr. Nixon for authorizing the creation of a secret police unit in the White House. This unit is said to have misused the CIA and to have engaged in unlawful activities to prejudice the trial of Daniel Ellsberg.
The fourth charge accuses Mr. Nixon of failing to act properly when he knew his subordinates were impeding lawful inquiries following the June 17th break-in. It was amended to cite specifics, such as the nomination of Richard Kleindienst to be Attorney General, electronic surveillance, the break-in at Dr. Fielding's office, and the financing practices of the committee to re-elect the President.
And finally, a fifth charge accusing Mr. Nixon of knowingly misusing his executive powers by interfering with agencies such as the FBI, the Watergate Special Prosecutor, the Justice Department, and the CIA.
Let's go now back to Carolyn Lewis, who has two members of that committee to comment on this vote. Carolyn?
I have here Congressman Flowers and Congressman Trent Lott, who both represent the South. One is a Republican and one is a Democrat. First of all, Mr. Flowers, it seemed to be a shift in mood today. Do you think that the committee is now getting more businesslike and really just getting down to work and not being as rhetorical and as argumentative?
Well, most of the constitutional propositions have been stated, I believe, don't you, Trent? And everybody kind of sees how it's going to go now, and you're going to really see us get down to business tomorrow, I think, don't you, Trent?
Well, I think that while we had occasionally slipped into some lawyer-type arguments, that for the most part we have gotten down to the serious business today. I think that maybe tomorrow when we get in these other areas it may change a little bit, because these are 1, 2, maybe 3 articles that haven't even been included by the staff. So I don't know exactly what to expect.
Well, what I meant, Trent, was we'll move along even more rapidly than we did today. And today was rapid by Friday and Saturday standards. And the way I'm inclined right now would be to vote against all of the other proposals. And so I certainly don't intend to mean that it's the serious business means that we're going to pass them. I hope we don't, because I don't think that any of those proposed articles rise to at least my standard of impeachable conduct, and I know you didn't think any of the 5 proposals rose to your standard. And I have a hard time disagreeing with the gentleman from South Mississippi. My in-laws live in his district and are constituents of his. And
Good
he's a very,
constituents, too,
very
I assure
close
you.
personal friend of mine, and I have the highest regard for him.
Let me ask you, gentlemen, something. President Nixon is pinning his hopes on Southerners, particularly in the Senate. Now, we have a split opinion here on 2 Southerners. Mr. Lott, let's just turn to you. Do you think the President will be able to hold the South in the House and in the Senate?
Oh, I think it's obvious already that he won't be able to hold all of the South. I think that some of his strongest support will come from the South in both parties. but I think particularly on the Democratic side of the aisle that some of his strong support will come from Southerners. In the Senate, that's another thing I really can't predict it, but I think that some of his strong supporters, again, will be Southerners over there.
Do you get feedback from back in Mississippi? Are the people with you on your stand on impeachment, or is there an erosion even there?
I think it's been interesting that every member has commented that the wires and letters that he's gotten have more or less been 3-1 or 4-1 in support of the position that he has taken from all across the country. But I think the people in Mississippi generally think that I have done the right thing, and the mail has reflected that.
What about you, Mr. Flowers, on that?
Well, I'm not sure my mail's been 3-1 in support of what I've done, Trent, but I think in the House and in the Senate, you're going to see Southerners all over the ballpark. They'll be, I hope and I honestly believe, working at it in the same manner we have, Trent, and voting their own convictions based on the law and the evidence and their own conscience.
I'd like to comment along those lines. I think that you'll see Southerners wrestling with this very dramatically within themselves, and I think it's obvious on this committee that a matter of conscience is involved here, and you will see them all over the ballpark based on their understanding of history and what's involved and the evidence, and I think Walter Flowers is a perfect example of that.
Thank you very much, gentlemen. Thank you. Thank you. That's
with us throughout the day's and the night's events have been Jack Murphy of the Georgetown University Law Center, an expert in constitutional law, and Stephen Hess, former aide to Richard Nixon, senior fellow at Brookings Institution, and the author of several books on American politics. Gentlemen, one question. We had Article 1 charging the President with obstruction of justice. Now we have Article 2 charging him with abusing the powers of the presidential powers as his presidential powers as delineated in the Constitution. In your opinion, which is the more serious of the two? Stephen?
Well, I can't speak as a lawyer because I'm not a lawyer. I would assume that under the law, Articles 1 and Articles 2 would be like comparing poison and bullets. They both have the same end result. They're both fatal, and they both bear the same penalty. But let's compare the allegations. Article 1, the Watergate cover-up. I can imagine that a presidential candidate could wake up on June 18th and learn that some damn fools have broken into the opposition headquarters on your behalf. Well, your election is threatened. And to protect yourself, I think you might find that you start to sink like in a quagmire, first into withholding evidence and then into perjuries and talks of clemency and hush money, the so-called containment theory. But then the charges today, the charges of abuse of power, of wiretaps, of using the CIA and the IRS and the FBI for your own purposes, of illegally opening mail and of breaking in, burglary. Well, these, if proven, are deliberate. They're planned. They're self-initiated. They're not something that you move into incrementally or accidentally. And so for me, at least, they're infinitely more serious. To me, they represent a complete misunderstanding of what our nation's history is all about, of what our society is all about, the elements of democratic government, of civil liberties, and respect for each other, or respect one for the other. So that's how I would come down on your question, Jim.
Jack?
I think the second article is more important from a legal point of view. I think we've watched the committee today create what might be characterized as a unique constitutional animal. This article, Article 2, involves a concept, as we've all said, of abuse of power. And that concept is rather plainly different to me from normal concepts of criminality. Article 1 involved those normal concepts under the heading of obstruction of justice. But with Article 2, while in individual subparagraphs you have reference to many activities which were criminal, or all but criminal, the basic thrust is that the President abused the powers of his office, that he violated his oath to take care that the laws be faithfully executed, basically that he breached his trust to the American people. This charge is more in the nature of a civil charge than a criminal charge. Much of the evidence directly implicates the President's men, but not the President himself. So in the passage of this article, there is at least the suggestion that a strong bipartisan majority of this committee believes that the President is answerable under his oath as a matter of civil constitutional law when he allows his men to conduct themselves in a criminal fashion corruptive of all ideals of trust in government. This is not an unexpected proposition, but I suggest to you it's the first time that the proposition has ever been announced by an American lawmaking body.
Well, to recap today, it has been a long day before the House Judiciary Committee, but you saw the climax just minutes ago. The committee, by a 28-10 vote, approving a second article of impeachment against Mr. Nixon, this one charging him with a broad abuse in his presidential power. There were some moving speeches, I thought, tonight, Jim, particularly those speeches by Southerners, James Mann and Walter Flowers of Alabama, underscoring what Congressman Trent Lott was telling Carolyn just a few moments ago, that the Southerners are really going to be all over the lot. I think today's development certainly underscores what we have been saying all along, that the pro-impeachment forces are very strongly in command in the committee, and this comes amid growing signs that the impeachment drive is gaining momentum among members of the House of Representatives at large, and also reports that some Republicans may now begin a new round of pressure against the president to resign.
Our thanks to Jack Murphy and Stephen Hess. Tomorrow, the introduction and debate on other articles of impeachment, contempt of Congress growing out of the subpoenas of the House Judiciary Committee, the president's alleged defiance of those subpoenas, the secret Cambodia bombing, and the president's personal income taxes. We want to remind those of you who have not seen today's debate from its beginning this morning that immediately following a station break, we will bring you, on most of these public broadcasting stations, complete gavel-to-gavel tape replay of the impeachment debate. Stay tuned.
This is PBS, the Public Broadcasting Service. You analyzes the presidency.
Yeah, I think he does think the House will not impeach him. Now, you may think that's living in a world of self-delusion, but I think they are genuinely believe that is not going to happen.
Washington Week in Review reports on the Congress.
It's becoming increasingly doubtful whether the Senate will have time this year to try the impeachment trial.
Washington Week in Review discusses foreign affairs.
Kissinger goes up and down in optimism and pessimism. I think that's clear. He saw a chance to get a deal, and he said he'd stay a few more days.
With moderator Paul Duke, Washington Week in Review looks at the major national and international events of the week. From Washington, NPAX, Washington Week in Review.
Such a feeling's coming over me. There is wonder in most everything I see.
The popular songs of the Carpenters next time when Karen and Richard Carpenter join Arthur Fiedler on Evening at Conch.
Surprised if it's a dream.
At 11:20 tonight Eastern Time, the House Judiciary Committee began its second vote to recommend impeachment of the President of the United States.
Mr. Donahue.
Aye.
Mr. Brooks.
Aye.
Mr. Kastenmeier.
Aye.
Mr. Edwards.
Aye.
Mr. Hungate.
Aye.
Mr. Conyers.
Aye.
Mr. Eilberg.
Aye.
Mr. Walde.
Aye.
Mr. Flowers.
Aye.
Mr. Mann.
Aye.
Mr. Sarbanes.
Aye.
Mr. Seiberling.
Aye.
Mr. Danielson.
Aye.
Mr. Drinan.
Aye.
Mr. Rangel.
Aye.
Miss Jordan.
Aye.
Mr. Thornton.
Aye.
Miss Holtzman.
Aye.
Mr. Owens.
Aye.
Mr. Mezvinsky.
Aye.
Mr. Hutchinson.
No.
Mr. McClory.
Aye.
Mr. Smith.
No.
Mr. Sandman.
No.
Mr. Railsback.
Aye.
Mr. Wiggins.
No.
Mr. Dennis.
No.
Mr. Fish.
Aye.
Mr. Maine.
No.
Mr. Hogan.
Aye.
Mr. Butler.
Aye.
Mr. Cohen.
Aye.
Mr. Lott.
No.
Mr. Freilich.
Aye.
Mr. Moorhead.
No.
Mr. Marizidi.
No.
Mr. Latta.
No.
Mr. Rodino.
Aye.
Mr.
Clerk will
Chairman,
report.
28 members have voted aye. 10 members have voted no.
And the resolution is agreed to and pursuant to the procedural resolution, Article 2 as amended, is adopted and will be reported to the House. And the committee will...
From Washington, NPAC brings you videotaped, gavel-to-gavel coverage of the House Judiciary Committee proceedings. Tonight, impeachment debate, July 29th, 1974. Here is NPAC correspondent Jim Lehrer.
Good evening. For most of you, good evening again. You have just seen 36 men and 2 women making history by answering the role of the Judiciary Committee of the House of Representatives. And for the second time in 3 days, they have voted to recommend to the full House that an article of impeachment be voted against President Richard Nixon. Tonight's article deals with alleged abuses of presidential authority. 7 Republicans joined all 21 Democrats in urging the House to send a bill of impeachment to the Senate on this charge. The final vote was 28-10. Of the 11 Republicans who voted against the first article dealing with Watergate, only one broke ranks tonight. He was Robert McClory of Illinois. Article 2 charges the President of violating his oath of office by failing to take care that the laws be faithfully executed. The article charges him with misusing the Internal Revenue Service, with directing the FBI and Secret Service to conduct unlawful wiretaps, and with allowing a secret investigative unit in the White House to conduct unlawful activities. It further charges that he failed to inform investigative bodies that his aides were interfering with them. And finally, he is charged with misusing those investigative agencies, specifically the FBI, the Watergate special prosecutor, the Department of Justice, and the CIA. In the debate just prior to the final vote, Democrat Don Edwards said this article represents a reaffirmation of the Bill of Rights. However, Republican David Dennis maintained to the very end there was no evidence of the president's committing high crimes and misdemeanors. Paul?
Before proceeding, let's do a brief recap of today's parliamentary developments. The day began when Missouri Democrat William Hungate moved to amend the second article first introduced last week by the Democratic majority, specifically Representative Harold Donahue of Massachusetts. The bipartisan coalition supporting impeachment then beat back attempts to strike out two of the major charges against the president dealing with the Internal Revenue Service, the Plumbers Unit, and electronic surveillance. Two of these attempts were pushed by Republican Charles Wiggins. A third attempt came from Democrat Jack Brooks and was merely an attempt to give the Democrats a chance to detail their charge that the president had misused the IRS. After the debate, the motion was withdrawn. All of the amendments were defeated by better than 2-to-1 margins along the same lines as the vote to impeach for obstruction of justice in the Watergate case. That passed by 27-to-11. The only significant change in language came on an amendment by Republicans William Cohen and Caldwell Butler. The charge specified the president failed to act when he learned his aides were interfering with investigations. The investigations involved the Watergate cover-up, the nomination of Richard Kleindienst to be Attorney General, electronic surveillance, the Ellsberg break-in, and campaign financial abuses.
Let's go now to our reporter down on the Hill, Carolyn Lewis. Carolyn?
Well, it was a day of exhaustion. It was a day when this ragtag army of congressmen and reporters and members of the public who have been waiting in lines all these days were beginning to show the exhaustion was there on the faces, and also I think it showed in the debate. There was not the fire, there was not the anger, there was not the crossing of swords that you had last week. And remember, too, Saturday night was the night when the first article of impeachment was voted, so it was much easier to get around to the vote this time. The ice had been broken. Today you had less parliamentary maneuvering. There was a bit of debate on specific amendments, but everybody was much more cordial, much more willing to bend, much more willing to go along with the rules. And so you had, although it was late tonight when they got to Article 2, the entire proceedings ended on a note, a high note, an optimistic note, and without the great agonizing solemnity that you had on Saturday night. Back to you, Paul.
All right, thank you, Carolyn. To help us appraise the events that have occurred, we have with us Stephen Hess, a political scientist now with the Brookings Institution here in Washington, and Jack Murphy, a law professor at Georgetown University. Gentlemen, what will we be looking for as the committee now continues its debate into other articles? Jack?
Well, I would suggest that particular attention be paid to 3 or 4 things which will come up in the replay of today's activities. The opening part of the committee hearings is marked by a brilliant exchange between Mr. Wiggins and Mr. Danielson on the question of whether or not the charge of abuse of power is a charge of a high crime or misdemeanor such as is required by the Constitution. I strongly recommend close attention to that exchange. I was somewhat disappointed that later on in the argument they didn't develop it more. Secondly, Mr. Wiggins introduced an amendment to apparently assure that the managers of the articles of impeachment in the Senate would have to prove personal presidential involvement in the acts, certain activities of his subordinates. And that amendment was defeated, leaving the suggestion that less than personal presidential involvement would nonetheless be a basis for impeachment. The specificity argument recurs with respect to paragraph 4 of this proposed article, and I would suggest that listeners will observe lawyering at its best and most functional in this particular discussion, worrying over words, seeing whether the internal structure of the paragraph is clear, complete, and fair. Finally, the discussion of electronic surveillance is one, I think, to be closely observed by all Americans, concerned as we are with the penetration of government into our lives. The ambiguities of the law are fairly well spelled out by the various congressmen who argue. I think the ambiguities of fact are fairly cleared up by the close of the discussion when the proponents of impeachment have made a very strong case that the president has acted through his agents in an improper way in the area of electronic surveillance.
Steve, do you see any way that the Republicans may now regroup around the president to save the president in the House?
I think it's highly unlikely, although this committee is not an exact replica of the House. Republicans are slightly more conservative than the full House. Democrats are slightly more liberal than the full House. The committee itself is considerably more junior in seniority. There are 11 freshmen on the committee. Nevertheless, they've given us some very strong clues, and the considerable split in the Republican ranks should be expected. And after all, the Republicans are a minority. They only have 187 votes out of 435. So even a division along these lines would be disastrous in the House for the President.
Gentlemen, thank you very much. Tonight you will be watching nearly 3.5 hours of parliamentary jousting, but behind the arguments over words are very serious attempts to limit the accusations against the President. As you'll see, the President's supporters made little headway with those efforts. In the first hour, Republican Charles Wiggins asked that the abuse of power motion be declared out of order because the abuse of power charge fails to state an impeachable offense, as prescribed by the Constitution. Democrat George Danielson countered by saying that abuse of the oath of office is a uniquely presidential offense.
In hour number 2, Charles Sandman takes issue with complaints about White House dealings with the Internal Revenue Service. Not a single audit was made, Sandman contends. Also in this hour, Larry Hogan explained that one reason the Ellsberg case ended in a mistrial is because FBI records of a wiretap on his phone were delivered to the Oval Office in an attempt to keep them concealed.
In hour 3, Republican Carlos Moorhead argues that it was the President's duty to stop leaks because it meant saving lives of U.S. soldiers in Vietnam. Also in that hour, Joshua Eilberg said Big Brother is no longer limited to Russia, because in this country, secret police have been listening to our phones.
And in the final hour, moderate Republican Hamilton Fish contended the genesis of the plumbers unit was the publication of the Pentagon Papers. Now let's go back to the beginning of the Judiciary Committee's third day of debate as Chairman Rodino calls the committee to order.
The committee will come to order. And before the chair calls upon the clerk in pursuance of the procedural resolution to read Article 2, the chair would like to make several announcements. First, there has been distributed the substitute, which is going to be offered by the gentleman from Missouri, and I have been advised that there is a typographical error which appears on page 2 in paragraph 3, and the word lawfully should be unlawfully. And would the members please correct their copies accordingly, but the clerk will, when the substitute is being read, please ensure that that is noted. The chair would also state that there are other technical changes which will be called to the attention of the committee, and as soon as the clerk has them before him and in typewritten form, they will be called to the attention of the members and properly distributed. I would like to state that there are going to be several roll call votes on the floor of the House, and it is the intention of the chair that following the first quorum call or roll call vote, that there will be a recess for a period of time which will be stated at the time that the recess will be declared, and it is the hope that we may proceed after that and in an effort to resolve this problem. I am going to call upon the clerk, pursuant to the resolution, to read Article 2, and would like to state, too, that the chair will recognize, following that, perfecting amendments in order that we procedurally are able to allow members time for debate then on the substitute for to be recognized for their 5 minutes in accordance therewith if they so seek recognition. I now call upon the clerk to read proposed Article 2. The clerk will read.
Article 2. In his conduct of the office of President of the United States, Richard M. Nixon, contrary to his oath faithfully to execute the office and to preserve, protect, and defend...
I have a substitute.
Hungate.
Mr. Chairman, I have an amendment at the desk. The amendment is in the nature of a substitute to Article 2 of the Donahue Resolution. And, Mr. Chairman, if I may ask the forbearance of my colleagues once more before the clerk reads, there's a further typo on page 2, sub 3. If they would write that in, it's written in at the desk. He has, and then there is an insertion, acting personally and through his subordinates and agents. That is the insertion, and then you resume. This is sub 3 on page 2, line 1. It would read, he has, then you insert, acting personally and through his subordinates and agents, and it proceeds in violation. The clerk will read it in the proper form, and I apologize to the members for my typing skills.
Clerk will read the substitute.
Substitute offered by Mr. Hungate. Article 2. Using the powers of the office of President of the United States, Richard M. Nixon, in violation of his constitutional oath, faithfully to execute the office of President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in disregard of his constitutional duty to take care that the laws be faithfully executed, has repeatedly engaged in conduct violating the constitutional rights of citizens, impairing the due and proper administration of justice and the conduct of lawful inquiries, of contravening the laws governing agencies of the executive branch and the purposes of these agencies. This conduct has included one or more of the following. 1. He has, acting personally and through his subordinates and agents, endeavored to obtain from the Internal Revenue Service, in violation of the constitutional rights of citizens, confidential information contained in income tax returns for purposes not authorized by law, and to cause, in violation of the constitutional rights of citizens, income tax audits or other income tax investigations to be initiated or conducted in a discriminatory manner. 2. He misused the Federal Bureau of Investigation, the Secret Service, and other executive personnel in violation or disregard of the constitutional rights of citizens by directing or authorizing such agencies or personnel to conduct or continue electronic surveillance or other investigations for purposes unrelated to national security, the enforcement of laws, or any other lawful function of his office. He did direct, authorize, or permit the use of information obtained thereby for purposes unrelated to national security, the enforcement of laws, or any other lawful function of his office. And he did direct the concealment of certain records made by the Federal Bureau of Investigation of electronic surveillance. 3. He has, acting personally and through his subordinates and agents, in violation or disregard of the constitutional rights of citizens, authorized and permitted to be maintained a secret investigative unit within the office of the President, financed in part with money derived from campaign contributions which unlawfully utilized the resources of the Central Intelligence Agency, engaged in covert and unlawful activities, and attempted to prejudice the constitutional right of an accused to a fair trial. 4. He has failed to take care that the laws were faithfully executed by failing to act when he knew or had reason to know that his close subordinates endeavored to impede and frustrate lawful inquiries by duly constituted executive, judicial, and legislative entities concerning the unlawful entry into the headquarters of the Democratic National Committee and concerning other matters. 5. In disregard of the rule of law, he knowingly misused the executive power by interfering with agencies of the executive branch, including the Federal Bureau of Investigation, the Criminal Division, and the Office of Watergate Special Prosecution Force of the Department of Justice, and the Central Intelligence Agency, in violation of his duty to take care that the laws be faithfully executed.
Wiggins?
I make a point of order to consideration of Article 2.
The gentleman is recognized on his point of order and will state his point of order.
Oh, I beg your pardon, Mr. Chairman. I'll withhold.
The gentleman will withhold his point of order. Clerk will complete the reading of Article 2.
In all of this, Richard M. Nixon has acted in a manner contrary to his trust as president and subversive of constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, Richard M. Nixon, by such conduct, warrants impeachment and trial and removal from office.
The gentleman from California is recognized on point of order and will state his point of order.
Mr. Chairman, my point of order is that Article 2 fails to state an impeachable offense under the Constitution. May I be recognized on my point of order?
The gentleman is recognized.
Mr. Chairman and members of the committee, it's quite clear from a full reading of proposed Article 2 that the gravamen of that article is an abuse of power on the part of the President of the United States. That concept of abuse is stated in various places by use of the word misuse and in use of the words in derogation of constitutional rights as distinguished from in violation of those rights. The question, ladies and gentlemen, is whether an abuse of power falls within the meaning of the phrase high crimes and misdemeanors, since we can impeach on no other basis. If it does not, then my point of order should be sustained. If it does, then we should proceed with the consideration of that article. My problem, Mr. Chairman, is that I have no quarrel with abusive conduct when that conduct does in and of itself violate the law. If that be the case, then we should impeach because of those violations. I do have serious concern as to whether or not conduct which does not violate the law, but which may be characterized by this committee or the Congress as abusive, falls within the phrase high crimes and misdemeanors. It's apparent from the proposed article that its author believes that abusive conduct is impeachable. My problem is this: just what is abusive conduct? What does it mean? I suggest that that is an empty phrase, having meaning only in terms of what we pour into it. It must reflect our subjective views of impropriety as distinguished from the objective views enunciated by society in its laws. It ought to be clear to this committee, a committee of lawyers, that such a phrase as abuse of power, is sufficiently imprecise to meet the test required by the Fifth Amendment. In my view, Mr. Chairman, the adoption of such an article would embed in our constitutional history for the very first time, the principle that a president may be impeached because of the view of Congress that he has abused his powers, although he may have acted in violation of no law. If that is true, then we truly are ratifying the statement attributed to the now Vice President that impeachment means exactly what the Congress says it means at any given moment. By declaring punishable conduct which was not illegal when done, this Congress is raising the issue of a bill of attainder, contrary to the express terms of the Constitution. The argument of ex post facto legislation is now before us. If we are to declare punishable
give a summary of the kinds of items which support the various paragraphs in the article. We are not presenting the evidence. So I will vote against the amendment of the gentleman from California, but I do hope that some of our draftsmen who are supporting the Article 2 will jot down some additional specifics and offer an additional amendment so we can clarify the objection raised by the gentleman from California.
Mr. Chairman.
Mr. Hogan and inquire of the gentleman who drafted this article as to whether or not he is prepared, as we have been prepared in the past, to list a number of the specific instances to which you are referring. In addition to the break-in into Dr. Fielding's office, I think a particular concern might be the matter that Mr. Hogan mentioned just prior to the break, and that was the activities involving the transfer of FBI records from the FBI to the Oval Office at the direction of the President. Could the gentleman from Missouri help us out in that regard as to whether or not he'd be in a position to delineate some of the specific items upon which he intends to rely upon the proof of this case?
I thank the gentleman for yielding. The language of 4, if you refer the first few lines of that, as it would concern, when you talk of concerning other matters, he has failed to take care that the laws were faithfully executed by failing to act when he knew or had reason to know that his close subordinates, etc. Now, we're talking of situations of which he should know or should have good reason to know. And as we have said earlier, the doctrine of impeachment cannot really be very narrowly confined. It's as broad as the king's imagination. It has to be. If you'll confine it closely enough, there will be somebody figure a way around it. What about the Kleindienst situation? The testimony, the evidence before the committee was that, as I recall it and would state it, that Mr. Kleindienst received what we would call a chewing out from the President in rather plain and forceful, clear language, and concerning a specific matter. And then when he was before the Senate committee, they were asked if anybody had approached him concerning the same matter, ITT as I recall, and he in effect said, well, he might have casually mentioned it. Well, I'm telling you, the chewing he got was such you'd remember it no matter who gave it to you, and certainly if it came from the President, he remembered it. Now, still we find him, the President, after this date, going before the American people and saying, when he knew that this testimony had been given, and when he had reason to know that the testimony was not true, and upholding the testimony of Mr. Kleindienst in that situation. Now, there are other examples, I am told, in the Jaworski considerations, in the false gem cables. These are the sort of things that would be covered here. I yield back to
Mr. Chairman.
Just a moment. How much time has the... Will the gentleman please defer? There are 6 minutes that have been consumed in opposition and 4 minutes in support, and therefore...
Mr. Chairman. Mr. Chairman.
Mr. Waldy.
Mr. Chairman, I rise in support to the amendment. And the reason I do is because we were specific in our allegation in the first portion of that paragraph where we limited the failure to faithfully execute the laws to the unlawful entry into the headquarters of the Democratic National Committee. Now, I happen to believe that the matter of Mr. Kleindienst and the antitrust case might very well fall within the provisions of a general allegation of paragraph 4, but we allege specifically the break into the Democratic National Committee, and we threw in just absolutely as an afterthought those last 4 words, and concerning other matters. And I have not at all concurred in what I have thought to be the objective of my friend and my colleague from California, Mr. Wiggins, to limit and narrow this inquiry so precisely that the proof that could be adduced would almost be prohibitive in our ability to produce it. But in this instance, I think, we have strayed so far into generalities that we would be well advised to adopt his amendment, and we would, in so doing, in my view, do no violence to our standards of fairness and do no violence to our obligation to have an opportunity to consider and to introduce all proof necessary that bears upon impeachable offenses of the President. So I support the gentleman from California.
Mr. Chairman.
Would the gentleman yield?
Yes, I'd be happy to yield.
I think there's some thrust to what the gentleman says, but I do think that we ought to take into consideration the point that has been made that in this take care paragraph here, there are other unlawful activities which took place to which the responsibility of the President ought to run and which ought to be provided as part of the proof with respect to this paragraph. So it seems to me there's a choice available between simply eliminating the clause and having nothing and developing a language that provides a more definite standard than the language that is contained at the end of this paragraph. And I would suggest to the gentleman that if we could develop that language, it would enable us to maintain the substance of what we are talking about here, which the gentleman from Illinois referred to somewhat earlier, and yet meet the basic thrust of the objection of the gentleman from California.
Well, the gentleman.
I yield to the gentleman from Arkansas, Mr. President.
I thank the gentleman for yielding. I would like to suggest that we give some attention to the result of this amendment, if adopted, in too narrowly defining the inquiry of this article, particularly in that it would, in my view, exclude the cover-up of the unlawful entry into the Democratic National Committee, or at least the second stage of that cover-up, when what was then being considered was the failure of the President himself to advise the Department of Justice of the involvement which he knew of his own men in the cover-up which had occurred. The language as it would read, if this amendment were adopted, would limit this failure to take care only to those acts surrounding the unlawful entry into the headquarters of the Democratic National Committee. If you were to add "and the cover-up thereof," it might improve this amendment. However, that is not included, and the effect of the amendment as adopted will, in my view, limit the thrust of this paragraph 4 to the break-in itself and nothing further.
Will the gentleman yield?
Mr. Chairman.
My time, Mr. Chairman, and I only want to respond to Mr. Thornton's point, which I think is well taken. If the language is limited only to a consideration of events leading up to the unlawful entry and not attempts to frustrate the inquiry into events subsequent to the unlawful entry, the cover-up, then I think his point is awfully well taken. It was not ever my understanding that the initial words were limited only to the unlawful entry and that we included the cover-up in the words "and concerning other matters." If we had to include the cover-up by putting in the phrase "and concerning other matters," it's incredibly poorly drafted. My own impression is, and I'd have to refer to the author, that the original words involving the break-in of the headquarters of the Democratic National Committee included both the entry as well as the cover-up, and concerning other matters has nothing to do with the Democratic National Committee burglary, entry, or cover-up.
Mr. Chairman, Mr. Chairman, I have a perfecting amendment at the desk.
The gentleman is recognized. The clerk will read the perfecting amendment.
Amendment by Mr. McClory. In the Hungate substitute, strike from subparagraph 4 the word "matters" and insert in lieu thereof the following: unlawful activities.
Mr. Chairman, this amendment
How do we get such an amendment in order at this time? There's an amendment, gentleman from California, pending, and I would respectfully submit that either an amendment must be offered to the amendment or an amendment must be offered in the nature of a substitute to the amendment. And I don't believe that a so-called perfecting amendment which ignores the appending amendment, goes back to the original text, is in order.
Both perfecting amendments can be pending at the same time. This is a perfecting amendment and therefore would take precedence over any other amendments. One may be, the vote would occur first on the McClory perfecting amendment.
But if the chairman would hear me further, I suppose the chair must know the parliamentary law better than I do, but while I've heard of perfecting amendments, this is the first time I've ever seen a pending amendment taken off the floor in this manner. I think you have to address something to the pending amendment, either a substitute or something to perfect it or change it. Well, I made my point.
The gentleman has stated parliamentary inquiry, and the chair has stated that the perfecting amendments can both occur. The perfecting amendment of the gentleman from McClory is only offered as such, and therefore the chair will state that what will occur now will be that the gentleman from Illinois will be recognized for his perfecting amendment, and a question would take place on that.
Mr. Chairman, all that this perfecting amendment does is to delete the word matters and substitute the word unlawful activities. What we're talking about here really are unlawful activities of those who are who were employed in the White House and who operated during this period prior to and subsequent to the Democratic National Headquarters break-in, and who were involved in all of these other unlawful activities to which we've made reference. The burglary of Dr. Fielding's office, the perjury with respect to Mr. Kleindienst's confirmation, and a number of other matters, too, that we're aware of. And I don't think there's any, it would certainly be inadequate on our part to recommend to the House of Representatives that they consider only the bare breaking in of the Democratic National Headquarters when so many other more serious matters are things that we've investigated and which are involved and which they should consider. I'd like to call attention to the fact that this charge, this Article 2, is in the nature of a civil charge or complaint, and it's something which upon which the respondent, of course, is well aware. This is stated with definiteness. There's no doubt or uncertainty as to what we're talking about. There shouldn't be any question as to the President being apprised of what's involved in this paragraph. And if we merely include the word unlawful activities, it will include these other matters. We don't have to delineate a long line of matters which are involved in the criminal conduct of, 20 different people who are engaged there. What we're talking about is a pattern of conduct or a pattern of misconduct. And we include, of course, the initial break-in of the Democratic National Headquarters, plus these other things that are also involved, in which we will be sending our articles to the House for their consideration and their judgment.
Will the gentleman yield?
I yield for a question. If the gentleman wants to make a question, I think he can get time.
Well, I'm asking for a question.
Sure.
That's correct.
I'm happy to yield to the gentleman.
I was just wondering whether the gentleman from Illinois felt that making it read concerning other unlawful activities instead of concerning other matters really advanced us very far as specificity is concerned, which I had understood the gentleman was concerned with a moment ago.
Well, yes, I'll say that it does, because we're not talking about other matters, other kinds of conduct that are not unlawful or anything that isn't in the nature of a criminal act or some serious wrongdoing. And so if we say that it's unlawful activity which we're concerned with, I think it apprises the President of what is involved.
Will the gentleman yield? Could the gentleman yield to me, please?
Yes, I'm happy to yield to the gentleman from Missouri.
I would like to indicate on my part that I would be pleased to accept the perfecting amendment of the gentleman from Illinois.
Thank you, gentlemen.
question is on the perfecting amendment.
The question is on the...
Perfecting amendment by Mr. McCrory.
The question occurs on the perfecting amendment by Mr. McCrory.
Parliamentary inquiry.
The gentleman will state it.
What happened to my amendment?
Your amendment is still pending.
We expect to vote on it shortly, do we? Thank you.
The gentleman's amendment will be voted on after the McCrory question has been put to the committee. The question is on the amendment of the gentleman from Illinois. All those in... The gentleman will state it.
There were further refinements which might be made in the perfecting amendment of Mr. McCrory by specifically spelling out some of the areas of inquiry. Would I be foreclosed after this vote from introducing such a perfecting amendment of the perfecting amendment of Mr. McCrory?
No, the gentleman would not be foreclosed.
I thank the chairman.
The question occurs on the amendment offered by the gentleman from Illinois, Mr. McCrory, as a perfecting amendment. All those in favor, please say aye. Aye. All those opposed? No. The ayes appear to have it. The ayes have it. Mr. Butler?
Mr. Butler is in the throes of drafting a perfecting amendment with Mr. Gentleman from Maine.
There is no amendment before the desk. Oh, the gentleman's amendment, Mr. Wiggins' amendment.
Mr. Chairman?
Excuse me, Mr.
Chairman? Could I ask a could I make a parliamentary inquiry?
The gentleman will state it.
If Mr. Butler is in the throes of drafting, and I hope he's drafting it quickly, then will he have an opportunity at that point, before we vote on the gentleman from California's main amendment, will he have a chance to offer his amendment? No, I'm just wondering if I could...
The chair wishes to state that the parliamentary situation is that the gentleman's amendment from Illinois hasn't been adopted as a perfecting amendment. The only amendment that now is before the committee is the amendment which was offered by the gentleman from California.
Well, then, Mr. Chairman, I wonder if we could have a 5-minute recess.
Parliamentary inquiry, Mr. Chairman.
If Mr. Klein can read it.
Parliamentary inquiry, Mr. Chairman.
Mr. Hogan?
My parliamentary inquiry, Mr. Chairman, is this. If Mr. Butler's amendment is to be in order and be considered, isn't it true that the rules require that this amendment be in writing at the desk?
The gentleman is correct.
So then I would assume that Mr. Butler would have to write it and have it duplicated and presented at the desk before it can be considered by the committee.
Mr. Chairman, I have a perfecting amendment at the desk.
The gentleman is recognized.
Mr. Chairman,
the clerk will read the amendment.
Amendment by Mr. Seiberling. Add at the end of subparagraph 4, by employees of the executive branch or the committee to re-elect the president.
Mr. Chairman, if I may be recognized to speak on my amendment.
Mr. Chairman, I'd like a copy of the amendment.
Committee will be in order until the clerk reads the amendment.
Amendment by Mr. Seiberling. Add at the end of subparagraph 4, by employees of the executive branch or the committee to re-elect the president.
Order against the amendment, Mr. Chairman.
Well, if I may be heard to speak on the amendment.
Would the chair hear my reservation of a point of order?
Is the gentleman reserving his point of order?
Yes, I'm reserving.
Mr. Chairman, may I be heard on my amendment?
The gentleman is recognized.
It seems to me that the objections to the amendment raised by Mr. Wiggins, or to the paragraph, are not entirely cured by the perfecting amendment of Mr. McClory, because crimes and unlawful activities go on all over the United States every day, and at least we ought to tie it down to those that we're really concerned about. And my perfecting amendment makes it clear that we're talking about other unlawful activities by employees of the executive branch or the committee to re-elect the president, which it seems to me cover enough of the activities that are before us here to get in all of the evidence that we have been considering, and that's why I offer the amendment. Yes, I'll use it.
You cover all unlawful activities of all employees of the executive branch. I assume that under your amendment, if a clerk steals $100 in the post office in Indianapolis or someplace like that, that's included.
Well, we have a record before us, Mr. Dennis, that's pretty clear what employees we're talking about, and it seems to me that that's sufficient.
Would the gentleman yield?
Yes.
I'd like to suggest that the language concerning other unlawful activities does not need any further limitation, since it refers back to the language at the beginning of subparagraph 4, which refers to failing to act when he knew or had reason to know that his close subordinates endeavored to impede and frustrate lawful inquiries by duly constituted executive, judicial, and legislative entities concerning, and then you have two concerning clauses, one the unlawful entry, and the other one would be concerning other unlawful activities, but that would relate back to the activities of the close subordinates and would be consistent with the theory of this paragraph as I understand it as advanced by the gentleman from Illinois.
If the gentleman from Ohio will yield, I'd say that that is correct, and I think that the language would be confusing if we accepted the additional language offered by the gentleman.
Well,
from,
if that is
Ohio.
the interpretation in the record, why, I think that does clarify matters, but the mere words standing alone, other unlawful activities, I don't think are sufficiently clear. Well,
but the gentleman would yield further. The other unlawful activities refers to the close subordinates, and I think those are the only ones we want to direct our attention
all right.
to.
Well, I'll ask unanimous consent to withdraw my perfecting amendment.
Without objection.
Without objection, the amendment is withdrawn. The question is still on the amendment of the gentleman from California. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? No. And those appear to have it?
On that, I request the yeas and nays.
The call of the yeas and nays is demanded, and the clerk will call the roll. All those in favor of the amendment, please signify by saying aye. All those opposed, no. The clerk will call the roll.
Mr. Donahue?
No.
Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde?
Aye.
Mr. Flowers?
Aye.
Mr. Mann?
No.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drinan?
No.
Mr. Rangel?
No.
Miss Jordan?
No.
Mr. Thornton?
No.
Miss Holtzman?
No.
Mr. Owens?
No.
Mr. Mezvinsky?
No.
Mr. Hutchinson?
Aye.
Mr. McClory?
No.
Mr. Smith?
Aye.
Mr. Sandman?
Aye.
Mr. Railsback?
Aye.
Mr. Wiggins?
Aye.
Mr. Dennis?
Aye.
Mr. Fish.
No.
Mr. Maine.
Aye.
Mr. Hogan.
No.
Mr. Butler.
No.
Mr. Cohen.
No.
Mr. Lott.
Aye.
Mr. Freilich.
Aye.
Mr. Moorhead.
Aye.
Mr. Mariziti.
Aye.
Mr. Latta.
Aye.
Mr. Rodino.
No.
Mr. Chairman,
Clerk will report.
14 members have voted aye, 24 have voted no.
And the amendment is not agreed to.
Mr. Chairman,
Butler.
in order that the membership may understand, I'm in the process of preparing an additional amendment, which I would rather than draft it in haste, I will prepare it and submit it at a later time when we get to this paragraph, if that is in order.
The amendments are in order at any time. However, in order to give the gentleman the opportunity to draft his amendment, the chair will proceed with the recognition of members under the 5 minutes which they're entitled to under the substitute amendment.
I thank the chairman.
Although the votes have been going against the president's supporters, they have not given up their efforts to persuade their colleagues to vote as they think they should be voting. NPAC's videotape coverage of the House Judiciary Committee's impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service.
You've broken off the engagement and you haven't told her yet? Well, that's pretty cool, Cathcart, I must say. That's pretty damn cool. You utter swine. Who the hell do you think you are coming here and jilting my sister? An utter swine, of course.
Captain Cathcart has been found shot dead.
Good God.
The police suspect foul play.
Poor devil. Oh, poor little Mary, too.
Oh, God. Oh, Jerry, you killed him!
The ATP Summer Tennis Tour will attract world-famous players competing for top prize money. Stan Smith, Arthur Ashe, Marty Reeson, Chris Evert, Yvonne Goolagong, Rod Laver, and Bjorn Borg are just a few of the players you'll see in major tournaments, like the Canadian Open in Toronto, the U.S. Clay Court Championships from Indianapolis, and the U.S. Professional Championships from Boston. All great tennis, all on this station, all summer long.
Surface is like the skin of an apple. To disturb it is to destroy it.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
Now, as we go back to the hearings, the members are arguing over the language for a second impeachment article.
Mr. Wiggins.
I just have a question of the chairman. There are pending at the desk several motions to strike.
That is correct.
And I, by reason of not calling them up at this time in advance of what we call a general debate with respect to the entire article, I hope that there is no waiver of that right. It would be my hope that we would continue to discuss it under the 5-minute rule, and at the conclusion of that, a member might be recognized for an appropriate motion to strike, if that be his intention.
Well, the gentleman may at any time be recognized for that motion to strike. And the amendments are at the desk now, and the motion to strike, if it's the gentleman's desire to heard on the motion to strike at this time, the gentleman will be recognized in preference to recognition of the members on the question of debate on the substitute.
Well, it's going to be done sooner or later, Mr. Chairman. I call up number 2.
The gentleman is recognized. The clerk will read the amendment.
Amendment by Mr. Wiggins. In the Hungate substitute, strike subparagraph 2.
Mr. Wiggins.
I thank the chairman for yielding. Members of the committee, as we all know,
You're not going to strike out one?
as we all know, subparagraph 2 is directed primarily to the area of electronic surveillance for alleged national security purposes. Since that subject has not been debated before this committee, my motion to strike is to focus our attention on that subject. I would hope to yield to other members on either side who have thoughts with respect to that. Mr. Chairman, are we operating under the unanimous consent provision?
That is correct. 20 minutes for those in favor and 20 minutes in opposition.
All right. I should like to set the focus for this debate concerning electronic surveillance by recalling that these individual wiretaps commenced early in 1969 and continued for approximately a year thereafter. We have before us a series of specific wiretaps which form the basis of this allegation of abuse of power by the President. They can be categorized, I think, into the following 4 groups. First, the 17 wiretaps, which were authorized by the Attorney General, and at least the allegation is made by the President that they were instituted in the interest of national security. In addition to that, we have before us evidence with respect to 3 other wiretaps instituted by Mr. Ehrlichman concerning employees in the White House. And with respect to that, the evidence does not extend to any presidential involvement or knowledge. And then we have 2 isolated wiretaps, which I'll let the gentlemen characterize, ladies and gentlemen, characterize as they wish. We have Donald Nixon, and we have the wiretap of Joe Kraft. Now that covers the evidence with respect to wiretaps before us. The clear bulk of that evidence involves 17 wiretaps which were commenced in the spring of 1969. I want to set the focus of the debate by making one assertion which I believe cannot be contradicted. And that is that the law with respect to wiretaps, which are genuinely and honestly in the national interest, is that the President does have that authority in 1969, and he has that authority today. It is improper to infer that it is illegal to install a wiretap which relates to national security matters. The sole question is whether, in fact, the President had that motive, or whether this was merely a subterfuge to install wiretaps for some other purpose, there can be no question that even today, subsequent to the Keith case, that wiretaps installed by the President for a national security purpose are authorized by Congress, at least have not been prohibited by Congress, and have not been prohibited by any decision of the United States Supreme Court. That being the case, Mr. Chairman, we should focus our attention on the evidence with respect to the bona fides of the President in installing these 17 wiretaps. If they were in fact pursuant to his concern about national security interest, they were lawful and they cannot be condemned in these proceedings. But if in fact they were installed for other purposes, then I would concede that they would be probably unlawful and perhaps should be considered by this committee in an impeachment context. Now, back in 1969, this nation was involved in a war in Southeast Asia. This nation was also involved in sensitive negotiations with the Soviet Union with respect to arms limitation. We have had evidentiary materials in abundance, ladies and gentlemen, that there were leaks concerning the bargaining position of the United States vis-a-vis the Soviet Union, which caused enormous concern by the President's top advisors and by the President himself. There can be no question at all, that Henry Kissinger was greatly concerned about these leaks. And as a result of those leaks, a system of wiretaps on possible sources of those leaks were instituted by the President. I'm willing to attribute those directly to the White House and directly to the President. Those wiretaps were there. What does the Chairman propose to do? Have I used my 5 minutes? Let me finish my sentence then, and I shall yield to others. Those wiretaps were in each case approved by Mr. Hoover, who was then FBI Director, and in each case were approved by the Attorney General. I would hope that the debate hereafter will focus upon the bona fides of the President's intentions with respect to the installation of those taps.
The gentleman from Wisconsin, Mr. Kastenmeier, is recognized for 4 minutes.
On this section was really already begun this morning by the gentleman from Maryland, Mr. Hogan. I think this particular section of Article 2 is central to the whole theme of abuse of power. As a free country, we have no higher course than to protect really our people against this sort of abuse of power which can come in a modern age in terms of a police state. What we did as a Congress, and in fact as a committee, in 1969 to limit the use of electronic surveillance and wiretapping is as follows. In the Omnibus Crime Control Act of 1968, which came out of this committee 6 years ago, we said that if any lawful authority is to conduct wiretapping or electronic surveillance, it must have a court order except, and I shall read, that the power of the President to take such measures as he deems necessary to protect the nation against the following threats, mind you. 1, the actual or potential attack or other hostile acts of a foreign power. 2, to obtain foreign intelligence information deemed essential to the security of the United States. 3, to protect the national security information against foreign intelligence activities. And lastly, to protect the United States against overthrow by force or other unlawful means, or against any other clear or present danger to the structure or existence of the government. Now, there have been a number of classes of wiretaps, some of which have been alluded to by the gentleman from California, Mr. Wiggins. Not necessarily in order of time. The one referred to by the gentleman from Maryland, that in 1970 by the Secret Service on Donald Nixon, which I agree any reasonable man has to assume occurred with the knowledge, consent by the direction of the President himself, and subsequent wiretaps and bugging, whether in Watergate or implicitly in the Houston Plan, or those undertaken for the President by Mr. Ehrlichman in terms of Mr. Liddy or Mr. Kraft abroad, or the 17 wiretaps, point to a pattern of use of taps which do not conform to the law as passed by this Congress in 1968, and I submit are not otherwise authorized by any other decision of the court or by law. Let us go back to the very beginning. How did we ever get there in the first place? How did the President happen to start engaging in wiretaps without any court order in such a melange of activities? As you know, in any event, the procedure was that all taps would go through the Attorney General of the United States for his approval, whether or not these are warrantless wiretaps, and would be recorded, carried out by the FBI and duly recorded. And as the fact was, later in the year 1971, sensitive about these taps, Mr. Mardian delivered this list of the special White House taps to the White House itself, in fact, to the Oval Office, to be secreted in a safe by Mr. Haldeman. In 1969, apparently following a New York Times article.
The gentleman from California wishes to yield.
Yes, Mr. Chairman, I yield to the gentleman from California, Mr. Moorhead. 5 minutes.
The gentleman is recognized for 5 minutes.
Yes, Mr. Chairman. During the SALT negotiations, a study was published in the New York Times on June 18, 1969, which spelled out our analysis of the Soviet Union's strategic strength and first strike capability. Henry Kissinger said each of these disclosures was of the most extreme gravity. As presentations of the government's thinking on these issues, they provided the Soviet Union with extensive insight as to our approach to the SALT negotiations and severely compromised our assessment of the Soviet Union's missile testing and our apparent inability to accurately assess their exact capabilities. Another leak involved the alternatives for ending the Vietnam War. One alternative to be studied was unilateral troop withdrawal from Vietnam. Henry Kissinger said concerning this leak, this disclosure was extremely damaging with respect to the government's relationship and credibility with its allies. Although the initial troop withdrawal increment was small, the decision was extremely important in that it reflected a fundamental change in the United States policy. Certainly, this gave to foreign agents information concerning the United States' capability and plans which were harmful to our position. If the President of the United States had not taken steps to determine where the leaks were coming, he would not have been carrying out his constitutional government to take care of our nation and its people. I submit to you that when such a leak takes place at a time when we are at war, when our troops could lose their lives, it is the responsibility of the President to find out where those leaks are coming from and stop them. And that's just exactly what he did. The 17 wiretaps were instigated for the purpose of discovering the sources of these leaks. I know that in the testimony that's been given to our committee, there was a question raised as to the effect of the wiretapping in solving the leaks. Mr. Colson, in his live testimony before this committee, answered that question. He told us that as a result of wiretappings, we were definitely able to close one of the major leaks that had occurred and therefore perhaps save the lives of many of our troops and help this country for the future. I think this grounds for impeachment is the weakest of all of those that have been brought up. Certainly, there is no grounds to impeach a President of the United States in his attempt to save the lives of our troops and the safety of our nation.
Mr. Chairman.
I'll yield back my time to Chuck Wiggins.
Gentleman from California.
I want to just make a few observations about the legality of these taps. This matter has been before Congress before. Congress has not legislated into the field. It's well to remember that former Attorney General Elliot Richardson, testified before the Senate expressing his opinion that if in fact we are talking about national security wiretaps, it was wholly legal then and remains so today. That is also my recollection of the testimony of Attorney General Peterson before my friend from Wisconsin subcommittee not too long ago when this subject was before it for consideration. I yield the balance of Mr. Moorhead's time to the gentleman from Indiana.
The gentleman is recognized.
Mr. Chairman, just a word on this legal situation. None of us like wiretaps very well, but we're talking here about what was legal and what was proper as of the time it was made and as of the time today. Now, at the time of the wiretaps we're talking about, I agree with Mr. Wiggins. The question is, was national security involved? That's a factual question. But if it was, there was nothing illegal about these wiretaps, and it's very doubtful that there's anything illegal today. It had been held, for instance, in the Third Circuit that you could have a warrantless national security wiretap used to stem the flow of information out of the government. And the contrary had never been held at the time we're now talking about. Now, and you got to think of the climate, as has been said. We were having leaks about the Pentagon Papers, about the SALT talks, about Vietnam, and Henry Kissinger said the leaks about the troop withdrawals.
1 minute of the gentleman has expired.
Have I only got 1 minute?
The gentleman from California had 5 minutes, and he had consumed 4 minutes and had 1 minute remaining, but he yielded it to the gentleman from Indiana. The gentleman still has 10 minutes in support of the
I
amendment.
will yield in a few moments to the gentleman from Indiana. Let it go to the other side.
The gentleman from California.
Thank you, Mr. Chairman. And I rise in opposition to the motion to strike. These 17 wiretaps started on May 12, 1969, as a result of the Beecher article in the New York Times that told the public about the secret bombing of Cambodia. And I want to correct the record right now. The SALT talks had nothing to do with it. There has never been an allegation that these 17 wiretaps were triggered by any SALT leaks. And there's nothing in our evidence to so indicate, nor did it have anything to do with the Vietnam War, nor did these taps have anything to do with leaks about the Pentagon Papers. That didn't come till nearly 2 years later. And you, on your time, my friend, you can straighten it out, but that is the fact. I think it's really more important to point out what was done with the information that resulted from these leaks, from these wiretaps. Mr. Hoover, the director of the FBI, would send them to the White House, to the President, and a total from 1969 to 1971. They went on for more than 2 years. There were a total of 104 summaries sent. And what happened? It was found that there had been no leaks of confidential information from these 104 summaries. Nobody went to jail. Nobody was charged. Nobody lost their job. Nobody was transferred. There were 6 or 7 members of the National Security Council who had their telephones tapped, 4 newsmen later, and several White House employees. Most of these people had no access to any confidential information whatsoever. And as I pointed out earlier, the summaries indicated that no leaks were going on. Well, how was this information used by the White House? On December 29, 1969, Mr. Hoover wrote to the President and said that former Secretary of Defense Clark Clifford was about to write an article in Life magazine attacking Mr. Nixon on his handling of the Vietnam War. And part of Mr. Clifford's attack was to be regarding Mr. Nixon's criticism of President Tew. Well, immediately this triggered political action by the White House. Staffers immediately took instant action. Presidential Assistant Butterfield wrote Magruder, quote, "The name of the game, of course, is to springboard ourselves into a position from which we can effectively counter whatever Clifford takes." The suggested methods of countering Clifford's article were sent to Haldeman, the chief political advisor to President Nixon, and included a proposed discrediting of Clifford by the use of his prior statements or a counter article. Haldeman directed Magruder to be ready to react and suggested finding methods of pre-action. Mr. Haldeman concluded, quote, "The key now is to how to lay groundwork and be ready to go, and let's act." Mr. Ehrlichman characterized the Clifford information as, quote, "the kind of early warning we need more of." And he noted to Mr. Haldeman, "Your game planners are now in an excellent position to map anticipatory action." The basic nature of the material developed from these 17 wiretaps and sent to the White House was political and personal. There were no leaks. The FBI was presumably sending what the White House wanted, and certainly the flow of the information was not stopped by the White House when the character of the material became obvious. The material, in addition to the political information on Clark Clifford, it contained reports on how certain senators were expected to vote on legislation, on the activities of critics of the administration policies, on the campaign plans of Senator Muskie. Incidentally, 2 people who left the White House and went to work for Senator I'm going to take 3 more minutes, Mr. Chairman, please, of the 20 minutes.
The gentleman has consumed 4 minutes.
4 minutes, I'll take 2.
Gentleman is recognized for 2 more minutes.
And on the social habits and political plans of White House employees. The material had no conceivable relevance to national security, but only could have had political value. I personally reviewed many of these summaries, and that the FBI sent to the President, describing what was said over the home telephones of those people under surveillance. And I want to be careful not to describe any of the information in such a way as it could get back to or trace to the people involved. Suffice to say, the conversations were those of citizens, their wives, their children, chatting on the telephone with acquaintances and close friends, confiding their joys, their sorrows, their anxieties about their personal lives, and in some instances, their observations about political and social events of the United States. These telephone calls were like any calls between close friends where personal disclosures are made only for the ears of the other end, at the other end of the line. And some of the information would be terribly embarrassing if it were heard by third parties. The summaries themselves are the strongest evidence of the wisdom of Mr. Justice Holmes' description of wiretapping as a dirty business. The President authorized these wiretaps. He didn't stop it when they almost immediately found out that they were non-productive. He knew about them. He discussed them with John Dean on February 28, 1973. He was talking about 2 of the men who were being tapped, and he said to John Dean, "Incidentally, didn't Muskie do anything bad on these?" To share with you how the FBI felt about it, this is what 2 agents said in a memorandum on October 20th, 1971. They were talking about why there were no regular records kept of these taps by the FBI. This is what the 2 FBI agents said. Quote, "It goes without saying that knowledge of this coverage represents a potential source of tremendous embarrassment to the Bureau and political disaster for the Nixon administration. Copies of the material itself could be used for political blackmail and the ruination of Nixon, Mitchell, and others."
The gentleman has consumed 2 more minutes. 10 minutes now remaining for those in support of the amendment and 10 minutes remaining in opposition to the amendment? The gentleman from California?
I yield 5 minutes to the gentleman from New Jersey.
Gentleman from New Jersey, Mr. Marizzi, is recognized for 5 minutes.
I support the motion of gentleman from California, Mr. Wiggins. There was clear legal authority for the warrantless national security wiretaps at the time that the 17 wiretaps were conducted. The former Attorney General, Mr. Richardson, and referring to case law, has stated that the Department of Justice is justified in relying on lower court decisions permitting national security wiretaps. And let me say that I certainly agree with what has been said here today, that we must look at the circumstances to justify wiretaps on the basis of national security. But I believe that the circumstances surrounding these wiretaps demonstrate clearly that they involve national security. Now, as has been discussed, we know the government at that time, and we must look back. We cannot look as of today. The government was faced with massive leaks of sensitive foreign policy information when the president was just beginning to establish policies of future relations with other nations. These leaks began in the spring of '69, when President Nixon was exploring the solutions to the Vietnam War. These leaks were damaging to the diplomatic efforts being made to end the war at that time. And I disagree with the gentleman from California, Mr. Edwards, that these wiretaps had nothing to do with the Vietnam War. Let's listen to Henry Kissinger and see what Henry Kissinger thought. And here's what Mr. Kissinger thought. Quote, each of the above disclosures were extremely damaging with respect to this government's relationship and credibility with its allies, with the South Vietnam government to hear publicly of our apparent willingness to consider unilateral withdrawals without first discussing such an approach with them, raised a very serious question as to our reliability and credibility as an ally. It had a great deal to do with the Vietnam War, according to Mr. Kissinger. And I think he's an authority in this area. Some of the most damaging leaks occurred with regard to the SALT negotiations. And despite what the gentleman from California states, the SALT negotiations were involved. On January 20th, 1969, when the president first took office, he immediately directed that an overall study be undertaken regarding the United States strategic force posture for the internal use of the government and for the use in the SALT negotiations. Now, notwithstanding the need for secrecy of this study, and it's obvious, the May 2nd, 69 edition of a large newspaper reported 5 strategic options under study. These options were published in the press in advance, before they were considered by the National Security Council of the United States government. The damaging nature of these disclosures was summed up by Henry Kissinger again. He said each of these disclosures was of the most extreme gravity, as presentations of the government's thinking on these key issues. They provided the Soviet Union with extensive insight as to our approach to SALT negotiations. And I say again, they had a reference, these wiretaps, to the SALT negotiations. Now, let me say that the results of the wiretap in several instances were fruitful. Now, we must realize that when wiretaps are placed, certainly they will pick up certain personal items that we're not interested in, but in this particular case, the results were successful in a number of instances. The FBI reported that several of the National Security Council staff members
had extensive contacts with members of the press. In particular, 2 employees, X and L, discussed many aspects of the internal workings of the National Security Council with a newsman.
The gentleman has consumed 5 minutes.
Mr. Chairman. May I ask one more moment to finish?
The gentleman's time has expired at 5 minutes.
One more moment. Thank you.
The gentleman from Pennsylvania is recognized for 3 minutes.
Mr. Chairman, I oppose the motion to strike. We're told that national security is involved, but I'd like to suggest that the mere assertion of national security is not enough. The gentleman from Wisconsin has given the criteria, and I think the members can read for themselves and see that the criteria have not been met, but more importantly, they've seen the excerpts for themselves, and I'm sure that the memory of these excerpts is present in the minds of all the members. Certainly, I remember them very vividly and perhaps have reason to. Let me say, Mr. Chairman, that Mr. Nixon himself, on February 28, 1973, that the tapes were a joke, that these taps were a joke, that they never had approved anything. It seems to me, Mr. Chairman, that this was an adventure into the private rights of individual citizens. And I'd like to discuss for a moment just what the use of wiretaps and secret listening devices means in a free society. I'm sure we all remember the stories on television, the movies and books about spying, which has gone on in Nazi Germany and in the Soviet Union. We've learned that in Russia you must never have a serious conversation without turning on the water or radio so the conversation could not be heard by the secret listening devices. It's also an axiom that the telephone is tapped, so in Russia everyone takes long walks in the park so they can communicate. It's become an article of faith that in Russia Big Brother has arrived and the secret police are always listening. Now we learn that in the late 60s and early 70s, and possibly right up to this date, secret police have been listening in America. Only now they have special equipment to eliminate the noise of running water or loud radios. In Washington, it's become a sardonic joke to say that the phone is tapped whenever there is a strange noise on the line. We've become a suspicious people, afraid to talk freely, not because of what we say might prove that we've committed a crime or endangered the national security, but because our political enemies might use this information against us. Mr. Chairman, the Nixon White House made the secret police a reality in the United States. The President and his men knew that what they were doing was so morally repugnant that they could not even trust the FBI to keep records of their activities. Finally, they could not even trust their own subordinates, so the files were taken to the Oval Office of the White House and then locked in the safe of the second most trusted advisor. Mr. Chairman, in addition to everything else, it seems to me that various crimes have been committed, and we are discussing now, it seems to me, not one of the least important, but one of the most important of the impeachable offenses. And when it comes time for general debate on paragraph 2, I intend to point out some of the criminal violations that are involved. I thank you.
The gentleman has consumed 3 minutes. The gentleman from California.
Only to the gentleman from New Jersey.
Thank you for yielding.
The gentleman is recognized.
In conclusion, Mr. Chairman, the records of the FBI show that the information that was obtained by these wiretaps was put to good use to prevent further leaks. And certainly I concur with what has been said here today, that the President committed no illegal act in instituting these wiretaps, and indeed he would have failed in his constitutional responsibilities if he did not attempt to prevent further disclosure of national security information. And I, for one, Mr. Chairman, would say that, in fact, that the President did not act to stop these leaks in the interest of national security, I would vote to impeach him for his failure to do so.
The gentlelady from Texas is recognized for 3 minutes.
Thank you, Mr. Chairman. Would you turn this on? Mr. Chairman, there is no question about the right of the President to institute warrantless wiretaps even in the interest of national security. We don't quarrel about that. Date back 1940, President Roosevelt, in a memo to his Attorney General Jackson, stating that it is in the interest of national security to prevent subversive activities, to instigate these warrantless wiretaps. But that's not what we're concerned about. We concede the right to issue instigate, authorize wiretaps in the interest of national security. The question is whether President Nixon used his authority in conformity with and comporting with what the law is, what the law was at the time those wiretaps were instituted. The fact is uncontroverted that Mr. Nixon authorized the wiretaps. The threshold question is whether or not the law and the Constitution were complied with. We have the 1967 Katz decision, which said that wiretaps do come under the Fourth Amendment against unreasonable searches and seizures. We have the 1968 Omnibus Crime Control and Safe Streets Act. Now, what I want to hear the opposition address themselves to is whether the Omnibus Crime and Safe Streets Act, which was signed into law in 1968, was in fact the law, even in the absence of clarifying regulations or a clarifying decision issued by the Supreme Court of the United States. There is no such thing as a law awaiting some clarification by the court. The 1968 decision was law, and the President did not abide by the law which was in effect at the time these wiretaps, 1969 to 1971, were instituted. I want to hear the opposition address themselves not simply to those wiretaps which relate to perhaps National Security Council employees, but what about those which related to newsmen who certainly know a lot but know nothing about state secrets? What about those instances where wiretaps were instigated on employees who had left the government and long since had nothing to do with national security matters? We read the summaries of those wiretaps, and you have heard us state that there was gossip and personal matters involved in some of the information adduced. I want the opposition then to address themselves to all of the taps, not that just those which may, under some stretch of the imagination, have had something to do with national security. A climate of leaks do not necessarily justify, and in my judgment, do not in any instance justify a violation of Fourth Amendment freedoms.
Time of the gentlelady has expired. The gentleman from California has 4 minutes remaining.
I yield the 4 minutes to the gentleman from Indiana, Mr. Dennis.
Gentleman from Indiana is recognized.
Thank the gentleman. Mr. Chairman, first I would like to call attention to exactly what the Keith decision, which had not become law at the time we're talking about, held. The Keith decision stated that it was necessary to get a court warrant before instituting wiretaps in matters which involve only the domestic aspects of national security. That was not handed down at the time we were talking about, which was back in 1969, and the general assumption in governmental circles was that you didn't need a prior court order to institute wiretaps for the domestic aspects of national security at that time. Contrary had never been held. But it's important to know what the Keith decision did not hold, even when it was handed down, and I read from the opinion of the court. We emphasize, before concluding this opinion, the scope of our decision. As stated at the outset, this case involves only the domestic aspects of national security. We have not addressed and expressed no opinion as to the issues which may be involved with respect to activities of foreign powers or their agents. And in the footnote they say, for the view that warrantless surveillance, though impermissible in domestic security cases, may be constitutional where foreign powers are involved, see United States versus Smith and so on. Now, a great many of these wiretaps here were cases where foreign affairs were certainly involved and where foreign powers were certainly interested and where some people might even have been agents of foreign powers, and even under this decision would still, in all probability, be lawful. Addressing what the gentlelady from Texas said, the court said further, nor does our decision rest on the language of Section 2511 or any other section of Title III of the Omnibus Crime Control and Safe Streets Act of 1968. That act does not attempt to define or delineate the powers of the President to meet domestic threats to the national security. Didn't apply to it. Had to do with ordinary crime. So they didn't take any guidance from the act. They didn't speak where foreign people were involved, and they then held for the first time that strictly domestic national security required a court order. Now, back in '69, there were a lot of important leaks. In early March, and I'm using now the books of our testimony, both the President's presentation and our own presentation. In early March of '69, and this is from the President's presentation to our committee, a decision was reached to conduct B-52 raids into Cambodia. They were conducted secretly, and we had it in our testimony too, to maintain the tacit approval of Prince Norodom Sihanouk. However, on May 6, '69, William Beecher accurately reported these raids in the New York Times, jeopardizing the relationship with Prince Sihanouk. On April 1st, '69, the Department of Defense made a troop study about withdrawing troops from Vietnam. It had not yet been discussed with the South Vietnamese government. Before it was discussed with the South Vietnamese government, on April 6, '69, Mr. Frankel ran an article in the New York Times about it. It jeopardized our relationships with the South Vietnamese government. Mr. Kissinger so testified in the affidavit which he filed, and other similar matters all happened in '69. And to finish my sentence, Dear Mr. Hoover, Agent Sullivan wrote in May '69, I thought you would like to know that Colonel Haig called me this morning to advise that they are releasing X today. At least this is one leak that will be stopped. Respectfully, W.C. Sullivan.
The time of the gentleman has expired. All those time in support of the amendment has all expired. There's remaining 4 minutes. Those in opposition to the amendment, I recognize Mr. Hogan.
Thank you, Mr. Chairman. As our extremely articulate colleague from Texas, Ms. Jordan, indicated, we are not here debating the President's authority to tap phones in national security matters, nor are we debating those areas where, in criminal cases, on a warrant, phones may be tapped. My good friends on this side of the aisle are, if they'll forgive me, engaged in a shell game. They're trying to put the emphasis on whether or not there is wiretap authority. What's at issue here is illegal wiretaps. Now, when the Time magazine story was about to break, the President was involved in about the wiretaps program at the White House. The President was involved in the creation of a fabrication that there was no such program. Subsequently, he publicly acknowledged it, and as late as July 12, 1974, in a letter to the chairman of the Foreign Relations Committee, he states, quote, I personally directed the surveillance, including the wiretapping of certain specific individuals, unquote. Now, my friends are talking about the Ellsberg leaks. I share their concern about that. I think it was reprehensible. One of the greatest tragedies in all of this is that because of the misconduct of employees at the White House and the President himself, Ellsberg escaped prosecution for leaking that confidential information, and I abhor that as much as anyone on this side of the aisle. But there is absolutely no justification for some of the pure and simple illegalities involved in this area of the law. The Secret Service has no authority statutorily to tap phones. They did, at the direction of the White House and obviously at the direction of the President, tap the phone of his brother with no statutory authority. The CIA was asked, and sometimes they refused, and sometimes they cooperated in activities inside the United States. Their statutory authority specifically forbids them to be involved in any domestic activities. Directing the FBI to investigate Daniel Shore because they didn't like the kinds of things he was saying about the administration was another misuse of the president's power. When it was discovered, they said he was being considered for a job. We had testimony here that that was a story which the president helped to fabricate. He at no time was under any consideration for a job. Now let's look to some of the specific wiretaps. The Joseph Kraft wiretap. If it was a criminal case, they needed a warrant. They had no warrant. If it was a national security case, they needed the approval of the Attorney General. They had no approval from the Attorney General. He was not involved in publishing leaked materials. That was pure and simple an effort to get information on a so-called White House enemy. It's been said many times about the former National Security Council employees who left their jobs, and the wiretaps continued for a long time. There's only one thing I want to add to that. Indicative of what they had in mind here is that Henry Kissinger no longer got those wiretap reports for the 8 additional months while they were working for Senator Muskie. They then went to Haldeman, who wasn't concerned directly with the National Security Council. Now, another thing that disturbs me about this is that Alexander Haig directed the FBI, quote, on the highest authority not to maintain regular records of the wiretaps and not to treat them in the same fashion that other national security taps were treated by the FBI. And the Joseph Kraft tap went into that category. So there were no records of the FBI, so that when the Department of Justice was asked in the Ellsberg case if they had ever overheard him in any conversations, the Justice Department directed the FBI to check their files. They came back and said, no, there's no evidence of any indication of wiretapping, because the records were all at the White House. As I indicated this morning, they were personally delivered to the Oval Office by Mardian. Direct presidential involvement. I wish I had another hour.
Time of the gentleman has expired. All time has expired. And the question now occurs on the amendment number 2 offered by the gentleman from California. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? No. The noes appear to have it. The gentleman from New Jersey. Gentleman demands a call of the roll, and the yeas and the nays are ordered. All those in favor of the amendment, please say aye. All those opposed, no. Clerk will call the roll.
Mr. Donahue? No. Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers? No. Mr. Eilberg?
No.
Mr. Walde?
No.
Mr. Flower?
No.
Mr. Mann?
No.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drinan?
No.
Mr. Rangel?
No.
Miss Jordan?
No.
Mr. Thornton?
No.
Miss Holtzman?
No.
Mr. Owens?
No.
Mr. Mesvinsky?
No.
Mr. Hutchinson?
Aye.
Mr. McClory?
No.
Mr. Smith?
Aye.
Mr. Sandman?
Aye.
Mr. Railsback?
No.
Mr. Wiggins?
Aye.
Mr. Dennis?
Aye.
Mr. Fish?
No.
Mr. Maine?
Aye.
Mr. Hogan?
No.
Mr. Butler?
No.
Mr. Cohen?
No.
Mr. Lott?
Aye.
Mr. Fraley?
No.
Mr. Moorhead?
Aye.
Mr. Mariziti?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No.
Mr. Chairman, 10 members have voted aye, and 28 members have voted no.
And the amendment is not agreed to. Recognize the gentleman from Maine for the purpose of offering an amendment.
An amendment at the desk.
Clerk will read the amendment.
Amendment by Mr. Cohen. On page 3, subparagraph 4, strike line 7 and insert in lieu thereof the following new language. National Committee and the cover-up thereof, and concerning other unlawful activities, including those relating to the confirmation of Richard Kleindienst as Attorney General of the United States, the electronic surveillance of private citizens, the break-in into the offices of Dr. Lewis Fielding, and the campaign financing practices of the Committee to Re-elect the President.
Gentleman is recognized.
Mr. Chairman, I might just briefly indicate that this is the long-awaited amendment put together by Mr. Butler and myself, calling for greater specifics in the subparagraph 4. I think we all agree, at least I do, Mr. Butler, that the statement was too general. I want to commend Mr. Wiggins for drawing our attention to it, Mr. McClory for perfecting it, but I think that these are the specific areas that would warrant inclusion under that subparagraph, and I would urge my colleagues to support it. I will yield to the gentleman from Missouri.
I would be pleased to accept that as an improvement in the language and accept it. Move the, if it's in order, I would ask the question.
On the amendment offered by the gentleman from Maine. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? No. The amendment is agreed to. The gentleman from California seeking recognition.
Yes, Mr. Chairman, I have a motion to strike subparagraph 3 at the desk.
The clerk will read the amendment.
Amendment by Mr. Wiggins. In the Hungate substitute, strike subparagraph 3.
California.
Mr. Chairman, I yield 5 minutes to the gentleman from Iowa, Maine.
Gentleman is recognized.
I thank the gentleman for yielding to me. This particular paragraph is the one which makes the charge of setting up the Special Investigations Unit in the White House, the so-called Plumbers Unit. Now, I think that in considering this charge, it is necessary to think of the background under which the President made this decision, and part of that background is what the gentlewoman from Texas has referred to as the climate of leaks. And there is no question that there had been a series of very damaging and serious leaks for several years. One has already been referred to by Mr. Moorhead as the leak in 1969 of the secret estimates of the United States Intelligence Board of Soviet strategic strength, and particularly of Soviet first strike power. This was a highly confidential document, but it was released by some official, leaked to a reporter, and appeared in the New York Times on June 18, 1969, stating our estimate of Soviet first strike power. Then came, I won't recite all of the leaks that intervened, but probably the most famous one was the release and publication of the so-called Pentagon Papers, which had to do with our decision-making process in Vietnam. Those started to appear in the New York Times on June 28, 1971, at a time when our troops were still involved in combat in Vietnam at a time when Dr. Kissinger was engaged in highly sensitive negotiations to end the war in Vietnam in Paris. On June 28th of 1971, Dr. Ellsberg openly boasted in a public press conference that he had had these papers copied and had furnished them to the newspaper. It was reported to the President that this man had been a highly trusted employee in the Defense Department during the Johnson administration, that he possessed other highly secret information of current validity and danger, including our nuclear deterrent targeting capability. And Dr. Ellsberg in his press conference had invited others to join with him. He was carrying on a publicity propaganda campaign, asking others also to join him in his opposition to the manner in which the administration was winding down the war in Vietnam, which did not meet with his approval. This was a highly dangerous situation. The President, who was responsible for the national security, had a clear duty to act. He had to do something. He elected to set up this Special Investigations Unit in the White House. Now, I don't happen to agree with the way in which he acted. I think it would have been much wiser for him to rely upon the Federal Bureau of Investigation, which was the established agency with long experience and knowledge in national defense security investigations. But it's very easy for me, and it's very easy for critics of the President with the benefit of hindsight to say that he should have gone the other way. But who is to say when a man charged with that awesome responsibility has to make a decision to protect the security of the United States if he doesn't make precisely the correct decision? Act he must, and act he did. Now, another very current instance of national security leak occurred shortly thereafter while the Special Investigations Unit was still being implemented, and that occurred on July 23rd, 1971, in connection with the SALT talks, the Strategic Arms Limitation Agreements discussions in Helsinki. Here we were trying to negotiate the numbers of ground-based and submarine-based missiles and anti-ballistic missiles which were to be constructed by us in the Soviet Union. There could be nothing more vital to the defense of the United States and to the interests of the United States than our ability to defend ourselves against nuclear attack. Yet, in advance, we had leaked by some official or officials in our government our fallback position. Now, everyone knows that in negotiations you don't reveal your final position. You try to get the best agreement for your side that you can, and this is certainly true more in national defense than anything else. But in this article, which appeared in the Times, they did clearly reveal that the Americans were prepared to ask something less if their full American bargaining package was not offered. Now,
the gentleman has consumed 5 minutes. The chair will recess, since there is a roll call vote, and recess until the vote has been cast, and return immediately after the vote has been cast.
Now that the language has been clarified in the fourth section of the Hungate substitute, the committee members recess briefly. As they returned to the markup session on Article 2, Congressman Wiggins was making still another attempt to cut down the number of charges against Mr. Nixon.
Time the committee recessed, the gentleman from Iowa, Mr. Maine, had consumed 5 minutes in support of the amendment. I recognize the gentleman from New York, Mr. Fish, in opposition to the amendment for 4 minutes.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, I think this Article 2, dealing as it does with the abuse of the enormous power of the federal government against its citizens, is an issue that is particularly abhorrent to a democratic people. The illegal activities of the plumbers is the subject of the third provision which we have before us a motion to strike, and I know there are several who want to talk on this particular paragraph, and I will attempt to be brief. As we know, on June the 13th, the New York Times published the first installment of the Pentagon Papers. The President, through Haldeman, directed Mr. Colson to prepare a memorandum stating his recommendations on the Pentagon paper issue. The memorandum of Mr. Colson, dated June 25, recommended that the investigation and successful prosecution of Ellsberg was an opportunity for political gain and for the President by publicity discrediting Mr. Ellsberg. As we know also, Mr. Ellsberg was indicted on June the 28th. The genesis, I suggest to you, of the plumbers was the Pentagon Papers. In a meeting between the President, Mr. Ehrlichman, and Mr. Mitchell on July 6th, we have the discussion of forming a, quote, non-legal group in connection with the Pentagon Papers affair. So there's no question here of presidential knowledge. The question has been raised, and will be raised again, however, that the issue was national security from the start, that this legitimized the formation of the plumbers and the effort to publicly discredit Mr. Daniel Ellsberg. Mr. Jenner, I've asked you during this break a few minutes ago to find for me certain citations I recall of conversations between the principals in this matter that showed to me clearly that it was a public relations effort they had in mind and that national security in the Pentagon Papers case was not the issue. Could you refer to those citations, please?
May I, Mr. Chairman? The following items appearing in the Ehrlichman notes, which, by the way, will be delivered to all of you tomorrow with a covering memorandum, I will read without comment. I think they speak for themselves. On July 1, 1971, a meeting of the plaintiff, Mr. Ehrlichman, at 10:50 in the morning, and Mr. Colson. Did I say the President? If I didn't, I should have. Item number 8 reads, leak stuff out. This is the way we win. The next is also July 1st at 1 p.m. The meeting with the President. Here's the following entry, labeled item number 1. Espionage not involved in Ellsberg case. Now, did I say 21? 29. What's this symbol? His case, breach of security, willful disclosure without intent to commit espionage. Same meeting. Later, note number 30, timing, dash, not react to Ellsberg case. Don't think in terms of spies. July 6, 1971, the President
against its citizens is an issue that is particularly abhorrent to a democratic people. The illegal activities of the plumbers is the subject of the third provision which we have before us a motion to strike, and I know there are several who want to talk on this particular paragraph, and I will attempt to be brief. As we know, on June the 13th, the New York Times published the first installment of the Pentagon Papers. The President, through Haldeman, directed Mr. Colson to prepare a memorandum stating his recommendations on the Pentagon paper issue. The memorandum of Mr. Colson, dated June 25, recommended that the investigation and successful prosecution of Ellsberg was an opportunity for political gain and for the President by publicity discrediting Mr. Ellsberg. As we know also, Mr. Ellsberg was indicted on June the 28th. The genesis, I suggest to you, of the plumbers was the Pentagon Papers. In a meeting between the President, Mr. Ehrlichman, and Mr. Mitchell on July 6th, we have the discussion of forming a, quote, non-legal group in connection with the Pentagon Papers affair. So there's no question here of presidential knowledge. The question has been raised, and will be raised again, however, that the issue was national security from the start, that this legitimized the formation of the plumbers and the effort to publicly discredit Mr. Daniel Ellsberg. Mr. Jenner, I've asked you during this break a few minutes ago to find for me certain citations I recall of conversations between the principals in this matter that showed to me clearly that it was a public relations effort they had in mind and that national security in the Pentagon Papers case was not the issue. Could you refer to those citations, please?
May I, Mr. Chairman? The following items appearing in the Ehrlichman notes, which, by the way, will be delivered to all of you tomorrow with a covering memorandum, I will read without comment. I think they speak for themselves. On July 1, 1971, a meeting of the plaintiff, Mr. Ehrlichman, at 10:50 in the morning, and Mr. Colson. Did I say the President? If I didn't, I should have. Item number 8 reads, leak stuff out. This is the way we win. The next is also July 1st at 1 p.m. The meeting with the President. Here's the following entry, labeled item number 1. Espionage not involved in Ellsberg case. Did I say 21? 29. What's this symbol? His case, breach of security, willful disclosure without intent to commit espionage. Same meeting. Later, note number 30, timing dash, not react to Ellsberg case. Don't think in terms of spies. July 6, 1971, the President, the Attorney General, Haldeman, and Ehrlichman. Note number 11, President is saying this, put a non-legal team on the conspiracy. That's the...
Gentlemen, 4 minutes has expired. I recognize the gentleman from Michigan, Mr. Conyers, for 4 minutes.
Thank you, Mr. Chairman and members. I rise, of course, in opposition to the motion for strike, and I must observe that for the second time in a row we've had clauses that have attempted to persuade the American people and our colleagues in this immediate vital judgment that national security itself was a justification for the illegal activities emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the White House, and I'm very sorry to say, from the authority, emanating directly from the and condemnation of the President of the United States himself. And I think that we cannot here today make this record too replete with the documentation that says once and for all that the bugaboo of national security will no longer suffice to intimidate the Congress or scare the American people into condoning activities of the kind that we have heard here in Article 2 in these proceedings. I want to assert, and I'm sure my other colleagues that follow me will, that the President was in fact directly responsible for the creation of the plumbers. It's documented in our evidence. The President publicly admitted it, that he approved the creation of a special investigations unit, the plumbers. For the first time in our history, the people of this nation were treated to the spectacle of a secret intelligence unit operating not in the FBI, not in the CIA or the Secret Service, but in the White House under the direction of White House employees reporting directly to the President of the United States. John Ehrlichman, in his own trial, the domestic affairs advisor of the President, testified that he asked the CIA, can you imagine our foreign intelligence agency to help, and that he asked the CIA to help Howard Hunt at the direction of the President of the United States. And he said, in my personal experience, my requests of the CIA were always at the specific instance of the President. I never did make a step to ask the CIA to do anything without the President having authorized me to do so in advance. So the fact that the President could and expected that the plumbers, a clandestine, secret organization, would in fact operate illegally. The President had, you may recall, approved the Houston plan only a year before, knowing full well that it sanctioned admittedly illegal activity. According further to the notes of the President's former domestic advisor of his meeting with the President on July 6, 1971, the President asked, put a non-legal team on the conspiracy. Now, we've learned across these months and the euphemisms of White House parlance that stonewalling, modified hangout, has a significance all its own, and a non-legal team suggests precisely that. And Ehrlichman's notes reflect the assignment of David Young, co-chairman of the plumbers, to a special project. Mr. Ehrlichman testified further before the grand jury that the President of the United States had prior knowledge of the first trip by Mr. Liddy and Mr. Hunt. I'm sure you remember those names from June 17, 1972, to go to California to case the fielding office.
4 minutes of the gentleman expired, and the chair calls attention to the fact that there is a roll call vote, and the chair will recess the committee until 7:30, and the chair would also like to observe that at this time 8 minutes have been consumed by those in opposition to the amendment and 5 minutes in support of the amendment, and that time, the balance of the time will be reserved by opponents and proponents. That committee is recessed until 7:30.
A day of lawyer-like work in the impeachment debate before the House Judiciary Committee. As you could see, most of the time of the 38 committee members was taken up today with two things. First of all, perfecting amendments designed to refine some of the language in Article 2, the article that charged the President with a broad abuse of his presidential powers. And second, amendments offered by those Republicans defending the President designed to modify, designed to tone down some of the language in the amendment. But the outcome of the significant votes, at least, was to provide fresh evidence that the pro-impeachment forces remain firmly in control and that the second article would be approved.
And in fact, it was approved. And later on in the committee's night session, the vote was 28-10. Tomorrow, more proposed articles of impeachment will be introduced, debated, and some of them probably voted on tomorrow. None of them are expected to receive the large bipartisan support of either Article 1 or 2. They may not even pass, in fact, but that's something we'll have to wait and see about. No matter the results, we'll be back tomorrow night with our gavel-to-gavel coverage of the House Judiciary Committee proceedings. For now, for Paul Duke and for Impact, I'm Jim Lara. Thank you and good night.
From Washington, you have been watching videotaped gavel-to-gavel coverage of the House Judiciary Committee proceedings. Production funding provided by public television stations, the Ford Foundation, and the Corporation for Public Broadcasting. This has been a production of Impact, a division of GWETA.